Good morning, ladies and gentlemen. This is the Board of Standards and Appeals public hearing for September 17, 2019, sorry. We'll start with the appeals calendar decision items. Item number 1, 2019-89A, 36 West 66th Street, Manhattan. It's the appeal filed by the City Club.
Right, does anyone from the City Club want to come up? Oh, yeah.
Yeah. This matter is, it's on for decision.
Yeah, but usually someone gets up and stands there when we vote, so that's... State your name, please.
Chuck Weinstock,
Okay,
representing City Club
City Club, okay, so...
and other appellants.
Okay, so for the members of the public who weren't at the review session yesterday, there was a review session at which time the commissioners spoke at length about their opinions on this. So if you want to hear the lengthy conversations, please listen to the video, which is on our website for yesterday's review session. Okay, correct? It's on our website?
Yep.
Okay, so then I would like to bring this, so what we're bringing to a vote is the questions that were presented by City Club, which were specifically about mechanical space and the bulk distribution, okay? So for a motion to, we closed the hearing already, a motion to grant the appeal?
Chair Perlmutter?
No?
Vice Chair Chanda?
No.
Commissioner Otley Brown? Oh, sorry.
Recused.
Abstain, sorry. Commissioner Shetta?
No.
Commissioner Shabeta?
No.
Application is denied.
You done with us?
Yes. Item number 2, 2019-94A, 36 West 66th Street, Manhattan. This is the appeal brought by parties of Landmark West.
Okay, so
Stuart Klein?
yes, Mr. Klein, just want to say your name.
Stuart Klein, Klein Slowick, on behalf of the appellant.
Okay, so we're going to sort of bisect this application into two parts. It was closed, but we will, for one part of it, reopen. But I don't know that we need to specifically reopen today. It's more instruction. I'm not really sure how we're handling that technically.
I thought we should reopen.
But we need to vote on the two questions that are identical to the questions for City Club, right? So we're going to bisect the decision, okay? So as to the two questions that we just voted on, which are the mechanical space as to the height of the ceiling and the bulk distribution, we talked about that at the review session, and so I'd just like to bring that to a vote, okay? And leave out of it the question of the mechanical equipment and whether that's the appropriate amount of mechanical equipment, okay? So on those two questions, a motion to grant the appeal?
Chair Perlmutter?
No.
Vice Chair Chanda?
No.
Commissioner Shetta?
No.
Commissioner Shabeta?
No.
Okay, so those two questions are now sort of closed out, right? So what we could open is, for not a lot of discussion because we don't have a lot of information yet, is the question of whether the mechanical floor space is appropriately occupied by mechanical equipment necessary to support this building. And so what I would ask of appellant, to the extent they're able to get it from public records, to provide the board with mechanical drawings. The Department of Buildings, is the Department of Buildings here today? Yes, okay. The Department of Buildings to supply us with the mechanical drawings, but also to review the mechanical drawings in the same way that the Sky House mechanical drawings were reviewed with the same depth. And I just want to again point out to the public that we spoke a lot about this subject at yesterday's review session, which is also on the video, and that the owner cooperate by providing drawings that are not available in the public record of the mechanical file drawings. So it's the M set, and it might be the sprinkler set as well, there was a request in the papers submitted by appellant for shop drawings. We didn't review shop drawings for Sky House. I think that's taking it much too far. Department of Buildings does not review shop drawings either. Yeah?
If it's possible, I would like to get the entire set.
Yes, the entire mechanical
No,
set.
the entire structural and architectural plans for the building.
we're only being asked to look at the mechanicals, and I don't want to...
Yes.
Madam Chair?
I totally understand.
Madam Chair, may
We're
I?
only looking at mechanicals, we're not looking at the structure of the building and so on.
No,
That's the
but with
question
regard to
before us.
mechanicals, under the Sky House case
Oh,
and under...
have
We
to
need to
reopen.
I'm
reopen
sorry,
in
I'm
order
sorry.
for you to speak.
I'm sorry, Mr. Klein.
Yeah, so we're going to open exclusively as to mechanical equipment, okay?
So, motion
So-
to reopen?
Motion.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
All right.
May I?
Yeah.
Under the guidelines set in the BIS system by the Buildings Department and in memos written by the Assistant Commissioner or Deputy Commissioner, it requires that the drawings include all piping ancillary to the mechanical system. So they're going to be reasonably complete drawings, almost to the extent of being shop drawings. And that guideline sets out approximately 10 different items that is reflected in the Sky House case of what has to be included in the drawings. With regard to...
I just want to interrupt. There's a big
sorry.
difference between shop drawings and
Oh, no, I
mechanical drawings.
appreciate that, yeah.
So shop
No.
drawings are off the table.
We're not getting
okay?
into every screw and everything
Right,
else.
shop
no.
drawings and
No.
probably aren't even produced at this point
Yeah.
on this project, so
No, I
we're not
appreciate
doing
that.
that.
And as to what we can supply, the drawings that were submitted to Building Department for review have none of the things that are said in the guidelines, so I won't be handing in anything.
Okay, so you're not able to get any additional information from going to the Department of Buildings?
No,
Did you
it's
go
not
and
on
you-
file.
They're not filed,
Correct.
as far as you know?
Yes,
Okay. When was the last time you went to the Department of Buildings to check the file?
About a month ago.
Okay, so there may be more, I
Yeah.
don't know without checking biz what was filed. I see mechanical filings, but we don't know what the level is. Okay, so I would ask Department of Buildings and the owner to cooperate the same way that was done with the Sky House case, and provide this board with a clear set of mechanical drawings. But I don't want to ask for the electrical and the structural, because now we're going down a wormhole. The question before us is, when you look at the planning of the floor, of each mechanical floor, is the amount of mechanical equipment that's shown on the drawings the amount that you would normally associate with a building of this size? That's what we're talking about, and that's what we looked at with Sky House. And it was actually not the board so much that looked at those drawings, we looked at them, but it was the Department of Buildings engineers who reviewed them and concluded in a letter that the amount of mechanical equipment that was in those spaces was reasonable for a building of that type.
It's obviously the size of the building and the requirements of the building are dialed into the equation, but also the equipment itself, because what the Buildings Department refers to is the manufacturing cut slips for the items to determine how much distance around them is necessary for venting and service and things of
Right,
that nature.
mechanical drawings do that, you know,
Yeah.
the mechanical engineer knows that the
they
workers
don't do
have to
that
get
here, that's the
around,
problem.
right?
Yeah.
So the workers have to get around and to work, and there needs to be room to replace equipment and that kind of stuff, right? And they show duct work, they show all of that on
Yes.
mechanical drawings, so that should be adequate.
Should we create a deadline for the owner and the buildings department to provide a response there by giving the appellant some time to respond to it?
Well, we'll have the owner up to talk about
Sure,
when to
thank you.
produce all of this and so on, okay?
Mr. Konofsky?
So- And Buildings Department also, Mr. Karnowski, yes.
David Karnowski, Fried Frank Harris, Shriver, and Jacobson, for owner.
Morning.
Good morning.
So I guess the question is, I don't actually even know what the status of the mechanical drawings is. Do you have that information?
Mechanical drawings were filed, and we will provide copies to the board
Okay.
and to the appellant. The characterization of the process that was followed is grossly inaccurate, and we'll provide them.
Okay, so that, it would help a lot to clarify when they were filed and make sure that they're complete according to the requirements in the code, and to give us a copy, and Buildings Department, we'll speak to Buildings Department, okay? Great, thank you.
Good morning, Michael Zoltan for the Department of Buildings. So just to clarify one or two things, one is the department did review the mechanical plans and found them sufficient and went through the proposed equipment. And I have a short synopsis of some of the equipment on the mechanical floors. So for instance, the mezzanine above the first floor has an expansion tank, a heat exchanger, a water source for heater pumps. The 15th floor mechanical floor contains storm water detention tank, pool equipment room, emergency generator, electrical switchboard. The 16th floor has the HVAC duct and equipment. It has the air handler units, fan units, other equipment. The 17th floor has an electrical room, mechanical and boiler equipment. The 18th floor has HVAC, air handler units, and fan units. The 19th floor has electrical equipment, fire pump room, fire reserve storage tank. The 39th floor has plumbing, telephone equipment, and a fire pump. So
Okay.
the department did review these. Now, if the board wants us to provide more of a synopsis, we can, of course.
That's so to model what happened on Sky House. On Sky House, the board was provided with a full set of mechanical drawings so that we could kind of read along.
Sure.
And the Department of Buildings issued, I think it was 2 actually, very detailed letters about what it reviewed and why it considered what it reviewed proper for a building of this size. So that's what we're looking at here. And if DOB can also give us more information on what they typically view for a building of this size. I mean, kind of back in the day, before the buildings were as big as they are, there used to be sort of a 5% rule. I don't know what the rule is today, because buildings don't look like those buildings anymore, right? So I don't know if DOB has kind of a standard method of operation to determine whether floor space devoted to mechanical is believable, right?
I have a request. I request,
Speak up.
do you have the original the plans for the mechanical rooms prior to the addition of the new floor?
I'm not sure right now. I only looked at the current ones, or not looked them, but had them looked at.
I'd asked for a production of the original that were produced.
So if I may, one of the questions that was brought up yesterday was about the number of floors.
That's correct.
Right?
Yes.
So just looking at the ZD1s, the zoning diagrams that outline the floors before it was changed from 160 foot ceiling, floor to ceiling, and then split up into 3 different floors that were 64, 64, 48. The number of floors containing mechanical equipment were the same. It was the height of the floors so you had 2 that had much smaller floor to ceiling, and 1 with 160, and then those 3 were redistributed into 64, 64, and 48. So there was no additional floor containing mechanical equipment. So to go through them again, you had the mezzanine about the first floor, the 15th floor, the 17th floor, the 18th floor, the 19th floor, and then by the roof. It's the amount of floors or stories is the same. That didn't change between the before and after. It was just the floor to ceiling height of 3 of them specifically is what changed.
Oh, okay. But I thought one of the ways of solving the problem for fire department was to install these sort of catwalks.
Yes.
So that meant retaining the floor to ceiling height more or less. Or I thought they subdivided it into different floors so that they would satisfy fire department about the height of firefighting at the top level.
Beforehand, there were 3 stories that all contained mechanical equipment. 2 of them had more typical floor to ceiling heights, and 1 of them had 160 feet from floor to ceiling. That was changed. We still retained the same 3 stories, but now one of them was 64, the next one was 64, and the next one was 48.
Oh, I see.
So it's the same number of stories, just the height of the ceilings under those 3 stories were changed. And the fire access levels were added on all 3 of those stories, but the number of stories remained the same.
I just want to make sure I understand it. So before the zoning lot merger,
not the merger, no, this is before the, no, this is simply,
I'm trying to understand what is the before that is being talked
the
about.
before, the building original, the building, once the zoning lot was merged and they were doing their project, the buildings department, there was an objection issued by fire department that said your floor to ceiling height is far too high and will not be able to reach the height for firefighting. So the project was at risk or something, there was an issue, a letter of
Thank you.
notice.
Intent to revoke
Intent to
approval.
revoke, and then they responded by changing the mechanical spacing.
Thank you for
Right.
that clarification. That's
Okay, that's helpful, thank you. I didn't realize that because I also was under the impression they slipped more floors in there, but, so we're talking about a total of 3 stories of mechanical space?
There are, I believe there are more throughout the building, but only 3 were reconfigured for that objection.
No, but a total of actual full, I know there's mechanical that's spread around a building, that's always the way it is, but in terms of full floors devoted to mechanical space, do you know how many there are?
I'm not sure exactly. I don't want to misspeak. I'll
Okay.
get back.
Okay, so that's something, well, it's for one, something we need to know going forward, but we should have a floor plan for all of the floors devoted to mechanical space. And a general description, if there's mechanical rooms on the other floors. I mean, the tower plate is very small, but to the extent there's mechanical rooms on the other floors, to explain what those are for. That's a fairly typical thing, that you find small rooms on each floor, but to understand that as well.
So this is not just to go through, so the request is not just to go through the floors that were fully deducted for mechanical floors, to go through all the floors of the building.
The idea is, because I know the skepticism in the crowd, right? If you're spreading mechanical, and there was actually a woman who testified last week, I think, who said, I don't understand why there's so much mechanical space in these buildings anymore. I used to put it in the cellar. So to respond to those kinds of issues, and it's easy enough to see from the zoning diagram, right, that certain amount of area on each floor is allocated to mechanical space. Just a general statement on those residential floors about the however many square feet it is. Do you have that? That's devoted to mechanical space. I don't know if we have that zoning breakdown. Just to explain, like, what goes into those typical floors to the extent there's mechanical deductions there, which is usually chases, actually, right? So, therefore, not actually equipment, it's the vertical, it's the piping, it's the chases, that kind of stuff. Just, I don't know if we have. You see
So-
mechanical deductions on there? No? Residential, yeah, we don't see. on
even
the
the
zoning diagram.
FD and Y axis has. those
Yeah,
axes.
okay, we don't have that chart in front of us, so, okay.
So the recent testimony, the immediate testimony from the Department of Buildings raises a question that I'm not sure whether or not we're procedurally permitted to inquire within. And that is, I'd like to understand when the reconfiguration, if these heights were entirely arbitrary. When they reconfigured all of these mechanical rooms, did they give any reason or purpose or use as to why they reconfigured it this way?
No, but, you mean in terms of, because it was fire department telling them it's too high of a ceiling at 160 feet or whatever it was. You have to do something so that we, fire department, are comfortable with the ceiling height, that in the event of a fire, we can fight a fire. And so I'm assuming that there was a fire department conversation where 60 whatever feet was the magic number.
Oh, but I thought it was another objection from the DOB saying that the kind of height that's used is kind of like uncommon for that size of building. I did read in their submission that they objected to the height because the height is not common for buildings like that.
I'm not sure what you mean. But don't forget, try not to, we already decided on mechanical space height.
No,
Right,
I'm not going there.
Right.
Yes, I understand.
Okay. Okay. Right, so if you could just give us information. We're talking about mechanical equipment now, right? We already talked about, we closed out the subject of how high the space is and which mechanical equipment fits. We're looking at the floor space now, not the sectional relationship, right? We're looking at the floor space filled with equipment. That's our question now, okay? Okay. Got it. So, okay, so then I would like to hold off on speakers on this question because we don't have any submissions, so there's kind of nothing to talk about, and I wanted to not have a 4-hour hearing. And so let's wait until we actually have some mechanical information and mechanical experts who can actually talk about whether what the situation is here, okay? So how much time do you need, DOB, to review in detail what you did for Sky House, the equivalent for Sky House? I know you need engineers to do that.
Yeah, so we need engineers. The board is sort of asking for a more detailed report as opposed to just check and make sure everything's okay, which we've done. So it will be a few weeks.
Okay.
And
Any
then unfortunately
ideas?
run up into holidays. But at this point, we're not getting any more, from what I understood from appellant, we're not going to get a specific allegation of, look at this floor, this is insufficient. It's just the general general breakdown of mechanical equipment. So we're not responding to anything now. We're responding to the request from the board.
So the thing that you should look at the Sky House letters that you sent again, because that's the model. And that's the basis on which we decided to bifurcate this case, right? So those letters were very clear what the engineers looked at. It explained what equipment was on each floor. It explained, it was accompanied by drawings so we could follow along. And it justified the existence of that many floors for a building of that type. So we do want a statement. This much equipment is typical of a building of this type, and this many floors, right? Because I don't know how many mechanical floors are, but in the Sky House case, there were 3, and then we looked at the interstitial floors that we were seeing in other buildings. We named about 5 other buildings recently built, and they all had 3 interstitial floors plus the rooftop mechanical, right? So, and I'm assuming some cellar mechanical because utilities are coming in, unless you're in a floodplain, utilities are coming in at the cellar level, right? So all of those things seem to be typical of all of those buildings. And so a statement about whether or not the number of floors devoted to mechanical is typical of a building of this type. Yeah. Yeah. I think it's okay, because it'll alert them. Yeah, sure. Fire department is here, and they just wanted to clarify something, and it might be helpful in us understanding what to do moving forward.
Good morning, Captain Simon Resner for the Fire Department Operations. So I just wanted to talk to you, you had mentioned that our objection to the configuration of the space had to do with ceiling height, and ceiling height was one of many factors. So I just wanted to outline, if you want us to, we can
Yes, please.
outline other factors that were considered here. We can also wait till the next hearing.
No,
to
I
do
think
that.
it's useful, because then knowing it, then everyone can respond.
Okay, so the issue for us with any void space or with any mechanical space has to do with a number of features. One is the way we fight fires in high-rise buildings is very different from the way we fight fires in traditional lower buildings. We utilize the stairways both as a point of operation, but we also stage people, we store materials, we have medical staff, we have air cylinders. So we utilize the core of the building for all of these different operational needs. And having the original configuration left us in a position of having 160 feet to traverse before we could get to a floor where we could have available space. So our discussions with the developer were to try to have accommodations made in the configuration of the floor plates that made up each individual level within the space, so that there would be adequate room for all of those materials and people. There would be the ability to cross over from stairway to elevator shaft, both for rescue and for egress. There would be the ability to move people out of a contaminated stairway if that does happen, which it does happen often in residential high-rise. So I don't want it to be that that the overall height was the only factor.
Okay.
There were many factors, so.
Okay,
And I
that's
can
helpful.
take any questions you have about that, but I just wanted to make clear that we took our high-rise firefighting operational manual, which we have, which does exist, and it calls out a whole bunch of features, including locations of command posts, locations of material, locations of radio operators, and so on, and tried to sort of graft that into the configuration of the building that was presented to us. That was not, the solution that we came up with was within the context of the building that we had. Okay?
Okay, great. Thank you very much. Very helpful. Are there any questions for the chief? No? Okay. Captain? Okay. No, thank you.
No questions?
No question.
Thank
Thank
you.
you.
Thank you.
Okay, so let's set up a schedule, a submission schedule. So DOB, 4 weeks to submit, is that enough? I don't, sorry?
What date does that get us?
October 15th.
I don't know when the holidays are falling.
The 26th.
Every Tuesday.
Every Tuesday, that's so convenient.
It's going to be after.
October
15th for a submission, does that work?
Or 16th.
16th,
Yeah, we can try it for that.
okay. Try, I mean, you need to accomplish it, so is that going to work?
Yes.
Yeah, okay.
October 16th, submission for DOB.
Right. And then does owner want to respond or participate in that, or? Yes, okay, so do you want to respond to DOB's submission, or do you want to wait until appellant has responded to Okay, so then we could have a simultaneous response from both of you and appellant, right? Okay, is 2 weeks enough for that, or?
David, I'm sorry, Mr. Konosky.
Yeah, you have to come to the,
You're going to start talking and scattering.
so,
I think we would like to be able to comment on what's produced, but since appellant is going to take issue with it, no doubt, I think we need that opportunity.
so do you want to respond also to DOB or wait till
I think we'll wait until appellant has
Okay.
responded to DOB.
Okay, so then the next question is 2 weeks enough time to respond for appellant to DOB?
I believe we're going to need 3 weeks because we're going to have to review everything that they give us in the first, it's going to be the first instance for us. And
Right.
since they're getting, 3 weeks, I think it's appropriate to get 3 weeks also.
Okay, what's 3
Okay,
weeks?
so November 6th for the appellant.
And then for owner to respond to that, 3 weeks?
3 weeks.
3 weeks, okay.
Weeks.
And then any kind of, we're not going to have SIR replies, so your SIR reply will be here, okay? Because otherwise this goes on ad indefinitely.
Okay, so the owner will respond by November 27th.
Okay?
Okay,
And so for a hearing, that's like the first,
December 10th.
second hearing in December. Yeah, because it's 3 weeks,
So
right?
for a hearing on December 17th. Okay.
Okay.
One quick observation. The 5% rule was in fact the standard rule of the buildings department, but over the last 20 years, because of most of these items have been miniaturized to a great extent, it's now on a case-by-case basis, depending upon the equipment that's being used.
Okay, well, I would let DOB speak to what their methodology is, so I don't know the answer. That's one of the questions for DOB. On buildings of this type, what's typical? And there may not be a typical, because almost every one of these buildings is kind of inventing something new each time, right? So I don't know if there's a typical, but just to respond to that. Okay.
Okay, so
Okay, so just to go through the submissions
thank you,
again,
Kurt.
October 16th for DOB, November 6th for appellant, November 27th for the owner, and a hearing on December 17th.
Thank you very,
continued
very much.
hearing.
Thank you very much. Thank you, everyone. And of course, you're welcome to look at these submissions at the board office at 250 Broadway. You need to make an appointment to see them, okay? Okay.
Item number 3, 2017-147A, and item number 4, 2018-183A. Sorry. This is 7112 Main Street, Queens. Oh, wait, there's the sign. It's signed for both of them. Yes, sir. Yeah, good.
State my name.
Yes.
Benny Rachmanov.
Good morning.
Good morning, everybody. Can I approach the...
Sure. This is, it's a petition.
Yes.
Oh.
There's petition, and plus, I didn't have it in front of me, couldn't find it, but I have the actual document. About 12 signatures from neighbors and houses that signed in the beginning when we started the administrative processes, signing on behalf of the issues that were involved in the building. I also like to just start off with an opening statement if possible.
So as not to have this here, did you listen to the review session yesterday?
I was here yesterday.
You were here, okay,
Yes.
sorry. So I'm usually focused like this, I don't see who's in
I
there.
understand.
So you heard our comments, so I don't want to, in the interest of, we have very many cases on today, and last week we ended at 10 o'clock, so I'm not interested in repeating that. And because we did go through each of the items that you presented, I don't think, I don't know that there's more to
Oh, there's a
be
lot
done
more.
here. You can't open up new issues, that's what we
We're not
talked.
opening up any new issues. Let me just open my opening statement, because
Okay.
there was an issue that you raised about what's my intent.
Okay,
And all
what's
that.
that?
So, well, I didn't come to the body for intent, but I'm gonna express my point. This is my opening statement. Dear honorary members of the board, within the hearing of May 21st, 2019, there was a question proposed on whether or not I wanted the building to come down. Not to be disrespectful or diminish the value or integrity of the board, that question would seem to present me to the public eye as an aggressor, which is to the contrary. I have in constant poise performed my civic and religious duties to protect the value of my property and my way of life. I could only have done this with the consent and support of my neighbors and members of the community. The following statement is not to discredit the board and its right to question, but we ask the board to be mindful that the public may misinterpret questions that are beyond the questioning and reasoning of the code and the zoning as to my intention. Therefore, I would like to clarify the reason why we are before the BSA and our intent. Around August 2015, Mabel Assets LLC purchased the 7112 property. Applicants filing indicated that the proposed building would be a daycare center only. The required poster and permits reassured the fact that it was only to be a daycare center. As the time had passed, applicants and their professional, Mr. Gerald Caliendo, had altered the original contents of the PW1A dated and stamped August 15, 2015, to include commercial use, while all the time was presenting to the public and community that is just only a daycare center. It would take over 2 years since the permit from March of 2016, when the permit was first issued, to be corrected to include the commercial use of a drug store. It will also take the 2 years for applicants to provide the location of district boundaries as per plan examiner Mr. Singh's original August 15, 2015 handwritten objection notes. We also assess the following fact that the original plans submitted were designed for daycare only. So when plan examiner Mr. Singh reviewed the original documents and generated objections upon his review, it was specific to a daycare only proposal. which is considered a community facility only use. So when did Mr. Singh view and determine objections for commercial and community facility use? The answer is he did not. Since the PW1A, the form that presents proposed use of occupancy, was altered to show a commercial use, to show as if the original application and review by plan exam was for a drugstore and daycare, commercial and community facility use. In reality, this was not so. Please view Exhibit E, titled Letter to Deputy Commissioner, for further information on the subject and evidence of documentation. Another most recent example is a request for certificate of occupancy by Gerald Caliendo, signed by a member of Mabel Assets, Boris Yakubov. The most mind-blowing discrepancy is how seasoned professionals such as Gerald Caliendo and Robert Nasimov get away with describing building for over 2 years, as an existing two-story commercial building, which is, by the way, is inaccurate information of it being an existing two-story commercial building, since one of the initial public challenges that I submitted was accepted, determining and showing that the C of O was actually a residential building. As to the contrary, the building was never a two-story commercial building, and let's quote the description of the first permit, I quote, "Herewith, file alteration type 1, or in order to convert a medical office and home occupation of business into a daycare and to obtain new CFO," end of quote. This statement is not accurate at all. It's been determined by technical affairs and their decisions made that the building is a residential building with medical use in the basement. But it was never in any way an existing commercial building. It is a misrepresentation and may be subject to a crime. The small print in the permit, as the small fine print in the permit states, and I quote, "Tampering with or knowingly making a false entry in or falsely altering this permit is a crime that is punishable by fine, imprisonment, or both." Honorary Commissioners, I can provide many more examples as of these issues. I believe you understand the gist, and frankly, these issues are for the DOB to enforce and the DOI to investigate. This is far from a domestic neighborly dispute. This is a simple issue of right or wrong. In Mabel's Assets' current lawsuit against me, one of their main complaints is direct to prevent me from continuing the administrative processes, specifically presenting to the BSA. I presented the index number prior. Further, during the time of the appeals to technical affairs were pending, Mr. Jerry Callahan had approached a relative who is also a public figure in the community, requesting his help in persuading me to withdraw from all administrative processes. Further, it was brought to my attention by Mr. Steve Orlo, owner of 7112 Main Street, that during the period of sale of 7112 Main Street, an individual had approached him in regards to purchasing 7112 Main Street to build a daycare. He requested from Steve Orlo to even out the shared property lines to construct a daycare center. Eventually, the potential buyer responded to Mr. Steve Orlo, stating that he cannot build a daycare center as per advice from his professional architect, Gerald Caliendo. So to clarify my intended position, the fact is that the applicant filed 14 PAAs to see what sticks and to get the property certificate of occupancy no matter what. So surely the board and the public can understand why I have done a comprehensive research of what is permissible and not permissible. Because let's get real, whether I am an architect or not, or a land use specialist or not, I have submitted dozens of challenges which have been accepted. I ask the commission not to judge me on the intent as it's irrelevant and unbalanced. In my point of view, the intent of self-certification with objections is used to get away with regulations and issues that might arise and prevent the project from happening. So please understand, my faith and trust is in the system and not in applicants who self-certify and misrepresent facts to get a building that is very well and properly standing. So my intention in point is standing before the board, which is a public hearing, not exclusive to lawyers and land use specialists, to revoke the permit and appeal the decisions.
Thank you. I just want to clarify what my comments were about. The fact that you're not a land use lawyer or an architect means that you end up doing an enormous amount of research, which is great, but that you don't know how, you actually don't because you don't have that training, and that's all. You don't necessarily know how to read the code. So for instance, not knowing how to find where the district boundary lines are in the zoning map is something that you learn from just doing this for a living, right? So you're operating at a disadvantage. That's all I was saying. So to give you the benefit of the doubt, you're operating at a disadvantage, so we understand that when you import seeker regulations, Environmental Quality Review Act regulations into the zoning resolution or the building code, you may not be aware that that's not permitted under statutory interpretation.
I understand that, but you have to understand that this is a board, it's recorded, public is hearing it, they might not understand where you're coming from. So I made this opening statement to clear it, I am an individual who is an influencer in the community, and, I need to clarify
And then the reason that
things.
I asked, for instance, on the prior hearing, I don't know if you were in the room during the prior hearing, it's very clear that the people who are opposing that project want to stop the building, right? So their motives are quite clear, right? They have an interest in making the building shorter. So usually, I'm trying to understand what your specific interest is.
Right.
So I could focus on one of your complaints to see whether one of your complaints will accomplish whatever it is you're trying to accomplish.
So my main focus is what the application's for. Reverse decisions made with the ZRD3s, whatever it says not accepted by each one, reverse it if it's, again, to the board's decision. Number two, also revoke the C of O. That's what I applied for. I figured that was understood, that was my intent.
No, we know that you want to revoke the C of O,
Right,
but
so
I'm trying to understand.
whatever happens with the building is not
Why?
my concern,
Okay,
that's not my
Well, then it'll
issue.
just be standing there with a revoked C of O, so
I
you don't
understand,
get it
but
to go away.
But you're specifying as if it's like, it seems to be, I'm not saying that's what you're doing,
Yeah.
but it could seem to be in perception that as if we're trying to help them, do a little variance for themselves, the other party. If they want to do a variance and alleviate these issues that I'm going to present today in response from yesterday's comments, then that's up to them to do a variance. I mean, and I'm going to show it. I'm going to show it. If we can begin, I'll definitely show the issues that you presented yesterday.
So I don't want you to be repeating your arguments that you've already been made to us in writing. I just have to say, because they're quite confusing arguments where they're not the standard thing that we're used to seeing made by professionals who just do this kind of work. We spent an enormous amount of time trying to figure out what it was you were getting at.
So if you can please express what you didn't understand here.
So
and
I
can
would like
explain
you
it.
to please be very, very concise in your comments and don't repeat what you've already argued because you already heard our response to those arguments. If you have a new argument, that's a different thing, on the same
Well,
question.
Okay, now I'm even more confused, because yesterday you say you didn't read or understand anything I wrote here.
No,
No, I don't think
that's
she said
not
that.
what I said.
I think what
That's
she
why you gotta
stated
explain
what she
that.
stated was that the members of the board spent an inordinate amount of time digesting this material.
Yes.
You raised a lot of questions that are not customarily raised. You made arguments that we don't see every day. We spent a lot of time going through that and dissecting it and understanding it. So what the chair was asking was that you not repeat that, because we already own that information. If there's something new that you want to say in response to the statements that were made yesterday, we're happy to hear that. But we're trying to save, well, for a few reasons.
Can we try one point and then see if I'm doing what you're asking? Because I'm really confused right now on what you're saying.
I think what you-
Otley Brown also had something.
Yeah, I just want to say that I think that from yesterday's conversation that we had perhaps needed a little bit more information about your open space conversation, simply because not all of the commissioners were on the same page with what we had read. But other than that, I believe that we have no additional questions for the other points that you
Well,
raised.
I want to show a discrepancy of what was commented yesterday, if possible. That's why I'm hearing that. I actually wrote the discrepancy, so I'm a little bit confused. The attorney from the DOB mentioned that the rear yard was never disturbed. The fact, and I mentioned this fact, and I brought a video, I showed you the elevation in the plans, I called out the elevation in the plans.
No, let's be clear. We're not talking about the rear yard, you were talking about the side yard.
No, but I'm expressing what the DOB had argued.
Yeah, but let's forget about what the DOB had argued.
You can't forget about it, because that was the structure of their argument. They brought a zoning resolution, 33-22, in regards to natural grade of yard or not natural grade of yard, if it can be disturbed or not. That was their base of argument to state that the curb level of the side yard line should not be elevated. Am I correct or not?
So I interpreted it differently than DOB, right? So I used
Well,
a
that wasn't
different
said
section.
yesterday, right?
Sorry?
That wasn't said yesterday.
Yes, it definitely was. I went through the level of yard discussion yesterday very clearly. I cited to the sections in the zoning resolution that when you have a side yard, you're required to have a side yard of 8 feet. But when you don't have a side yard, you're not required to have any side yard. Once you're required to have that side yard because of your backing up, you're sort of siding up to the rear yards of the adjacent properties.
Right.
Now, by section, whatever it is, you have to have an 8-foot open space. Under the zoning, as soon as you create the open space, you convert that to a side yard. That's just the way it works in the zoning resolution. So then, under the yard regulations explain that the level of a yard shall not be higher than curb level.
That's the rear yard, not the side
No,
yard.
the level of yards, and so this is the part, so we're the interpreters of the zoning resolution, right? And we're not needing to interpret in this case, it's just reading it. So when you have it, so there's no side yard required on this lot.
There is a side yard required. We discussed this in the last
Let
hearing.
me just finish the sentence.
Okay.
We're talking about the northern side that's coincident.
That's not what I'm
with-
referring to.
Which one are you
You're
talking about?
confusing the whole thing, guys. I'm sorry.
Which
with all due
side
respect.
yard are you
We're
talking about?
I'm going back to what the DOB mentioned. I'm not talking about that side, the open space with the side yard. You mentioned what you said already. Right? You mentioned yesterday that it's been open and they have to conform to it either by putting a wall or putting a door. Am I correct?
No, that's the southern side yard.
Right, but this specific side yard in regards to where the community driveway is also.
That's the side
right,
yard I'm
that is
talking about.
along district boundaries, which 33-293 is applied. It was already decided that, you read from that decision. It was decided in the ZRD3, you read from it in front of me.
Sorry, the portion of the property that belongs to this owner sits fully within the district of the R4C12, I think, overlay.
Yeah, I think that is one standard that we all have to come to terms with. Zoning district map is very clear in this case, where this subject property is clearly within R4 with the commercial overlay.
Right, but that's not what I'm referring to right now.
So
We're
you-
jumping two different codes, with all due respect. I'm focusing on the one specific provision along district boundaries. You're jumping to right now where the district lines are. That's not the provision I'm referring to. That is the specific provision that the DOB responded to. I'm focusing on along district boundaries.
Okay.
Put aside right now, you asked me to be specific, I'm trying to be specific to the point. Forget the district line, forget everything else, along district boundaries.
Yes.
When you're along district boundaries, you have to provide a minimum 8-foot side yard at curb level.
No,
That's what it says clearly, black and white.
that's not exactly what it says. You're required to provide an open space because in a lot of situations.
At curb level. My key point is at curb level.
No, my key point is you can't, in the zoning resolution, there's a difference between the word open space and a yard and a side yard. A side yard is a defined term and open space is not. What constitutes open space in certain situations is defined, but not open space. So it's an open area that must be provided between the rear lot line of a neighbor and your side lot line, and your side lot line. But the way that it works is, as soon as the instruction is provide 8 foot of open space between your side lot line and your building, that open space converts to being a side yard. Once it's a yard, now I go and I look at the section that governs levels of yards, which is, level of yards, 33-22 applies to the level of yards, which states that the level of a yard shall not be higher than curb level. And it also says this section shall not be construed to require that natural grade level be disturbed in order to comply. So I get to the same place that DOB does, but in a different way than DOB does. That's all.
Okay, now, in that specific thing you
Madam Chair,
read,
could you move your mic a little more?
in that specific provision you read, it's referring to when the property is already at curb level and natural grade is above curb level. The provision of special provisions is where it's below curb level, and now you're required to put it at curb level.
No.
There's no correlation with the two.
It says the level of a yard shall not be higher than curb level. How else do I read that as?
But the
not
word
higher
special
than
means
curb level?
exception to the rule. The word special means it's out of the current rule.
Where's
Special
it?
provision,
There's no special, this is a standard.
special provisions along district boundaries. It's further down. 33-293, we reviewed this last hearing.
So, again, the special provision, as you're calling it, refers to open area, which is not a yard. Open area is open area.
And it has to be at curb level. How can it be an open area at curb
Because
level?
it converts, and we've actually had a case on this
But
where...
you're completely, with all due respect, you're completely ignoring the requirement of at curb level. So if it's below curb level, it has to be at curb level.
There's a disagreement. I'm hearing both sides repeating the same things.
Yes.
We disagree.
Yes. So we disagree, and so this is actually not what I wanted you to do, to repeat your argument that you already have made in your papers and then have this discussion again, because I don't want this to be a 2-hour hearing where you go through the 10 points that you made. We can't. So we cannot, okay? You made
So
a
once
submission.
again, so you said that a natural grade should not be disturbed and brought down below curb level. And the actual applicants have done that in the rear yard. That's exactly what the deal will be presented. So the actual applicants went against this zoning resolution.
No.
Yes, there was a rear yard prior to construction
It doesn't-
of 20 feet. And it says clearly, if you have to put it below curb level, you should not disturb her.
That's
You should not
what it
disturb
says.
it. That's what it says.
This section
All right.
shall not be construed to require that natural grade level be disturbed in order to comply.
And the issue is they've disturbed curb.
But it doesn't prevent you from disturbing it. It says you are not required to disturb it in order to comply with the section. So the buildings.
But they didn't comply with the section.
You just, sorry,
The point is they
rear
didn't-
yard. There is a rear yard behind the property, is there not?
There is a rear yard behind the
Okay,
property.
good.
Not anymore. It's below grade now.
The level of the yard shall not be higher than curb level.
Okay? Shall not be higher than curb level. So when they bought the building, the level of that yard was at curb level. So it should not be above curb level, but yet it could be disturbed to go down below curb level.
That's the instruction for level of a yard.
But if you go to the
Not higher
zoning
than curb.
33-293, it clearly states it cannot be below curb level.
That's not for the rear yard.
That
that's
is for the rear
side
yard.
That's for a side yard.
I'm confused now.
Okay, I'm gonna show
So,
you.
but I don't want to do this anymore, really. You asked the questions in your papers, we reviewed the questions, and that's how it works here. You
But
make
with all
your
due respect,
submission.
I never got responses to the initial thing that you requested with the bulkheads. Never got a response from the DOB? When you asked whether to measure
No,
further
you
back than
did.
10 feet?
You didn't ask it again in your papers, and we
I
did.
didn't, I never got a
We
response. You
Sorry.
asked it orally for a
We-
response.
But we got the response at DOB, and then
They
I
never
looked at
gave it to
again.
me.
You can't
'Cause
continue to
You
interrupt.
need to let the Madam Chair speak, please.
Okay, I apologize. Go ahead.
So when we talked about the mechanical obstructions last week, the bulkheads at the last hearing, DOB explained that they look at the obstruction above the maximum permitted height. That's consistent with what the parapet wall regulation is as well. It says the parapet wall is 4 feet above the maximum permitted height. You don't need to think about it as a parapet wall when it's below the maximum height. So it's logical for them to read, and it doesn't give the instructions in the zoning resolution don't tell you otherwise. It's logical for them to only read the portion of the bulkhead that is exceeding the maximum allowable height. And if I remember correctly, because this is an old question, when you did the math, even on the bulkheads below the maximum height, it still worked out in terms of aggregate street wall width. So again, this is like arcane zoning talk, but you add the width times the height, and it can't be more than a certain number, right? And the architect had done those calculations and showed compliance, and if I remember correctly, it even complied if you didn't interpret it the way the Department of Buildings did. And the reason I brought it up was I was interested in the Department of Buildings' application of that rule, but I didn't see that the bulkheads didn't comply, even if it was applied the way I had thought it was applied, where you measure right off the roof line. But it makes sense what they're doing, because otherwise it doesn't make sense as a permitted obstruction when you're not penetrating the maximum height. There needs to be a point at which you start the measurement. Okay, so we talked about it at length at the last hearing. There isn't.
The last hearing was requested by the Department of Buildings, whether you measure further back the 10 feet, whether you measure the bulkhead on an angle, because aggregate width wall refers to when a wall faces the street. Since the building is in a specific angle, every single point of the angle, if I create a perpendicular line, I presented you the actual drawing, it's in the definitions. They were supposed to respond to that, you requested that response, I never got that response. And you can go back Madam Chair, with all due respect, you can go back to the YouTube channel in 4/23/08.
It sounds like there might be a little bit of confusion as to the board's sort of determination. The board sets forth a determination in a written resolution, and it sounds like it might be helpful for you to have the board's decision in writing so that you can determine whether you feel that the board has complied with all applicable laws. And if you disagree, then you can go to the Supreme Court of the State of New York and file an Article 78 proceeding. But it sounds like right now we're listening to a lot of disagreement.
Listen,
and so,
with all due respect, I understand where you're coming from.
You've had ample opportunity to submit your bases for why the certificate of occupancy or this building does not comply with the law. And so how can we be sitting here having this conversation about what the board has determined when you haven't had a chance to review what the board has determined, which will be set forth in writing?
With all due respect, guys, and the board and the commissioners, last time I was here, Madam Chair said clearly that if I would come, maybe the DOB will agree to what I am saying. And in those discussions, I think you should review the May 21st submission, the hearing. I was here, I heard it.
The DOB did agree with one of your comments.
But the 3 questions you proposed, and I was waiting for those answers.
So I think with one of the options that we have is we can close, we can review the tape and review the May 21st hearing. If there's anything that comes up, we can reopen the case if we feel necessary, or we can decide on the next date.
Okay, I think closing is a good idea, because I don't want
I
this
humbly
to go.
request that we don't, because I have other points that you did not discuss yesterday to address.
So if you're going to make we can take, I don't want to take another submission, because these things your submissions are very difficult for us to review, because they do go all around, right? And so we dug in as deeply as, you have 5 people plus counsel reviewing your requests, right? Plus the Department of Buildings, which I thought did a good job of answering your questions, and concluded in one case that your observation about the southern side lot line was correct, and the owners have to amend the drawings to respond to that. But what we have been presented with to date, we have now concluded that that your concerns don't have merit. In other words, the building complies with the zoning, and I don't think that there's anything more to discuss. If you want, we can close the hearing and review.
Listen, I came here to present points of yesterday. I think I have a right to present certain points. If you feel that they're not...
You're going over things we've already
But I haven't even
reviewed.
started, and
Yes,
I'm
you
already...
have.
No, I haven't. I haven't even started. For example, you mentioned yesterday curb level. You went to the 2015,
What are the points that, how many points do you have that you would like to present?
Okay, so about 4 or 5 more points to present.
No, we're not doing
I just want to say that the board was not convinced by your arguments, in a nutshell. That's it. We were not convinced by your arguments, but now we are ready to close.
But with all due respect...
No, wait, I'm not done. If you want to take this further, then you do have the option of filing an Article 78, but we don't have the time to sit here and go back and forth.
But with all... I understand. I'm not denying what you're saying right now.
Interrupting.
Because you disagree with our point of view on these.
I'm not disagreeing with the point of view. Yesterday, you mentioned that the curb level is at 77. That's not the curb level, that's a base plane level.
Then you-
Curb level is 75, it clearly indicates it in surveys.
What you're doing-
And the zoning clearly states you calculate a height from curb level, not base plane, especially when it's found in the street line.
May I ask, is your intention to argue against the statements that were made yesterday?
My intention is to clarify points of yesterday's statements.
No, you're
Of my position.
disagreeing, you're not arguing.
But I'm not giving the opportunity to present it.
because you're
From the
incorrect.
onset, I was told that I cannot talk.
No.
That's not fair.
It is fair. We've heard all of your arguments, your submission, and we reviewed all of the issues raised in your submission, and we don't agree with your conclusions. You're incorrect about where you measure height from. It's from the street line, which is not the curb. The street line is the property line. That's the definition in the zoning resolution, and the survey shows 7705. I'm sorry, sir, but if you don't understand how to read the zoning resolution, that's part of what's
But-
leading you down this proverbial
But
path.
I want to
and
clarify
we're-
one thing.
we're not
I work
gonna
for an
continue
engineering
down the
firm.
path with
For you to say I don't understand, I do project management for an engineering firm, 5-year architecture and engineering. I did not bring this to the point because it's a
Yeah,
personal
we're
issue.
We're closing.
Mr.
Are there
Ramos,
speakers on this?
The chair
Department
has
of Buildings
decided not to take
needs to speak, yes.
Decided to close this.
Yeah,
I'm
we're
sorry.
done with
She
this.
doesn't want to take any more testimony.
I
Right,
think
okay.
we might have to ask if there's speakers from the community.
Yeah.
There's no-
Department of Buildings is a party to this, so do
Yeah.
they want to speak?
Anybody else? Is nobody else? You
Good
wanna
morning.
say something?
Michael Zoltan for the Department of Buildings. Just one
Todd, too, is the owner.
One correction from my papers. After speaking internally at DOB, we had requested for the side yard that an Alt 1 be filed.
Yeah.
I was informed that an Alt 2 would be
Alt 2,
sufficient.
that's what I
but that
thought, yeah.
counsel for the owner has still represented that they will comply with that. But it's Alt 2 as opposed to Alt 1, just to correct
Okay.
that record.
All right, so an alteration type 2.
Yes.
Right, that makes sense. I didn't understand why it was an alt 1, but I'm not the DOB. So, okay. Thank you very much. Todd? Oh.
He represents the owner.
Oh, okay. Owner's representative.
Todd Dale on behalf of the property owner. I'll make this quick. I just want to confirm what the Council for Department of Buildings said. We agree to any condition with respect to resolving the Elm Cove issue and filings that are necessary.
Okay.
And I would also just like to thank the board for their patience and efforts on this case.
Thank you very much. Okay. All right then, so I'd like to make a motion to close.
Wait, the applicant is, the appellant's not in the room.
He doesn't speak.
In the room?
I think he's in the room. He left
He
under
chose to
protest.
leave the room.
Yeah.
That's his choice. He's leaving under protest. Does he have to be in the room?
If anything,
Well, in that case, we should just vote. Yeah. There's no reason to look at
The only-
videos.
I agree. We should
Yeah.
vote. Maybe something's close. I think we have reviewed.
yeah, I think you're making a statement.
Madam Chair, I just want to make it very clear, in my review of this, I reviewed, to understand the full depth of this thing, I went back and forth between the prior discussions and what was submitted. So I think, and I would think all of us had to do that because it was a pretty complicated set of documents, and trying to piece the pieces together, we had to go back and forth, so.
And by back, you mean to the original tape on
To the
521?
original tape, original documents, and trying to connect the dots.
Okay, thank you. Okay, to just note that the appellant is not present, but, and I just want to add to that, I spent probably 2 days reviewing every question, trying to break it down. So the idea that we didn't give it a fair and careful review is incorrect. And this is the second hearing where we gave very, very deep review on the first collection of papers, which were very confusing. This second set of papers was less confusing, and so it was possible to dig in and find a way to understand what was being asked of us. So I think everyone spent an enormous amount of time trying to figure out if the questions had merit. So anybody want to just say anything? Otherwise, we close. Okay, so a
you make
motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta? Commissioner Shabeta? Do you want to vote, or you want to wait?
Yeah, and like to bring it to a vote. Motion to grant the appeal?
Chair Promoter?
No.
Vice Chair Chanda?
No?
Commissioner Otley Brown?
No.
Commissioner Sheta?
No.
Commissioner Shabeta?
No.
So this is for both 2017-147A and 2018-183A. Both applications have been denied.
Thank you.
Special order calendar, item number 4, 54084BZ, 341 Soundview Avenue, the Bronx. Here, number 5, yeah. Yes. Did I say 4? I said 5. I thought I said 5. I'm sorry. I keep doing that for some reason lately. Getting ditzy. Raise your right hand. Raise your right hand. Oh, hi, how are you? You can sign in later, but just raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Go. You can sign in that now, as she's speaking. So I'm not going to mark this adjourned.
No.
Yeah, you can sit. No, she said she was not given an adjournment. Oh, okay. Madam Chair, just for clarification, we're not accepting the adjournment, right? Correct.
Yeah,
Okay,
that's why
fine. I just want to make sure when we mark the
I think
vote
we might have
sheet.
to open.
No, it's not, oh, is it open? Is it closed? Oh, it's closed, yeah.
Oh, I'm sorry, yes. I apologize, yes. It has to be
Yeah.
open. Reopen it, yes.
So for a motion to reopen.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Elise Fullader from Eric Palatnik PC on behalf of the applicant. I brought Lance here today. He provided you with photographs of the work he attempted to do, and I can go through it with you. If you turn to this set of photographs, the other set's all landscaping, and this set is of the wall on the first page that he stuccoed, the slats, and the landscaping photographs were from before. This is the photographs these photographs are from yesterday, this set. These are the slats he put in. And then after that, you can see the curb or whatever sorry, I don't know the exact name for this, but curb type area he installed in front of the trees.
Wheel stuff?
And then there's more photographs of the slats and the no parking sign. And that's what we have from yesterday.
Okay.
I didn't submit it because I felt that it wasn't I didn't want to give you a half submission, but if the
So
size...
explain to us what it is that you didn't think was, so in other words, the landscaping hasn't been installed, is what?
Well, the landscaping is the same as it was on those photographs from before, but I haven't had updated plans from the architect.
So you're waiting for updated plans, so what's holding up getting
But he
the up-
says that the landscaping matches the plans, but I don't have, he says that his trees, but I don't have a full set of landscaping, and I wanted to confirm that before I made a submission, so that's why I hadn't made a previous submission.
Sorry, I'm not understanding. So this is a photograph of the landscaping as installed, right?
Yes. But my client told me today that that amount of trees is the amount that is on the plans that you have.
So, I'm just looking at this.
Okay, he can also explain anything.
Yeah, no, but it's more than explained. So the block wall belongs to whom?
The block wall belongs to,
State your name for the record.
I guess, oh, I'm sorry, Lance Medina.
Okay.
The block wall belongs to, I guess, the neighbor, but last time I was here, you guys had asked me to stucco it.
Yes.
So I stuccoed it, I had it stuccoed. The landscaping,
Okay, so wait a minute, so this photograph with the trees in front
was prior to the stucco.
is prior to the stucco? So this is that
the-
wall stuccoed?
Yes.
Okay. Okay, and then the curb that is needed in front of these trees?
So the curb was it was a railroad,
Tie?
like 8x8 railroad tie. And so what I did was to kind of keep the wood look, I couldn't find any railroad ties. So what we did was we kind of like, got like 10 by 2s or 10 by 1s, and we framed it out and we went around to kind of keep the wood look.
Okay, so
And,
this,
and
but this isn't
in
the
the
same
area that
image.
was.
I don't, so you're saying that's the
That-
image? But
yeah.
that's not in front of a stuccoed wall, it's in
No,
front of a
that,
brick.
because before, that area there was like, the wood was rotted away. So that's what you guys had asked me to repair. And we said we were gonna repair with pavers, but I couldn't even find pavers that huge, like 10 by 10 or 8 by 8 pavers. So we came up with an idea and we boxed it out to keep the wood look, make it look uniform. What we did was we made like a wood
So
casing.
then, is that photograph the, so I'm having trouble following along with what changed.
So that's.
Is this photograph the one that has the curb in front of the tree?
Actually, the photograph, you have the old photograph, when it was messed up? Where like where the curb was like messed up?
This is the ones from before.
Okay, so yeah, you can see partially here.
Hold it up if you're.
Okay, so in this photo here, if you look at the bottom left, you can see it's partially deteriorated. That's what, last time, you guys had pointed out to me. All those railroad ties were in good shape.
What about?
And those trees never had any railroad ties there?
Right, but they need to have a curb, is the point. You can't just have the soil fall into, unless it's
Yeah,
in
no,
a,
what we did was we put like, Home Depot sells a plastic 3-inch trim. Before you put the sod down, you put you create like a little edge with like a plastic trim. You don't really see it, but it's there, the soil, so that the sod is like deeper than the actual ground. And then you install this, it's real thin. It's
So-
to hold in the sod from coming
what's
out.
on the other side of that little plastic trim?
On the other side is.
So the trim separate,
Separates the grass from the sod.
so there's grass on, so if you have the trees over here,
Uh-huh.
what's over here? Grass?
Grass, like grass, it would be, it's a shaded
Is it-
area, so the grass doesn't grow too well there.
Right, so the whole thing is, you need a curb to hold the soil in place, otherwise, when it rains, all the soil washes out. That's why you install those curbs,
Oh, the curb, all right.
right? That's what they're there for, right?
Okay.
Unless it's planted in an area that's all soil, you know, like a little garden, that's
Well,
all
that's
soil.
how, prior to even doing any of this landscaping, that's how it was. But when I had the landscaper come in, we just continued with the sod all around. But that's how it was along the slotted gate. That's how it was prior. There was no sod there. I had the landscaper just to go kind of uniform. When he planted the trees, I told him to go ahead and put the sod around it. I wasn't aware of that.
Okay.
I didn't know that.
I'm looking, I'm trying to understand this because it's sort of in, you don't have a floor plan with you, a site plan with you, do you? 40. Okay. So the comments that we had the last time were that the landscape, you said the landscaping was installed and will provide photos that the landscaping matches the plans. And then Mr. Medina said that the stucco, he'll stucco the block wall and finish the slatting on the fence, right? So what you're saying now is that, and I'm trying to find a plan. Oh, you found a plan. That the plan, no. Where are you? Sorry?
I don't think it's changed since the
Everything, everything is everything you asked for last time I was here, I complied with.
Okay.
I fixed the curb, I stuccoed the wall.
Okay, I see what the confusion, the only drawings that I have were filed March 20th. And the site plan is very super simple, right? So it doesn't tell you, maybe that's part of the confusion. Is all of the space behind the building grass, sort of
Yes.
grassy area?
Yes.
Oh, and there's no equipment that, you can't fit equipment back there because there's no way to get there?
Yeah, just a little
Right,
door.
I see. So this is really just kind of a buffer zone. So, okay. So what I would ask you to do, but I think then we have what we need, and I'm sorry you wanted to adjourn this.
The only reason why I wanted to adjourn it was because I wasn't clear on certain things, so I wanted to come to you guys, with 100%.
Okay, appreciated.
All right.
So what I would just ask you to do is on that grassy area that you say doesn't grow very well, instead of it having nothing, try planting little vines. Vines do really well under the worst conditions. There's like English ivy and I don't know what the other one is, but it grows, you don't even need to water it. I mean, it's pretty amazing stuff. And then it'll fill that area in and it'll look better than nothing.
All right.
Yeah, and in that way, it'll discourage you from, let's say, workers from throwing trash back there or whatever.
Workers don't have access.
Nobody has access, so it'll just make it look prettier.
All right. cool.
Okay?
All right.
So we'll just put that in the conditions, and you don't need to change the drawings, okay?
Great. Thank you. I appreciate
Okay.
it.
So I think then we can close this. Again, motion to close?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Okay, so I would like to make a motion to grant on condition. One of the conditions is compliance with the operational plan, which I believe we had at one point, right? We have an operational plan. And do we have an operational plan? Yeah, it's about the cameras, the speed bump, all that stuff,
All
right?
that's in
Which we
place.
talked about before, right? And then maintenance of the landscaping as shown on the drawings. And in addition to what's shown on the drawings, the planting of ivy, ground cover ivy in the open space behind the back of the building to the rear wall, to the rear planting.
Okay.
You'll understand it better when you look at the drawing. Okay, is that okay
So
with
here,
everybody?
right? Here.
Okay, so then on that motion, a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Thank you very much for coming, really appreciate it.
Thank you so much.
Okay,
I'm sorry.
go ahead.
Item number 6, 41850 BZ, 7369, 217th Street, 7336 Springfield Boulevard, 21902 74th Avenue, and 7310 220th Street, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? I do. Hear this one? This is an adjournment, right?
For the applicant, WOTC Tenants Corp., Eric Goydell, 4 Goldstein Altshuler Names and Goydell PC. Thank you again for having us today. There's nobody from Windsor Oaks appearing with me today. We had sent in a letter, and I acknowledged that it was a few days late. I was waiting to get the contract with a new vendor, the draft of the contract out. I'll also get a proposal from the new vendor. And also, we were waiting on Councilman Grodenchik's letter, which came, I believe, around August 27th. So, since the last appearance date, we identified a new contractor, Landmark. We're in the middle of a contract with entity Verde Domain. The season runs per the contract to December 31 with cleanup and what have you. And then we have a window period between January 1st and March 1st, within which we can terminate what was a 3-year contract. We were only in the first year, and I have that diaried for January 7th to do so. In the meantime, we are going to sign this contract, but the vendor Landmark has the contract for review. We had asked them also to give us a proposal for the buffer zone, and I laughed yesterday because I kind of empathize with what you said about the Latin. So I graduated from Stuyvesant High School, started college thinking I was going to be a science major. Then I took botany, and that disabused me of that thought, and I'm an attorney today. So I think we're maybe wired similarly for those genus, species, and phyla, whatever. The vendor didn't want to give us a formal proposal for that until we had the underlying contract negotiated for the work.
Oh, so that's some general maintenance for the rest of the grounds?
Right, that contract is for general maintenance, and then once we have that signed up, that's for the whole property. Then they were going to give us a proposal where we might, as you pointed out, Chair, we might secure additional proposals depending upon how costly that proposal is and the scope and the recommended scope. So we would appreciate. We will have this contract, I expect, signed sometime in the next few weeks, and then we will be terminating, as I said, right around January 7th. But between now, when we have this contract signed for the general work, we can get a proposal, from them and perhaps some other landscaping companies. Preferably, we'd like to use the same landscaping company. All things being equal, it's better to do that. So we'd appreciate further indulgence. We're trying. But it's going a little slow, I acknowledge.
So it's just mostly to show that we're staying in touch, so, and not to wait until the planting season where we miss out. So if you could come back here in January with the status on your signing of a contract for the buffer zone.
Sure.
Right, or at least have a bunch of proposals, and one of them is the way you're going to go, or something to that effect, because then you don't have a lot of time. Otherwise, you lose your place in line, right? Because they're getting jobs, and you'll lose your place in line. I dare say you need to decide sooner than January, or you will lose your place. So, okay. Are there any speakers on this? Okay. So let's just put this on for like a mid-January.
Okay, so with the submission January 8th, and the continued hearing on January 28th.
8th and 28th? Thank you. Thank you very much.
Great, thank you.
Thank you, have a great day.
Thanks for coming.
Pleasure, everybody.
Item number 7, 75160 BZ, 105 New Dorp Lane, Staten Island. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member question?
Of course. Aren't we adjourning this? Aren't we adjourning this?
Oh, yes, sorry, so you need to swear in.
Yeah,
Sorry about that.
we need to adjourn this because
Sorry.
we need to give notice, right?
May I just please do information?
Yeah, sure.
Just wanted to let you know that we've actually been playing a bit of phone tag with Deborah D'Erico from Community Board 2. We finally got in contact with each other yesterday. She's going to speak with her board and see if they would like us to come back out. Of course, I made the offer. So when they determine if they'd like us to come back out, I told her it would be our pleasure to do so. With respect to notification to the neighbors, although not technically required by the rules, we're more than happy to do it. My question for you would be, because it's not under the rules, I have to ask you how you'd like it done. We are over 10,000 square feet. Would you like it 400 feet from the center of the site or 400 feet from the corners of the site?
The main concern is the immediate neighbors who are affected
So would
directly
you like
by
us to
this
just do the
activity.
immediate neighbors? We're open to however
So
you
I would
would like us
say
to
from the
notify.
corners of the site, 200 feet from the corners.
200 feet from the corners?
Is that the site?
Yeah.
Yeah. Well, 200 feet from the corners. Notify the right people. So the adjacent residential is...
They're certainly within 200 feet.
Hold on a second, wait. Just It would be across the street also. Have it...
They have right behind them and across the street.
On
Yeah,
both sides of the
so
street.
you have both sides, yeah, so what is that? Both sides of Cloister and both sides of New Dorp. And Railroad is a commercial strip, right?
That's a railroad cut.
No, that's a railroad cut, right. So, and then maybe, say, two houses to the, so that would be lots 67 and 40, and 23 and 21, that's on the tax block already, and lot 28. That's on the tax block.
So you only want us to alert those, or alert to 200 feet from the corners, plus make sure that those lots are included?
Make sure those lots are included.
And do
so
200 feet from the
200
corners?
feet from the corners, making sure that the two adjacent properties, two over, and that across the street is also.
So those were lots 67, 40, 23, 21, 28. What were the additional lots? I just want to make sure we're getting all the lots that you'd like to be
Yeah,
notified.
hold on a second. So then, so that's on 30, that's on block 3630. Right, and then across the street, it's parking.
4199, it would be lot 1.
So 4199, lot 1, and
3629, it would be 44 and 33.
so.
Block 3629, lot, did you say 44?
And, is that residential?
No, that's commercial.
That's commercial, so 40,
And maybe this also.
44 and 46.
Yeah.
Okay.
Make sure those are included.
Absolutely, so 200 feet from the corners, plus the listed lots, which were 67,
Yes.
40, 23, 21, 28, and then lot 1 on 4199, then lots 44 and 46 on 3629.
And I mean, just in case we might have missed one, the idea is that we're.
Of course, so we're going to hit the 200 feet
all
from the corners
surrounding-
also.
Yes.
This
So
is C
we should
lot,
cover
so
everybody.
maybe this is-
Commercial
And
and
this-
retail, I think.
Let's
CR
see.
is commercial retail, right?
It is CR is commercial retail?
I think so.
And just for the record, we also have a survey already on order.
So this
Once we
was
received the
mixed
fire department
residential.
letter yesterday morning, we ordered that survey.
I'm sorry, say that one more time.
Once we received the fire department letter yesterday morning, we automatically ordered a survey.
Okay, good.
We will, of course, amend the plans accordingly, and if a change needs to happen due to the construction classification, we will make that change.
Right. I think maybe they're concerned about the 2-hour wall, needs
Right.
to be more.
We're not going to know until we get the survey where their building lies to determine what we need to
Right.
do.
Right. Okay, okay, good.
Okay, so we'll take
So
care of
then,
that.
how much do we need to notify, 20 days to notify, so it's like a month at least, and I don't know what our schedule is.
So she has to amend her application.
Yeah, this
So
is,
she has to amend her application, so that amends, so we'll go back to all the electeds.
Well, we did already modify the application, and we sent out CCs that were required on it, but we will also be notifying the neighbors now. And we've offered to meet with the community board, as I said.
Okay, I just want to make sure.
Okay, so about November. Okay. Submission October 30th for a November 19th continued hearing.
Thank you so much.
thank you.
Item number 8, 9091BZ, 636 City Island, the Bronx. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
Good morning. Amanda Iannotti on behalf of the applicant. We heard the board's comments yesterday. Several questions regarding the parking in the rear. The prior approval does not expressly permit any sort of heavy machinery parking.
Right.
I'm not clear at the moment what that's used for, so I have to get some clarity from the applicant. I believe it might be related to the second, the store right adjacent to the Dunkin' Donuts is like a general contractor construction office. I think it's related to that activity, but I'm not sure. So I would have to get back to the board on what those trucks are therefore.
I think that's what you said at the last hearing, that you thought it was related to the contractor, but I
Yeah.
don't think those trucks belong in a residential neighborhood, especially seeing how they're used. I mean, it's not
Sure.
like they're just stored there empty, they're stored there with supplies piled on top, so, which isn't, open storage isn't even allowed, so. Okay.
I will talk to the applicant about moving them. I'm not sure if they just sit there for storage, though I think they're actively used.
Right, so it seems like, and again, I don't, without looking at what would be required in order to allow a contractor's establishment to install all, and that's not even a use group 6, a contractor's establishment. So it's not
It's
even.
like a retail, it's like a sales office.
So a sales office wouldn't have a heavy earth mover and a gigantic
We'll speak with
dump truck.
applicant about moving them. Yeah, sure.
So, yeah, see, there's an earth mover, and then there's another photograph with this dump truck filled with stuff.
Okay. A number of improvements do need to be made to the site. Just to go over them again, fix the cracked asphalt and resurface some of the broken parking area, fix any fencing that requires repair, fix the dumpster enclosure and move it away from the adjacent residential lot line. So we'll look at where we can move that to. The planting beds, you noted that the plans were revised to include it along the rear lot line as well. We'll revise the type of tree to be at least 8 feet high and include a curb to hold back the soil and the mulch, and also put wheel stops or something to prevent the cars from rolling into the landscaping bed. In terms of changes to the plans, we could make the line between the commercial property and the residential to the rear. We can define that boundary more specifically. The lumen spread, we need to make sure it's 0 at around all the property lines. We noted that there would be shields installed on all the lighting. I don't think that that was enough to bring it down to 0, so I'll have to speak with the architect about that.
The poles are very high.
Okay.
I think that's the reason that they're having a problem. I don't see how shields can really work, because they're expected to take care of the entire yard. And in order to do that, the poles are really high, so not sure.
Okay, maybe look at lowering them or moving them.
Or changing the light fixture to be a different type. I mean, there might be something that's more focused. You know, lighting is very sophisticated these days, so.
Okay. So all of those improvements will need to be made now.
Yes.
And we'll need some time for that. I wanted to just ask one question. Did you want to see a revised planting and landscaping plan before the improvements are made, or are we just going to go ahead and do them?
Do them. So we need to see, so the trash enclosure affects the planting. So we want to see where you're proposing to put the trash enclosure. So yeah, I think we need to see it again.
Okay.
But I would like the work to be done under this planting season.
Right.
So we'll have you come back fast.
Right.
Okay. Also, we wanted information to clarify, because it's difficult to tell the difference between the approved plans, the existing, and the proposed. You were going to give us more information on that?
I thought it was just addressed verbally at hearing, but I will put it in writing. And the as-built survey actually changed slightly from what we had said at the prior hearing. So the prior approval allowed about 9,400 and change square feet. The as-built survey now shows 9,186 square feet, so it's actually about 300 square feet less than the original approval. And I believe that's attributable to the width of the building's actually slightly longer than what was approved. The rear line was 91 feet 10 inches on the approved plans. The as-built shows 86.8 feet. So there's a bit of a difference between what was approved and what was actually built. And a small difference.
Okay.
Can I make a comment and probably a suggestion to address the lumen? The reason I think the lumen count is so high, especially along the residential, as the chair mentioned, one is that the light post is very high, but there's only one existing light pole in the rear, which is kind of trying to shed light on that from one corner all the way. So I think the way the light is projected, it is going to result in some spillage into the residential. So you may have to consider providing another light pole on the other corner, and that would bring down you can then direct the light in a manner and provide the shield and not cause an overspilling into the.
Plus, you have a
residential.
building on which you can mount lights, so where there's a proper shield so that they don't cast further than. I mean, the building
On this.
on the actual building on the site.
Yeah.
Can support lighting. It's cheaper to install, that's why I'm saying it, because it's very much cheaper to install lights on a building. But I
Right.
think that you will still need another pole, probably.
My only concern with that is because this is, the subject's building is 1 story and the residential building is 3 stories, so there might be some light that would be visible from the
Right.
residential windows in the.
There are some lights
So-
on the building, so if you look at
Right,
photo number
there are.
6, there's a light right by the bait and tackle store, and then there's 2 small lights that face down closer to the Dunkin' Donuts entrance.
Okay.
But they don't really shine, well, I guess the bait and tackle one shines a little bit into the parking lot. The other 2
I see.
more for
Yeah,
the
And I
wall
think those
lights.
are, and those are adequate for the accessway.
Walkway, yeah, yeah.
Oh, we'll take a look at that. I know another change was to extend the walkway to the handicap ramp up to space number 8. So is that's just like a hatching on the ground so nobody
Yeah.
drives into that area?
Right.
Okay. Okay, so
And also put a wheel stop so that the vehicles don't.
a wheel stop.
Yeah. Overextend, yeah.
Overextend onto the.
Okay.
And then we had a question about the parking calculations.
Right. So, the parking calculations do all appear on Z001. The general commercial, in the 3rd column of calculations towards the top, where it references ZR112.
Wait.
Sorry.
Z01, okay, where is it? Oh,
On the 3rd column at the very top where it starts with 112-111, that's the parking calculations for the general commercial, 1 per 300 square feet.
But it doesn't show the area. Where's the calculation?
5,000.
Oh, minimum number of parking spaces,
70.
2168 square feet. That is for eating and drinking. And that's where it says it's waived. Where is the calculation for the retail?
That's 1 per 300 square feet is
So
the general.
accessory of 5212 is the general retail?
No, it's also under the special district 112-111.
Right, so that says the minimum number of street access parking space, 1 per 300 would result in 17 spaces.
Right. So wait a second. You have, what are the uses again? You have a Dunkin' Donuts and a what?
Dunkin' Donuts and the Baskin
Three
Robbins
retail.
is considered an eating and drinking establishment. And then three commercial, regular use group 6.
So in that 5212 calculation, what's being included? Everything
The
but?
other 3 stores.
So not the Dunkin' Donuts
No.
and not the Baskin Robbins?
Yeah, that's one store, but Dunkin' Donuts.
Oh,
Baskin
that's a
Robbins is
combined
one thing.
store? Oh.
Yep, one thing.
So that's the store that is
For this-
2168 square feet in combination?
Yes.
So the 17 spaces are for the retail only? Is that correct?
17 commercial spaces for the general use group 6, and 1 for residential, so there's 18 now in the rear.
Okay, but we did have a question about how you are going to actually reduce the size of your
Right,
resident,
so-
your restaurant.
There was a rear storage room that was part of the Dunkin' Donuts store. It is 168 square feet, and it was not really being used by them, and the applicant, in an effort to create a better arrangement of the parking layout in the rear, and not have it
be required to be an intended stacked layout for it to be a self-park and with better maneuverability, will give that storage room over to the contractor office that's right adjacent to it.
Yeah, I understand the idea of give, but I also understand the idea of leases.
I'm not sure how he's working that out with the leases and with each tenant, and in terms of rent. I can find out more information on that.
Yeah, because that's the part that for me isn't believable.
Okay.
I sign a lease for 5 years or whatever it is. It's the space I signed a lease for. What are you going to give me to give you back the space I signed a lease for?
I honestly cannot speak
Right.
to the negotiation to move that one room
Yes,
to the other.
But I know that you can't speak to the negotiation, but I need to understand that it actually can happen, because if it has to wait for the termination of that lease, it's effectively not happening.
Okay.
Right?
I will get more information on that.
Right, and then we said the ramp. Okay. All right, I think those were all the issues, other than talking to city planning about that strange waiver rule. Okay, are there any speakers on this? Okay, so I would like to put it on for kind of quick review of the
Revised plans.
site plan. How much time do you need to modify the site plan, relocate the dumpster?
2 to 3 weeks.
What's up there?
I also had a question, if you have submitted an application for street tree.
I've requested proof of that. I haven't received anything back. I don't have confirmation that it was filed. I'll resubmit with that. Thank you.
So what I would like to do is, so planting season begins in a month. Okay. Right? So I would like to see if we can, it could be submitted kind of late-ish, so maybe 2 weeks before the hearing. Okay. Can we get it in for early?
Well, they mentioned 2 to 3 weeks, so how about October 3rd is really fast. How about October 22nd with an October 2nd submission? Does that work?
Yeah.
October 22nd hearing?
Yeah.
I'm afraid that doesn't really give him a lot of time to plant.
No.
No.
We'll do it quicker, if that's okay.
So we have an October, what's that? How many are there on this hearing? No, but all we're doing is just checking quickly. So if you could, so for the October, what do you say, 3rd hearing?
Yes.
Submit pretty literally the week before, I don't know, it's already.
I'll do it as quick as possible.
Okay.
Okay. So the regularly scheduled date would be September 13th, which we've passed. So the options would be Friday the 20th, Wednesday the 25th, and Friday the 27th, which would be realistic.
Can we shoot for Wednesday, the 25th?
Yes.
Yes.
Okay.
Okay. And if you could, on your cover letter, for one, indicate that, so that alerts the project manager, just in case, that the board said it was okay for you to submit on the 25th. And also to just show us bubble the drawings and indicate what the differences
changes
are.
are made?
So it's really fast for us to just look at the changes. Okay?
So this is for October 3rd.
Okay, so a submission on Wednesday the 25th, or September 25th, and continued hearing on October 3rd.
Remember, that's a Thursday.
Yeah, it's a Thursday.
Hearing's a Thursday, review session's Wednesday.
And also, if you could, on your cover letter, note that the reason for the submission is for us to verify the planting and dumpster enclosure, and early enough to allow for you to meet the planting season.
Okay.
Okay, so that way, it's just a reminder to us why we're getting the submission late, and also what we should be focusing on in terms of the review. Okay?
And you don't want any improvements begun to made, like
If you have started doing
like
it.
the asphalt or the fencing?
You can do, yeah, for sure you can do that if you've made progress on that. That would be great.
Okay,
I mean, for
like
instance, you already know that you're going to have to start digging a planting bed. They could start that work with the
Okay.
understanding that at some place or other, there's going to be a dumpster, which may not be where they think they want to put it, right?
Okay. Thank you.
The issue is the dumpster can't be in front of the residential use, so where does it go? Right?
Yeah, there.
Yes.
The property to the, well, the right side is a mixed use. I don't know if that's a better location, because otherwise it's residential on both other sides.
So the way that it's placed, I think there's just one. Yeah, because you have the drive-through there, so you can't put it where the drive-through is, I guess. That's 18 feet, and everywhere else, you've got residential. So my question is, like, maybe it needs to go up against the building. And I don't know exactly how that would work with your parking spaces, so it might affect your parking. Because otherwise, you're just placing it in front of a different apartment
residence,
building, right?
The
See, if
adjacent
it's
building to
here,
the south
it's
is
a
commercial.
apartment building.
Is it completely commercial?
Right.
Then we should put it against a commercial property. If you can't place it against your own.
No, but so the commercial property is located opposite the adjoining, an 18-foot
driveway.
drive,
Right.
right? So they can't put a dumpster in the 18 feet. So, I'm kind of looking at,
There's a corner next to spot 18.
but that's next to
That
residential.
backs up to the residential.
That's two
again.
residential
Yeah, right,
spaces.
right.
My eye is on somewhere around parking space 8.
8.
Now, how that affects your parking layout, I don't know.
Okay.
You maybe
It's big enough to accommodate.
Yeah, but maybe you move the parking spaces down a bit, that kind of thing. You will have to play around.
Okay, we'll look at that.
Okay.
Okay. Thank you.
Thank you. Did I ask if there were speakers? No. Are there any speakers on this one? No. This is 630-636 City Island Avenue.
The applicant is,
Oh, okay.
if you want to say.
This
Are
is
you
the owner?
applicant?
Yes.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Please state your name for the record.
Good morning, ladies and gentlemen. John Chaffone. I'm the owner of 636 City Island Avenue. We have done some work since we were last here. We put up and straightened out fencing, redone the fencing. We did concrete. We're cleaning up the whole area. We ask, I personally ask that you approve us as soon as possible. I have a vacant store there that I can't rent because I don't have a C of O. It's the property, I want you to understand, this is not a typical Bronx property. City Island is a unique area. The rentals for commercial and residential are not like the Bronx. It's often misinterpreted. It's much lower, and our taxes are really high on the property. Not that, you consider that, but I want you to understand, it's very difficult for us to continue to maintain this property. So if you could grant us the C of O as quickly as possible, would help us continue to make the promises to improve and to, again, comply with your requests that you've set out from the very beginning. I appreciate it all. Thank you.
Okay, thank you. We're trying to expedite the schedule. You see, we put this on very soon.
Ask the question about the lease.
Oh, yeah, you have thank you. You have the answer. So the parking count is reliant on the size of the Dunkin' Donuts site, right? And your council's represented that you're going to be reducing the size of that establishment to stay under the required parking amount, right?
Yeah.
So my question is, if you have a standing lease, how can you remove that amount of floor space from the tenancy?
I have to check, but I don't believe the lease gives them a number of spots. It just gives them the opportunity.
No, not spots, space in the
Square
store.
footage?
Square footage in the store.
Oh, in the store.
See, because the way the zoning works is you measure the size of the store, and then you divide that by a number, and that tells you how many parking spaces, and you get to waive it if it's fewer than 15 spaces, right?
Originally, that site, they used to make their donuts and other products there. They stopped making it. Now they bring everything in, so
Right.
They don't really use a lot of their
Right.
square
So that's
footage.
the thing is, because it's just the measurement of the, what's known as the establishment, as opposed to, you can't exclude storage and so on. You need to reduce the size of that establishment physically, right?
Okay.
So your lease, this is the question, how can you actually accomplish that in the face of a lease with a tenant?
I'm sure we would have to lower their rent, and they would be amenable to
Yeah.
that, particularly when they're not using the square footage.
Okay, so that's something that you're unfortunately going to have to do.
We have to, yeah.
While we're looking at this, okay? So, and then the other question is about the tenant who is parking all the trucks. Who is that?
Yeah, unfortunately, that's my tenant, Grindstone, and I told them that they can't keep the trucks there. They told me they're looking for a space too, but that's my tenant in one of the stores. They do management.
That's the construction
Yeah,
management?
Yeah, but I told them they can't have it there.
Okay, so that's something that will be enforced, right? So you need
Yes.
to move those trucks off.
Yeah, they're gonna, I'm glad to have them as a tenant. I mean, like I said, it's a double-edged sword. It's so hard to rent. Retail throughout the city is bad, but in that area, it's the worst.
Yeah.
Retail is just...
Understood. Yeah, the problem with the trucks is you're in a residential district. And that's our issue, right? If this were a commercial district, it'd be a completely different thing. Okay. Okay,
Thank you
I
very
appreciate you coming.
Thank you.
Amanda, can you just put his name in? Thank you.
Sorry?
Appreciate it. Item number 9.
It's okay, she seems to have it. Okay, go ahead. Sorry.
Item number 9, 17193 BZ, 3245 75th Street, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Okay.
Okay. Okay, well, I'll say it after.
Good morning, Faye Baton from Sheldon Lobel PC for the applicant.
Before you begin, I just want to acknowledge what was just handed out to us, which we received yesterday. We have a new letter from Councilmember Drum opposing the application on the grounds that it didn't comply with our waiver requirements as to do with timely filings. This variance expired in 2014, and in response to Councilmember Drum's comments, it's true that I don't see in any of the submissions what we normally ask for, which is proof of continuous use since the expiration in 2014. And also, Councilmember correctly points out, because it's odd, we usually do pick all this stuff up, so that you also need to make a statement about substantial prejudice without the waiver of the rules. So you should respond to both of those issues.
All right, we will respond to that, and I think at one point, maybe in response to the notice of comments, this is off the top of my head right now, we did file for an amendment to modify the condition of the term as per the rules. I think we did file another filing fee check. I will have to double check that, but I will update the statement of facts to include substantial hardship, loss, and the proof of continued use will provide photographs as per many other applications. So we attended yesterday's review session. The first comment, I know this was a discussion, and this has been a continuous discussion regarding the community board resolution. Our office has reached out numerous times for the resolution. I actually rewatched their hearing on February 15th, 2018, and I know that one of their conditions was going to be to ensure that vehicles will not park on the sidewalk. So it passed. But I know we don't have a physical copy of that resolution.
And was it this one that you said that they wanted to hear from us in order to get something in writing? I didn't understand that.
So they said that our paralegal had reached out numerous times, and they said that the BSA would have to reach out. But at the last hearing, Tony had mentioned that she's reached out before and hasn't received it.
Still hasn't had anything. Okay.
I mean, it was
All
a
we
year
can
and
do
a
is
half ago,
ask.
so.
Right, okay.
Okay, we made a submission last night just some updated photographs to show that the sidewalks were in the process of being repaired and the signs were actually installed for the no parking. And we will provide for the next hearing, we'll provide full site photographs, but I just want to show those in the meantime that those were addressed. And regarding the plans, it was separated on purpose, the existing and proposed, because we wanted confirmation from the fire department regarding if they had any objections on the proposed site plan, and we received it today from DCI Daily. They don't object to the new plans, so we are going to remove the stackers in the meantime. The applicant does have already a proposal for that, so we'll do it before the next hearing.
Okay.
And I think the architect will try to make the signs a little bit larger on the plans. I know if you just really, really have to scroll in for those. It does say no parking. If you scroll in a lot, it does say no parking, but I'll see either he makes a note and points to the sign on the plans or just provides a larger elevation.
You're saying that little thing inside says no parking?
I checked yesterday. On the left side of the elevation, if you just scroll
in 1,000,000%.
Exactly. So the applicant is obviously taking measures. You see it?
It does, oh my God. So I'm curious, what size drawing gets printed?
I'm not sure, but I'll ask him to.
49 by 96.
I think the best solution is just have a separate drawing
Yeah,
which
right.
indicates the size of the sign. And
Yes,
that's it.
and what it says, yes. And calls them all out as sign type 3 or something like that. That's customary, actually.
So I'll make sure he does that. And I think those were most of the comments from yesterday.
Yes.
The applicant is moving forward as shown by the photographs in our submission. So now that we have approval from fire department to move forward regarding the stackers, maybe we would like a continued hearing, and we could provide all the photographs as well for a submission sometime in November, so maybe a December hearing.
Okay. Are there any speakers on that? Okay.
Oh, yes, council member.
Oh, did you want to speak? Oh, okay. Thank you for your letter. Okay, all right.
A submission on November 27th and a December 17th continued hearing.
Is there any way to do the December 10th hearing?
Sure.
Sorry.
Yes.
I realize I'm already here for that one.
A submission on November 20th with a continued hearing on December 10th.
Thank you.
Thank you.
28 or
20.
Item number 10, 13204 BZ, 310 East Houston Street, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond to city board member questions?
I hope Barbara's here. Take a break after this.
Good afternoon, Eugene Pillman for the applicant.
Okay.
We made a submission this morning.
We saw the submission, and I'm just going to first give it to Commissioner Otley Brown. Is Ms. Cohen here?
Ms. Cohen could not attend today.
Okay. So I'm going to give it to Commissioner Otley Brown to just ask the question again, and hopefully you can answer the question, okay?
So at the previous hearing, it came to light that you wanted to sell the development rights for Lot 40 as well as Lot 7503.
Yes.
So I had asked a question that was, could you tell me the breakdown of the available development rights for each lot? And then tell me whether or not any of those rights were in existence at the time of the grant. Because you were only accounting for 1,627 square feet at the time. So what I received was the breakdown into the two lots, with Lot 7503 having 8,405 square feet and Lot 40 having 2,829.4 square feet.
Today.
So what I need to know is only 1,627 square feet of that you had already added for the sale available at the time of the grant, or was there more of that available at the time of the grant? And if so, That's got to be valued in the financials as a sale.
And that was not what was
That's
stated
not
in
what
the
was
letter.
given.
Right, so this is how it breaks down. At the time of the grant, the site was in an R7-2 district. R7-2 districts permit a maximum FAR for a mixed-use building of 6.5 pursuant to 2411 if community facility bulk is used, and residential FAR depends on if it's a height factor building or a quality housing building. In a quality housing building, the permitted FAR is 4.0 in an R7-2 zone. The building was originally approved for 3.05 and subsequently built to a 3.35 FAR. Pursuant to height factor regulations, the max is 3.44, which is still in excess, so, you know.
Sorry, slow down. It was built at 3.35.
3.5. 3.35 residential and 4.6 total. So there was substantial, you know, other possible floor area that could have been captured, in particular, community facility floor area.
No, nobody sells community
Yeah.
facility floor area. Sorry, it's just not sold, right? How much was all of the available residential floor area used in the building
So-
at the time of the grant?
If we're using the height factor regulations based on the lot area of 7,901, it would be 27,179 square feet.
Say again, 7,901.
So the lot area is 7,901, and the maximum height factor residential FAR is 3.44, so that equals 27,179 square feet.
27,179 square feet, and when you talk about that, the 7,901 lot area is the entirety, including
Is
that little-
both lots, yes.
Both lots, okay. All right, and what was built was?
What was built was 26,441 square feet, which exceeds the approved residential floor area of 22,490 square feet in 2004.
Can you go back and repeat the number again?
Certainly. So the building was approved at 22,490 square feet, and it was built to a residential floor area of 26,441 square feet.
Which means that only 738 square feet was left over at the time of the variance.
Yes.
So then,
Wait, 22,490 is the number. It was approved at 22,490, right?
right, but then it was built to a higher amount. which
Even
was-
though we didn't approve it at the higher amount.
Right, but
Okay.
they did an analysis of what it was actually built to.
Oh, okay.
Right, the pro forma from 2004 was revised with the existing as-built condition because our position is that the excess floor area could not have been captured in this building due to the irregular lot shape and the sky exposure plane, which begins at 60 feet or the 6th floor. That's why the penthouse is partially set back from East Houston, and that's why an 8th floor could not be provided here due to the sky exposure plane.
So the thing I want clarified is, all that was left at the time of the grant or the time of building your building
Pursuant to the previous R7-2 zoning, right, is
was
a...
738 square feet.
Right.
That's it. For some reason, you've accounted for 1,627 square feet as being what was left over. So now the rest of the 11,234 square feet was added due to the upzoning.
The 2008 upzoning to R88, correct.
So I don't, being that what actually was left over at the time is actually less than what they valued as the sale, I don't need a new financial.
Hallelujah.
Yes, exactly. So that's all I wanted to know, because if it wasn't going to disturb the E-finding at 1,600 square feet, it certainly is not going to disturb the E-finding at less than half of that. So that's all I needed to know.
That's all she needed.
Yes.
That letter that was submitted didn't answer that question.
Did not.
In any form.
Our concern was that the board would, indicate that there was 15,000 square feet of community facility floor area that could have been transferred and ask us to value that, and we had some concerns that that
So this
would...
is the part where I made a comment yesterday that, if you're someone who works in the discipline of selling development rights, you know
Right, there's no sales of
this.
community facility now.
Nobody ever, unless it's, a house of worship, they don't pay much for them, buys community facility floor area.
No, to take it for your...
Actually, on the contrary, they merge and the developer pays them because they're not building any residential, and the developer pays them to not build any residential, and they get all the community facility floor area kind of for free. So,
The non-contextual districts, they do have a big community facility bonus, so
You don't
based on
get
the
to
lot
take it.
sizes around it, right, they couldn't max out anyways, probably.
but you don't get to benefit from it in a TDR sale, right?
Understood.
The bonus does you no good unless you're building a building with the community facility on it, and, yeah, okay. I think then we've answered the question, right? Okay, are there any speakers on this? All right. So I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition, we talked about this so long ago, probably no one remembers, that there shall be no conversion of the second floor community facility to residential permitted. And this decision supersedes the 2014 letter of substantial compliance, just to make that clear, okay?
Distinction, okay.
So on that motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Application's
Thank
been
you.
granted.
And now we'll take a 10-minute break, right?
All right.
Thank you.
Okay. Back on the record for the public hearing, September 17, 2019. New cases, item number 11, 22709BZ, 100-14 Roosevelt Avenue, Queens.
Members of the board, I handed up a handout that the applicant provided.
You did what? I'm sorry?
I provided a handout.
Yeah, oh, you provided the handout.
Well, they provided.
Oh, okay.
I facilitated the distribution of.
I raise your right hands. You have to too. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions?
I do.
Okay. Have a seat. Go ahead.
Good afternoon, Sandy Anagnostou representing the applicant, and I'm joined by Mr. And I'm joined by Mr. David Rosero, the property owner.
Just a second on the feedback, because otherwise we can't hear you.
Okay.
Go ahead, Sandy.
Try again.
Sandy Anagnostou representing the applicant, and I'm joined by Mr. David Rosero, the property owner. My office made a submission earlier this morning, and I provided some of the documents that were in that submission, which address the issues that were raised at yesterday's executive's review session. One of the questions that was raised is, why are we here since the site was part of a rezoning application, which was approved back in 2013? Well, under the original variance, the board approved a two-story commercial building, and that configuration doesn't exactly meet the C14 zoning district regulations, which is the current zoning of this site. When we were previously at the board, the site was zoned R6B. One of the items that was requested yesterday was the City Planning Commission report for this rezoning application, C-13344ZMQ, and I did not print the entire document, although it was submitted. I just, if you refer to page 7, 7B refers to the area which includes the subject site.
So it's describing how you go on Roosevelt Avenue, 8th
Yes,
Street.
and it's bounded, the site is bounded by Spruce Avenue, which is a street in use, but it's not on the final map. It's bounded by Roosevelt Avenue and 102nd Street. Also, I provided the zoning map, the current zoning map, which shows the
the site with a C14 commercial overlay. You have to really zoom in to see it because the site is so small. But if you do zoom in, like on your, in the PDF on the computer, you could definitely see it. I also provided the map at the time when the rezoning became effective.
Oh, you
on
found the one with the little
October,
dots, okay.
was it October 30th, 2013, and it shows the dots which do surround
Great.
the triangular
Oh,
site.
thank you.
And I also blew up on the last page of this handout, the sketch is also included for the proposed rezoning, but I kind of zoomed in and printed out the site, and you can see it was definitely included.
Great, thank you. So it really was a zoning change in 2013, not 15?
2013, yes. So besides the building department issuing an objection that we should refer back to the BSA, because under the prior grant, a condition was put into the resolution that substantial construction should be done in accordance with Section 7223 within 4 years. We also have the issue with the second story of the existing commercial building. Since this site is located, well, you could look at the survey. It's located 109.74 feet away from 102nd Street. In accordance with Section 3326, we would have to provide a yard of 20 feet on the second story, because we're allowed to have a permitted obstruction according to 3323 of 1 story, but not more than 23 feet above curb level. So the configuration that was approved under the prior grant, it was approved, it was built, but it doesn't exactly conform to a C14 for this reason. And therefore, we still require to have a variance. It's
So,
not.
okay, that's the question. So, sorry, I need to get to the drawing again.
And that's really the only issue, because we're under the maximum allowable floor area is 1,672.86, and we're 1,509.85. Lot coverage, this is a commercial building, but in that zone, it's 80% lot coverage. We're a little bit over 85.76 square feet.
Okay, so I'm just trying to understand that, because you didn't give us a zoning analysis so that we could understand what the C1 regulations require. So you're saying that?
If you refer back to the zoning that was on the BSA approved plans, there's a zoning analysis, there are calculations as if C14 zone, closest commercial zone at that time, because our property was zoned R6B, it does state that required rear yard in accordance with Section 3326 ZR, 20 feet.
Where's your rear yard, though? You're within 100 feet of a corner.
We're more than 100 feet.
109.
Right.
So that 9 feet.
Yeah, so required rear yard under 3326 is 20 feet after first story at 23 foot high. That was in the previously approved plan.
So you need to speak up, because that was
sorry.
very private comment.
Sorry, I thought, as part of the approved plan, it says a required rear yard per section, zoning resolution section 3326 is 20 feet after the first story, or 23 foot height, whichever is less. And so I guess that is what you're referring to in this case.
Yes.
It would still not meet that requirement because you have built, you haven't provided that setback.
No, and we can't, because the building is completed.
Now, understood that you can. So I'm, of course, interested in you not having to be here for a variance at all, so that, you know, your client can go off on his merry way and be as of right. So, but just want to make sure that there's no kind of waiver in a situation, or not a waiver, where it doesn't apply where you have a block frontage that's less than X, right? Because there are those where the block frontage is less than this, then rear yard regulations don't apply, those kinds of things. So, so in a C, special provisions for shallow interior, special provisions for rear yards, rear yards along district boundary. Other special provisions, so many special provisions. Multiple rear yard lines. Rear yards.
Minimum required rear yard.
Yeah, so that's the thing I just want to make sure, and I didn't realize it was the rear yard issue.
That's
And
the
so-
only,
But because, you know, it's a very short lot, right? And there is here we go, along short dimension of block. That's,
You're looking at 33261?
I'm just looking, yeah, 261. It says, rear yard with shall be provided at every rear lot line. Shallow interior. This is a through lot.
Yeah.
Or 33.
It's a through lot.
30. This is a through lot, right? So through lots. Accepted districts. Accepted through lots. In the districts indicated, no rear yard shall apply to any through lots which extend less than 110 feet in maximum depth from street to street.
And special provision for through lots says, in the district as indicated, the regulations of this section shall apply to all through lots in the case of the zoning lot occupying the entire block, which it is not the case.
So doesn't this other one work? No rear yard shall apply to any through lots which extend less than 110 feet in maximum depth from street to street.
It is less than 110.
It's a little skinny lot. It's a through lot that extends 20 feet on a good day from street to street.
Yeah.
And you could look at
And
it
on
as
any dimension, right, so you're looking from the spruce and the
Spruce to Roosevelt.
Roosevelt is
And if you
less,
say that, you could say the first 100 feet, I don't quite understand these drawings, but anyway, the first 100 feet is the corner lot, and then after that, you have a through lot, and the through lot extends less than 110 feet from street to street. So I don't think, frankly, you need this waiver. I mean, I don't think you need this
variance anymore.
anymore. And if you want to just preserve it for a minute and go to DOB and just present that, I think you could abandon your variance, and then life is so much simpler when you're not married to the BSA.
Well, the building department referred us to the BSA.
No, I know, but you
so-
didn't make that argument, right? And they may not have noted it, and why they referred you, I'm not sure, other than, not sure, right?
is it because Spruce Street is not a map street, that's why they're not counting it as a through street?
It's not on the city final map. It's opened, it's in use, but if you look at the survey, and it's not mapped on the city final map, so.
But then, It's not mapped, but it's a CCO street. We don't know. Does it have an opinion? What does it say in the survey?
July 1st, 1978.
So isn't that the definition of a street, that it is recognized as a street? So definition of street.
It's not a through street. If you look at the survey, the site is not a through street. There's like this funny thing, because if this is Spruce Street.
But Spruce does go through.
The site is only up to, there's a distance of 12 feet or.
No, that's a sidewalk. What is that? That's a sidewalk.
That's a sidewalk, and there's dirt road down there. It's like dirt and unfinished.
You see, there's two different things. There's the unmapped on city final map dash line, and then there's this thing called Spruce Avenue that has easement title, CCO, Corp Council opinion. It does go through. This one.
No, right, that is.
Yeah, so there's two overlapping, a dash line that indicates some old easement, that's an easement.
Yes.
And then the Spruce Avenue. So I would say, though, that the cleanest thing to do is to go to DOB and say, we don't think that the rear yard regulations apply to us because we're a through lot that's less than 110 feet and a corner lot where you never have to have a rear yard. Right?
Within 100 feet, yeah.
Within 100 feet, and go to them, and then make sure they're good with it, in which case then you can actually abandon the variance, because I don't see any reason why you need that, right?
Should we grant it now and let them go back to DOB and clean it up, and then they can send a letter to abandon it?
No, because that's not the...
The whole, the problem is time.
No, I understand time, but you still need to go to DOB anyway, right?
Well, because Mr. Rosero has a deadline for his tax abatement, July 9th is the deadline.
July 9th?
I'm sorry, December 9th, December 9th.
December 9th. So how about this? You need to do what by December 9th?
Obtain at least a temporary C of O.
So you already have to go to DOB. So we can put, if you go to DOB, for instance, this week, we could put you on for a continued hearing in case of the need to extend this quickly.
Okay.
But it would be much easier
As long as
for
we
you-
can come back to you
Yes.
quickly, fine.
Because it'll be much easier for you if
Sure.
you never more have to come to the BSA, because you're going to have this problem constantly.
I agree.
Right?
Thank you for pointing that out.
Okay.
As far as the building, it's completed. Right now, we're in the process of the contractor and other obtaining sign-offs and scheduling inspections for all the work types, so that we could at least be able to obtain the TCO before this December deadline. I also submitted a letter from Rothkrug Inspector, which explains the time-sensitive issue regarding the tax abatement.
Understood. Okay. So we're conscious of the timing, but I think the right thing to do is to make sure that you actually have to be here at all. So if you can arrange for kind of a quick review by DOB. Just on that question, I don't think there's anything else. There's no lot coverage for commercial. There's no community facility located in this building, right? No residential located in the building.
No.
So you don't have a lot coverage issue. Yeah, it seems like was it DOB who pointed out the rear yard?
It was well, yes, and it was also part of the original variance.
But we didn't waive the rear yard here because it was a use waiver, in which event we don't look at the bulk for a non-permitted use.
But the board approved that configuration on the second floor, that size, because of this small and uniquely shaped
Right,
lot.
but the point being that the board recognized it was an odd-shaped small lot, right? That was the hardship. And the question was, what can we put here? Residential doesn't work here. Community facility doesn't work here. go build commercial, right? But once you just have a use waiver, the board doesn't look at waiving bulk because the use isn't even permitted, so there
Right.
isn't any bulk to go by,
Yeah, there's
right?
no commercial bulk in a residential district.
So the board didn't waive yard regulations or anything. It just waived the use, and then from there it and that's the way the DOB looks at it also. Once use is waived, the bulk is determined by the board.
Right.
And it's not restricted by whatever the use regulation, the bulk regulations are in some other unrelated district, because this was in an R district,
Yes.
right? So, yeah, so DOB is incorrect that we waived the yard. And in any event, I'm not sure that yard regulation applies to this site. It may have applied generally in a C1, but not to this site.
So, Madam Chair, what was that section you were through lots?
33-282.
282, okay.
Yeah, accepted through lots. That applies to a C1.
Or C14.
Right. It just generally C1s, all C1s this applies to. Okay. So we can put this on quickly. I think 2 weeks is enough for you to meet with DOB?
We're gonna have to, yes.
Okay, I mean, you have to get the appointment, right?
So submission date on October 2nd with an October 22nd continued hearing.
Or maybe we can do this
I think we
earlier for
can-
them.
And we probably don't need such a long submission period on this one.
We don't need to look at anything. It's just,
Yeah.
do they need to provide a yard or don't they? Right? That's just the answer, and then we go on. So we could put this on for October 3rd.
Okay, October 3rd with a submission on,
It could be the Friday before.
okay, the Friday before.
October 3rd hearing, submission.
On October 1st, which is a Tuesday, because October 3rd is a
Which
Thursday.
actually makes it a little better for you. You have another couple of days to get DOB's attention.
Okay, thank you.
Okay, thank you very much. Thank you for the submission, super helpful.
You don't need to. Item number 12, 216 13BZ, 750 Barclay Avenue, Staten Island. Yes, by yourself? Okay. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions? I do. Okay.
Good afternoon, Chair and Commissioners. Philip L. Rampula. We reviewed the tape from yesterday's executive session, and with the help of BSA staff, I've obtained a sample of the construction timeline that you requested at yesterday's hearing, and we can have that done in a week's time.
Okay, great.
I'm hoping for a submission date of the 8th and a continued decision on the 22nd.
Just a second, are there any speakers on this? I don't know, so that one has a very strict deadline, right? The one we just heard, deadline about finances and so on. And we have a very packed schedule, so I'm not sure how do we do it. You said you could get it to us in a week?
I can.
All right, submission October 30th for a continued hearing on November 19th.
November 19th.
19.
Yeah,
Okay, thank you.
Item number 13, 2018 125A, 495 Wild Avenue, Staten Island.
We're just
Reopening?
Opening this, yeah. So a motion to open, reopen.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
And we're just accepting a letter from DEP that was missing from the records, which consider it accepted, do we have it?
And it's
Yes.
a letter of no objection.
And it's a letter of no objection, okay, which is what we want. Okay, so then, motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And the vote. We have to do a vote?
Yes.
Um,
I thought this was
do we
ready.
have to vote?
Yes. Do we have to
Just
re-vote on
accept
this?
and close, we have to, what do we have to vote on? We already voted.
Yeah.
We're just opening the record to receive an
Okay, I'm
object
sorry.
and closing, that's all, right?
Item, appeals calendar, item number 14, decision item 14, 20515A through 21415A, 12860 to 12876, you don't have to be sworn in. 76 Hook Creek Boulevard and 12863 to 12875 Fortune Way, Queens.
Hi, good afternoon. Todd Dale for the applicant. We had just submitted a letter requesting withdrawal with leave to file again once we resolve the underlying issues.
Absolutely, so yeah, just carefully go through it and decide what the project should be. You heard all of our comments already, we're happy to receive a new application.
We are very aware of the comments, and we will make sure that the owner understands.
Okay, because you could do it in one hearing the next time. All right. So our motion to withdraw?
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Item number 15, 2017-202A, 43 Cunard Street, Brooklyn, Cunard Avenue, Staten Island. I apologize.
Is anyone here for this, or just?
No, it's an adjournment request.
Yeah, so it's an adjournment request, and they're working with city planning on what alternate might work. So they asked for 6 months, which is fine.
6 months.
Did they ask you 6 months?
So, March 24th with a submission on Wednesday, March 4th.
Wow, okay. Item number 16, 2019 1A through 2019 5A, 7, 11, 15, 19, 23 Nello Court, Staten Island. Just sign in here. You don't have to be sworn in. Thanks.
Good afternoon, everyone. Joel
Raise the mic,
Locasano.
Mr. Locasano.
Yeah, please speak up, it's hard to hear you.
State your
Okay.
name.
Joel Locasano for the applicant. I've had an opportunity to review the tape from executive session. I'd like to reply to some of those comments. With regard to the 7 proposed lots that were possible, I did explore a preliminary design which involved 7 lots. In order to achieve it, it was necessary to do one zoning lot with individual tax lots. The proposal involved 3 homes across the back, plus 2 homes up each side of the property with a T-shaped road running up the middle and then across the houses in the back. What it yielded was a very small footprint for the home, really an impractical footprint for the home. So that concept was abandoned. I then pursued a 6-lot subdivision for the home, for the property. That involved, again, 1 zoning lot, separate tax lots, with 3 homes running up each side of the property and a roadway up the middle. These homes could be 3 stories, so the footprint would be the same as it was for, say, the 7-lot subdivision, but it would gain an additional 3rd floor because there was lot area there for 6 3-family homes in South Richmond.
So 3-family homes are also a possibility
I'm sorry,
here.
3-story.
3-story, okay.
Yeah. Again, this was, I felt out of context with the neighborhood, so I then went on to the 5-lot subdivision, which you have before you. It includes 5 zoning lots. The houses proposed are approximately 2,500 square feet, in context with both the neighborhood and R3X zoning, which would permit a 40 by 100 or 3,800 square foot lot. And this would yield approximately 70% of the floor area permitted for the overall lot. If 3 as-of-right lots were constructed fronting Sprague Avenue, and I used an equal amount of floor area as the 5 I proposed, these houses would be approximately 4,000 to 4,100 square feet each. But more importantly is the footprint that they would take up would be out of context and would represent a poor design for the home. I had submitted...
Sorry, just a question about that. Isn't that more like you would choose to take 4,000 square feet and you would have a house with 4,000 square feet?
Yes.
And you would choose to have a footprint of a size that you are arguing would be out of context? You don't have to build those.
You're right. I did that to show a comparison to what was originally proposed to the board. If I had gone with 3 houses of similar size to the ones in the 5-lot subdivision, that would represent 7,500 square feet out of the available lot area permitted to be developed, and that's approximately 42%, leaving almost 60% on the table to be undeveloped. So I felt that that was a hardship in and of itself.
But, you know, if we talk about hardship, there are many, many lots in New York City that never get to use all of their floor area. I just use as an example houses in historic districts where the floor area ratio is 10, but there are houses and they can't possibly ever expand their houses to use up the 10 FAR. They may have 4 or something like that. So it doesn't mean that automatically you get to, under any rule, use up all your floor area. It's very, very common that you leave floor area on the table due to height regulations in a lot of places. For instance, there are limited height districts where you can't go higher than X, but your lot area permits you to have a much larger amount of, much more floor area, but you're limited by the height. So it's not a right to use up all the floor area.
Well, for example, if these lots were 40 by 100s fronting on the street, you would be able to develop 100% of your permitted floor area. Now,
Sorry, say that again.
If they were, say, 40 by 100s, a typical lot in an R3X zone, all fronting a map street, you'd be permitted to use up 100% of your floor area. Permitted in an R3X zone because the FAR is considerably lower than it is in, say, a district in Manhattan.
Okay, but we're not just talking about Manhattan, we can talk about lots of other places, but for instance, if you had a very long lot, right? And you wanted to build a house that was taller than what's allowed in the given district, like there's a 35-foot height maximum. That's common in a lot of low-density districts. You wouldn't be able to use it. You have the floor area, but you wouldn't be able to use it because you have a height maximum. So
I think I do have a little bit of a disagreement here on this one, is that the applicant is indicating that if they were to build this site similar in the context of the homes that are built in the cul-de-sac, they would be leaving 60% of floor area undeveloped, which is not a very typical thing. Even the zoning resolution, when written, contemplated that more than 50% of floor area would be left undeveloped, whether one used height factor or a quality housing or anything. So this is a significant leftover of floor area that is being that's not being allowed to be built. And I don't think anywhere in the zoning resolution even one puts in the most conservative estimates of all the zoning regulation, will result in that much of leftover floor area in an as-of-right situation. So I do think this is a reasonable hardship, and even what is being proposed does result in not 100% built out. It does result in some floor area being left over, and that is somewhat, that's even less than what the zoning resolution would allow. Typically, we would look for, 80, 90%, and here they're leaving about 70% of floor area being built, so 30% is being left unbuilt. I think this is very reasonable, and as I've said, in terms of, I know, the city planning has reviewed this plan. The subdivision of this is very much, has been reviewed in the context of the neighborhood. This fits the building shapes and the sizes and the heights. They totally configure with the neighborhood, and it is a mishmash, but they have picked the most predominant one. And the subdivision has been approved by city planning, so the layout of the configuration is in keeping with the context.
But I just want to add to that the choice of how much floor area to put in these houses is a choice, right? So you don't have to build the 2,500 square foot house, you can build the 3,000 square foot house, so then you're leaving less floor area on the table in the as-of-right. How much floor area you use is your choice as a developer. You could use up all of it as a developer because the lot is deep, so there's room to put all of the floor area on the lot. If you choose not to build it as big, because the argument is the market isn't interested in such large houses, that's a different question. But as we talked about before, the market was interested in large houses on Sprague Court. So I don't understand why it's not interested in it now, and what we see in lots of other neighborhoods is a huge interest in larger houses.
It has to do with the configuration of the lots on Sprague Court. They're very wide. Those lots, when built, were all septic lots, and they had to have a minimum 100 feet of frontage along the street. So therefore, what you get is a large home that's very wide. That's, in essence, that's what people want. They would not want the same square footage in a very narrow home that's very long.
Well, so
there's
that
sort
part's
of a fine-
confusing.
There's a fine line between,
Right.
like, what is permitted on the lot and what is actually saleable to the general public. And I think once you cross that, say, 3,000 square foot mark with a home that's deeper, that is deeper than it is wider, you're getting into very muddy waters. There's really not a market for that. The homes on Sprague Avenue that are on deep lots, those houses are much smaller because they were all septic at one time. Even the ones that are 40 by 100, they predated the requirements for septics. So that's why they are of the size that they are. Other lots which are, there's I think 2 of them that front Sprague Avenue that are greater than 100. They're about 120 to 150. There are 2 of them. Those have large houses because at the time you can build wide. There was a market for it, and they, quite frankly, didn't have a choice. You needed 100 feet of frontage, so they could not subdivide their property into 40 by 100s.
So I don't understand what you mean by septic lots.
The requirements went into effect which required a home that does not have a sewer must have 100 feet of frontage and 10,000 square feet of lot area.
So then...
Now, if you had a lot that existed prior to that regulation going into play, you were permitted to develop it and put a septic on that lot. So many of these lots on Sprague Avenue were like that. They were 40 by 100, 30 by 100, and believe it or not, they had septics on them.
And what about the 3 buildings that were there previously that were demolished?
Septic.
So I don't understand. So today, what are you required to do?
If there are no sewers, you must have 100 feet of frontage.
But you created this situation by demolishing the 3.
We have sewers.
So you said, if you have 100 feet of frontage, you must have your own septic. Is that what you just said?
It's the other way around.
No, I'm saying if you wanted to develop the lot before the sewers came in.
Oh, but now you have sewers.
Correct.
Right.
So we're permitted to go 40 feet in width.
Okay, isn't that an advantage?
Yes, it is. It increases the value of the land.
Okay.
Okay,
So what we've done is the property has the development area for theoretically 7 lots, according to the regulations and zoning, 3,800 square feet, and 40 feet of frontage if I go with a private road.
So I hate to interrupt.
Speak up.
That isn't an argument for hardship. But before we even get to hardship, my bigger problem is your lots are fronting. I don't see how when you have, if you take, if the GCL 36 is for a lot that's not fronting, how do we get to a waiver when you control the frontage and you have frontage, substantial frontage?
Okay. In the GCL 36, as you know, there are 2 conditions. One is for cities over $1 million, and one is for those under. In New York State, there are over 1,500 cities. There's only one over $1 million. So basically, you have New York City and you have everybody else.
Correct.
For the ones under $1 million, they talk about an area variance. An area variance is much, much more flexible than, say, a use variance. What you have to do is just show that the benefit to the applicant does not outweigh the detriment, health, safety, and welfare of the community. Well, we don't have that requirement in cities over $1 million or $1 million and over. Not at yesterday's review session, but at the one prior, you were all discussing, like, what do we ask for now with these cases? And you had a difficult time in determining what to ask for.
Correct.
So imagine, as the applicant, the difficulty in responding to that. I mean, I tried to respond to the comments that were being kicked around at the time, and I think I have demonstrated that there is a form of a hardship here. But keep in mind, the Sprague Avenue, in that direction, the block is 900 feet deep. That's very unusual.
But that's hardship is what you get when you with the argument you can make once this statute applies, once they're, like, it's more of a threshold question or a jurisdictional question, you have frontage.
Yes.
Right, but I think the GCL 36 waiver doesn't have to do with the lot frontage, but rather the building perimeter. You have to have at least 8% of the total perimeter of the building fronting on a map street. It doesn't speak to the lot, it speaks to the building.
Okay, and there were 3 buildings there that were demolished, and now to say I don't have frontage and I have a hardship, I find that to be a difficult argument.
There were 2 homes and a detached garage. One of those was a detached.
But I think it's true that at the last hearing, because the subject, as you are aware, you're sort of caught in this time period where the board is looking at these GCL waivers in a different way than it did previously, and trying to hang on the text of the GCL 36, the actual text, and not having adequate direction from the text, which says, look at this as you would a waiver of zoning regulations, which we don't kind of have unless we switch to the zoning resolution of 7221, and we don't want to apply that same set of criteria because that means submitting financial analyses. It's a very, very elaborate, expensive process that we don't want these GCLs to go down. So we suggested in searching that maybe you use the area variance concept, which is 81B of the general city law. But the first part of it is, so the findings are that it's not going to be a detriment to the community, and the advantages outweigh the disadvantages, right? But the first finding is that there is actually a hardship, right? So, and that's the part that I'm having trouble with, because it is true that you can be developing on this site 3 complying houses that use up either all at your choice or most of the floor area. And the other reason that this idea of the long, narrow house is confusing to me is we see it's probably hundreds of houses that are long and narrow, where they're asking for one FAR, they're asking for an 8,000 square foot house that's long and narrow. And true, it's not as desirable as a big box, but it seems like the square footage is what a lot of people with big families are looking for. And in this case, you're allowed to have a two-family, so it's an opportunity to make quite a significant sized house that gives some real area to the people who are living in it, real
Okay,
space.
I don't know where those homes are located, but on this section of Staten Island, and you can see from the diagram I provided, that's not typical, that's really the anomaly. On the drawing 103 that I gave you, it has an overlay of those 3 homes. What it doesn't have are the dimensions. So I had prepared a sketch when I was doing that overlay, and the homes would be well over 80 feet in depth. And that's difficult to come up with a good design. You would be much better off with a wide house.
Sure.
Right, and narrow in depth. So it becomes a marketability problem. So to do 3 houses of that size would not really be feasible. If we were to reduce the size of those homes to something more in context with an R3X, then you'd be leaving 60% of the floor area available on the table. And that's where I feel that there is in fact a hardship. I prepared the revised findings in context with an area variance because I really didn't know what else to do to try and comply. And I think if you look at what the requirements are for an area variance, they're much, much more flexible than a use variance. So basically, if you were, and forgive me, but I live in Jersey and I'm more familiar with the planning boards over there, if you were to come in with something requiring an area variance, it's because you want to cluster the homes and come up with a better design. And that's similar to what I'm doing here.
Right.
And why I feel it meets an area variance.
So, and that's part of the problem is in New Jersey where you go to local planning boards for this. They're the local planning board. They're not the Board of Standards and Appeals, right? No. They're not the Board of Appeals that you go to the local planning board. And I think the trouble that a lot of us on the board are having with these GCL waivers is that because we're not the local planning board, we're being put in the position of planning. And I don't think, and that's my personal opinion, is that that's not what we were created for. We were created to give waivers when there really is a hardship, and not hand them out kind of indiscriminately, but really carefully. And that's the issue about the GCL 36s, where they were handed out without analysis. And so now we're trying to really analyze the question of hardship, and that's the issue. But I actually want to say that, given that this is the first time that I've seen you anyway appear before the board, you did a very good job in trying to make an argument. But the question is whether you persuaded enough people on the board with the argument, I think, is the issue.
Well, I'm not sure what else I can provide to you to persuade you.
Thank you. Okay.
One other thing, if you don't mind, just so you know that I did look into it. You had mentioned the court case with Brock, I believe. I did look into that, and I didn't mention it in the findings because I didn't find it relevant. That was on a 16-foot wide driveway, in essence, that provided access to homes. The fire department had an issue with it, concerns about public health and safety and responding to emergencies, which I totally agree with. The board voted it down for the same reason, and there was also an opportunity to gain access to that property from an alternate location, which I don't have that luxury here.
You don't.
You're creating, by the way you're designing this.
Commissioner, could you lean forward towards your mic?
The way you're designing it is the reason why you need the GCL 36. So the question in Brock was whether or not the lots or the lots had potential frontage through an adjoining lot that was mapped.
Right, and it did.
And it did.
So I felt that that wasn't relevant to this particular case because I only have the one location to access my property from, which is Sprague Avenue. And the fact that it is deeper than it is wider, that's why I feel that there is a hardship.
So I'm just looking at the area variance rules. So one of them is whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties. So in this situation, if we just look at the area variance, not that it applies in this case, right? You could say, no, you do see other layouts like this one in the neighborhood because the board has allowed other GCLs like that. Probably. Or maybe it wasn't done, it might have been done through the buildings department, which at a certain point was also allowing them
I
as of right.
think Sprague Court went to the board.
Okay, Sprague Court, okay.
Yeah.
But I mean, a similar situation like this where you have houses stacked very closely on one little route, right? But then the other one is whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. And that's the one that I find isn't met here, because there is a feasible method of achieving development on the site, which is, usually a variance is because you can achieve. So that's the part. And whether the alleged difficulty was self-created, this one is, again, maybe, the problem complained of is odd because you have frontage. This isn't a site that's a flag-shaped lot with 20 feet of frontage and 20,000 square feet behind it, right? So it's really not the same sort of situation. I think that's the main problem with this for me.
Okay, you do have a very deep lot, and that's where I feel that, it's not self-created. We cannot take advantage of the development rights of the property with 3 homes fronting on Sprague Avenue.
But again, at least 11 other sites on Sprague have the same lot depth and the same similar, if not narrower, lot width. So
Right, I did look at those. Those are developed with homes that are 1,500 square feet, like I said, other than the ones that are unusually wide.
But they could be enlarged, for instance. They're old homes, they could be enlarged.
There could be a house
They could.
behind a house.
They'd be very narrow, and that would be an undesirable condition.
Well, there's a 303 Sprague is a similar lot.
Where is that in relation?
It's about 200 feet north of you.
Yeah, there are a few that are the same width and a few that are narrower, but you don't have to just stay on Sprague. You can pull out and see others around the corner that are also similarly long and narrow. So it's a typical lot size or lot depth in this area, just like there are other kinds of typicals. I mean, you have a lot of variety here, and I think that's, for me, what is... Okay, so I think we've discussed this fully.
Add one thing. If we're looking at it, not that this is an area variance, but I think it'd be important to also note the community board's recommendation on this issue, and they're one of a great source to tell us how the character of the community would be affected if we were looking at it as an area variance, which I don't believe we are here.
Right. And the community
Board voted against it.
Okay.
May I touch on that?
Yes.
I was at the land use hearing for that, and they voted unanimously to approve it. They were actually in favor of my design because you have parking for both the main house owner and the tenant, and they don't conflict with each other. Unfortunately, what happened is when it went to the general meeting for a vote, the chairman, who is the president of his homeowners association and has difficulty collecting funds, bullied the other members into voting against it because he felt that an HOA has no teeth.
That what has no?
An HOA has no teeth.
But that's a problem too. So that's the other thing we're confronted with.
Well, these are only 5 lots, and what you would be paying into the fund for would be snow removal and lighting.
So we also have a lot of trouble with the HOAs. They vanish. People don't seem to know that the city doesn't own that street, et cetera, and then people call up the Department of Sanitation, how come you didn't plow my street? And sanitation says it's not ours, and so then there's a big fight. We see this all the time,
sure you do,
unfortunately. So
HOAs
the
can be
community
altered,
board
though,
member.
to give them more teeth.
Sorry?
They could be altered. The HOA could be,
Well, we don't know how to alter them because the HOAs are formed by the developer, and then the developer just kind of hands it over to the purchasers, and then the purchasers are required to enforce these HOAs, which they don't. And so they just sort of vanish into the ether, and we've seen that quite a lot. And unless there was an attorney general involvement in these HOAs in a way that enforces them, I actually don't know how to get around the reality that we've seen with many, many property owners having no idea that the street that they live on isn't a street.
one of the things I think you can do is have a managing agency be in charge of the HOA and collecting funds.
Right.
This way there's money there.
So, that's something to talk about with developers in Staten Island, but we can't manage the managing agency, so here we are. So, for example, in a mapping action, city planning actually requires all kinds of things be provided, restrictive declarations and all kinds of things to require the developer to do what it demands, but we're not in any kind of position to manage that kind of thing here. So that's part of our other problem with these GCL waivers.
Well,
But I think
as part of an
that,
approval, can you add that to the resolution?
so that's the problem. We don't have enforcement capabilities here, so they need to be self-enforcing, and that's our problem, that they haven't been self-enforcing. But I do think we've talked about this a lot. Are there any other speakers on this? Okay, and I think we can, we have the opinions of the various board members, so let's just close this. Motion.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
And the
And
vote?
I don't think there's any other additional material to review, so I just want to bring it to a vote for a motion to grant the request.
Chair Promoter?
No.
Vice Chair Chanda?
Yes.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
No.
Commissioner Shabeta?
No.
The appeal is denied.
Thank you. Thank you for your good work, though.
New cases, item number 17, 250-14A, 253-14A to 257-14A, 5041, 5300, 5310 Grosvenor Avenue, and 5041, 5030, 5040 Goodrich Avenue, the Bronx. Just come and sign, you don't have to be sworn in. Wait. This one. Let's see, what number is this? 17. Here we go.
Good afternoon, Richard Lobel of Shud Lobel PC for the applicant. I'm joined by Frank Noriega from my office. Commissioners, we have an amendment to an existing vested rights application. This application was granted by the board in 2015. This was a common law vested rights application pursuant to BSA Rule 1.0601F. This is an amendment of that vested rights determination. Extremely brief retelling of the facts is that this application derives from a Plan 15 unit development. This was originally brought to city planning for a SNAD special permit and other authorizations and certifications in 2001. At the time, it was approved by city planning but rejected by the council. At that point, the applicant had an option called the as-of-right option in order to build in accordance with as-of-right laws without benefit of the SNAD. They did so and began that process, were permitted, and construction began in December 2004. In February 2005, the zoning resolution was amended to remove that as-of-right option, so the permits were rendered invalid by change in law. And so the applicant at that time, in February 2005, actually filed for an 11331 vested rights case. This would allow DOB at the time to provide for a 2-year continuation of the permits in order to complete or move towards completion of construction. There was no opposition by DOB at the time. Deputy Counsel Felicia Miller decided and issued correspondence to that effect. So the 2 years passed, and then over the course of the next 7 years, the board actually granted repeated statutory vested rights applications in the form of 11332 applications. So these were granted for 3 2-year terms for a total of 6 years. There was one additional 1-year term. And so after 7 years, come now 2014, the development was not yet completed. And so in 2014, the applicant came before this board, and I know that Chair Perlmutter was here at the time, and applied for a common law vested rights application. The common law vested rights provisions basically allow for a more liberal granting of the vested rights. They do not require an applicant to satisfy statutory terms, but are generally governed by important constitutionally vested property rights. And the findings for those property rights and for those vested rights are essentially 3. There is substantial construction. Substantial construction was done on the development pursuant to those permits that were valid at the time, that there were substantial expenditures made by the applicant, and that this was done pursuant to valid permits. There is also, in certain cases, a discussion of serious loss that would occur in the absence of the grant of vested rights. And in 2015, the board did grant those common law vested rights to the applicant here to allow for continuation pursuant to a 4-year vested term. So really, what do we know about this type of vested rights grant? There are many cases in the courts where no term has been granted for a common law vested rights case. They basically just accrue to the owner and they can continue work. The board, at certain points in its history, chose not to grant chose not to impose a term, but more recently has imposed a term. So that's why the 4-year term was imposed in 2015 through June 2nd, 2019. And so now the applicant has now applied in April of 2019, made an application to the board for continuation of the vested rights here. We've submitted materials with regards to the central findings. It would be our opinion that the vested rights that accrued are still valid vested rights, that there's been no action by the applicant which would deem them to be abandoned, or that any recoupment would have occurred which would have terminated their rights. They've continued construction at the site. Of the 8 sites that were the subject of the 2019 vested rights grant, 2 of those have been granted C of Os. And of the remaining 6 sites, 4 of those have basically completed construction and are awaiting CO. One of those is substantially constructed, and the other one is a vacant site. And so we now come to the board. We feel that, again, we've...
So, sorry, is there only 1 vacant site left? Because our list was 2 vacant sites.
That's, Chair, I believe that there was an error in our materials. It turns out that I think it's 2300 Grosvenor is actually constructed and the frame is up, so we can correct the record and submit that material.
Sorry, which number?
5300?
I'm sorry, 5300, correct.
5300 is constructed.
Correct, and we have photographs.
You don't have a C of O, though?
No,
No, but as of the original submission, it was to begin construction in May.
Correct.
Oh, so
That was 5310, was to
yeah.
both of them.
Yes, in our statement of facts, my name's Frank Noriega from Sheldon Nobel. Yes, in our statement of facts, when we originally submitted back in April, we made the statement that we were going to begin construction in May for the 2 sites, 5300 and 5310. When we resubmitted to address the financial issues that were raised in the notice of comments, we overlooked that statement. But in 5300, we did start construction, and we can provide those photographs. 5310 has not started construction yet, but we plan to as soon as possible.
Okay, do you know the state of construction of 5300?
Most of the frame, we'd have to follow up. We have photos of the frame. We can certainly submit these, but as far as percentage.
Framed and sheathed.
Yeah, it's not
framed and sheathed.
extensive, but the frame is up.
Okay.
So.
And 5310 has not started?
Correct.
And do we know when that's going to start?
As this application is currently pending before the board, immediately after the board's grant, we would begin construction.
Okay.
So to reiterate the findings with regards to substantial construction, essentially the construction at the site has continued since 2015 and since that time, as of 2015, I believe that there was significant progress made on the homes. Since that time now, we have these additional lots which have been developed. Substantial construction, while there's no bright line test that's submitted in the New York State cases, it basically is that it would be inequitable to prevent the applicant from proceeding, that a new physical framework has been imposed on the site, and here it's clear, particularly given the fact that these lots are basically together in a planned development.
Right, so I just want to clarify.
Sure.
So the statement that we had before indicated that there were, of all of the sites, only 2 of them at the time were waiting to start. Everything else was in some version of almost complete, or completed with a CO, or completed with no CO.
Correct.
So there were only 2 sites that remained, and now one site is fully framed and sheathed with a building that's basically used up its floor area, right,
Correct.
which is the issue.
Correct.
And lot coverage and so on. So now you only have 1 left.
Correct.
And so I think in terms of Putnam, if we just go through
Sure.
that, which you started, the subject of recoupment, if you could just go through the sort of the test about whether, and we're just talking about one site, so at this point it seems kind of like I don't even know what would happen. What would happen if you didn't build, if you had to comply with the zoning for that one site? Do we know?
Right. Well, the 2015 board determination looked at a number of factors, but looked primarily at the approvals that would be needed to build on the site, particularly submission to the SNAD requirements, and made a determination that first there was an absolute difficulty in that you would have no certainty of getting approved. And in this case, that's particularly poignant because here, dating back to 2001, both the community board and the borough president voted against the project, which was the reason for the initial application. But moreover, the cost per home, as was proven to the board at the time in 2015, would rise from, I believe, something in the neighborhood of $4.5 million per home as far as cost, to over $6 million per home, given that you would have no certainty of being able to construct on that lot. So there would actually be a substantial loss in terms of the over $23 million that has been invested in the project since the board's grant in 2015.
But the 23 million is invested in the infrastructure.
In the infrastructure, but also in construction of the existing homes that have not yet been CO'd.
They've not been CO'd, but the anticipation on selling them. Oh, so, all right, so what you're saying is, unless you get an extension on the time to complete, you don't get COs on 1, 2, 3, 4, 5, 6 buildings,
Correct.
right? 2 of which are not completed. Is 5041 Grosvenor complete now?
It says completed but no C above.
No, 5041, my note says to be completed in the next few months.
Oh, I had both of them, both 5041 Goodrich and 5041 Grosvenor are both completed but no C above.
Oh, okay. Can you just, because it's true, there's 2 different addresses. I have Goodrich's completed, but Grosvenor not, so.
Yeah, I believe if you look at the current photographs, the photographs were taken in November. You can see that it was substantially completed. Since then, I think we are pretty close. We can confirm.
On which one, Grosvenor?
Grosvenor.
41?
Correct.
So it's,
Again, I think we're very close. We're nearing final stage of construction. We'll be anticipating getting a CO soon.
okay, all right, so, but we don't have a CO, so if we're going back to 1, 2, 3, 4, 5 buildings that are actually very far along in construction now that need a CO, and failure to extend the vesting would mean
No C.
shells, very elaborate shells, because they actually have shutters and
Correct.
lawns and, okay. So we're really just, so that, I think that's for me, that's kind of the substantial loss hardship that's presented in a kind of a Putnam situation where you can't say you recouped on all the sites, except for the 3 vacant ones, for example. If there were 3 vacant ones, I think that's the way I'm looking at it. Because you built those buildings, you simply can't get a C of O. There is no way to return it to the prior zoning. Does that make sense?
There would be substantial loss here.
I mean, to me, you go back to the initial vesting application, because without that vesting, you couldn't have this.
Right.
So even though we're far along, no vesting takes you back to square one, where
Right.
you couldn't do it at all, unless you got the approval of all those different people that already signified they were not going to approve it, which mean that you wouldn't.
Right, okay.
So to me, when I said you should update the statement, it just strengthens your application to say now we are one away from full
Yes.
build out, whereas we might have lost 10 million, now we're losing like 30 million, or whatever.
Right, on those 5 houses that are ready to go, but for the CO.
Yes.
Right? Okay. Do we feel like that's an answer to Putnam that's satisfactory? Do we need to get a written submission?
I think I'm satisfied with it.
Are you okay with that?
Being that we discussed it.
I don't want to unnecessarily prolong this.
Thank you, Chair.
Okay. All right, are there any speakers on this? All right.
Member Community Board asked.
Oh, yeah, the
Oh, yes.
I'm sorry, I know, but.
Sure. No, Chair, I think that the determination was actually that the community board notification and subsequent requirement for a hearing here would be improper pursuant to
Yes.
1.0601F. That although I know that there was a notice of comments which discussed notification of the community board, that may have actually been an error. So.
Say what? Sorry, go ahead.
So that we would request that not stand in the way of an otherwise duly notified and applied for vested rights application.
Right, okay, so this is a huddle on our council part. So if extensions of time to complete construction and obtain a C of O are not required to be noticed under our rules. By, I think it was accident, the board sent out a notice of hearing to the applicant with instructions to notify the usual officials. And they did that instead of saying, hey, why do we have to do that?
So, Chair, if I might chime in, there is some confusion. This is actually not an extension of time application.
Oh, so, right, well, it's an extension of, extensions of time to complete construction is what I meant.
Correct, but it's not even not an extension of time on the SOC calendar. There's a special provision under the A calendar where we're actually amending the common law vested rights case. And I think that's where the confusion is. And I think our office, even in the initial filing, the referral went out to the community board because we weren't quite sure. We had some discussions before we even filed as to what this is actually filed as.
But why do you say it's an amendment of a vested rights case? It's simply asking more time to finish under...
and that's originally how we thought to file it, but we were instructed otherwise that there is a sub-filing under 106.1-F for amendments to A calendar cases, and that's what we're filing under.
It's an amendment for previously approval. It's to extend the term.
So understandably, it is very confusing. We were confused. I'm sure this board staff was confused. And we have notified that community board in April about this, and we've offered to meet with them in April and May.
So the community board was advised and they didn't hold a hearing.
But they did reach out to us, and we told them we would, in conversation, we had a conversation with respect to, they asked us not to put this on until October, No,
I know, I understand that, but let's just play out what this really was. So they were notified through the usual process, even though arguably they didn't need to do that. You didn't need to do that, right? In April, when you file this application, so the normal time period to hear is 60 days.
Correct.
So if we just did the normal time period to hear is 60 days, right? The other part of it is an extension of time to complete construction under any term isn't required to be noticed. That's the other part. And what would the community board be talking about? Whether or not they vested, we're the ones who determined that they vested.
Absolutely.
And they're not the ones who determined that they vested, right? And by the way, they vested, so a long time ago, very long time ago. And they built X number of houses, I've lost track, right? So I'm not sure that really, other than writing us a letter, that it would have any impact on, it can have any impact on our review. It's not the same thing as weighing in on, we do get community boards on initial vesting cases that say, no way they vested because foundations were not complete, or they worked illegally on weekends and things like that. That's not what this is about, right? Okay, so I'm sorry for the community board, which I normally would extend to, but I don't see a reason to be holding up CO issuances on this case. Okay, so apologies to them, but, yeah. Okay, so I would like to close this hearing.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Oh.
Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
We didn't say for how long.
2 years?
Too late.
2 years. 2 years, good, 2 years.
Chair, can we actually request a 4-year term? I think that will be done at that,
The
I mean,
record is now closed.
It's
You want
closed.
to open this to discuss the timeframe now. Yes, no?
Let's open it and just.
We can amend
You want
our
to
grant,
discuss
open
it? What?
We can open it to amend our grant and open,
Yes, okay, sorry, we have to reopen it and tell council what to write.
Motion to reopen. Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
aye.
Because actually, the text only, the submission says they need to extend time for 6 of the 8 homes, but it doesn't tell us how much time, I don't think. So amongst us, do we have enough information to determine this, or should we reopen and listen? Did we already open? Did we open? Okay, so let's hear why you think you need
sure.
4 years.
I honestly think that while I believe that 2 years will be sufficient and that it's in the owner's interest to proceed as quickly as possible, I would not want to be in the position where we'd need to come back to the board after 2 years, and so that's the only reason we
How
would
about
ask for
3 for a nice compromise?
I think that sounds totally acceptable. Thank you, Chair.
And this will be running from the prior expiration?
Which was
7/25/19?
June of this
July.
year.
June
Expired
2nd, June 2nd,
June
2019.
2nd.
Correct.
That's my notes too, June 2nd. Okay, 3 years from June 2nd, 2019. You don't find that, Jay?
Okay.
Yeah, because it was decided on June 2nd, 2015 and allowed for 4 years. Okay, so motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, and a motion to grant an extension for 3 years to complete.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Chair, Commissioners, thank you for your time. I
Thank
appreciate
you.
your consideration.
Item number 18.
Sorry, just a second, let's get the phone out, okay. Thank
Item
you.
number 18, 2018-129A, 484 Sharretts Road, Staten Island. No, 8 cases not yet. Soon, but not yet.
State your name for the record.
Good afternoon, Philip O. Rampula. We reviewed the review session yesterday, and if I can get right into it, that's okay. One of the first questions that the board was asked was what triggered the DOB to send this application to the BSA. At the time the original building was built, the buildings department had the practice that if a street was CCO'd, it did not require it to go to the BSA. And as long as they had 8% of their frontage on a mapped street, and they did the calculation, which they did not have to go to the BSA. So now the owner was able to purchase the property next door, which only has frontage on Marjorie Street. And under the relatively new regulations, that requires that building section to go to the BSA to construct that building.
But it's not a building, it's an enlargement.
Yes, it is, but it doesn't, it no longer has 8% of the perimeter of the building on a map street.
Oh.
Right, right.
But before, if you were just renovating this building, no enlargement on that, you
Right.
still wouldn't have had 8% fronting on.
No, they did. I
you did?
researched the records, and I found that they did the calculation that 50-foot frontage that they have on Sharretts was enough to satisfy the 8% perimeter.
Okay,
But they maxed it out.
all right.
So here we are. One of the questions asked is that we should submit a builder's pavement plan, which we did in my last submission. It's Exhibit E.
No, it was a
we had
builder's
some-
pavement plan only for the little piece of Sharretts.
No, it's for both. It's for Marjorie also.
Oh, okay.
And I would like to direct you to page 2 of the builder's pavement plan. And,
Okay, hold on a second, let's
Okay,
get there.
take your time.
Which day did you submit that?
I submitted that.
The initial submission?
No, it was in answer to examiner's questions.
So I don't find it in the May submission, which was, I thought, the answer. In May, you submitted, what is that? Oh, maybe that's the builder.
May 14th.
Sorry, May, yeah, you submitted a BPP
Right.
on Marjorie, but I don't see,
So if you look at page 2,
okay.
you'll see down on Marjorie, you'll see
Oh, I see, yeah,
the
yeah.
cross-hatching.
Yeah.
Yeah, you know, part of it, the problem is it's like a soupy PDF. It's very hard to see it.
I understand.
Okay, so,
So now, from curb to curb, the street width will be 37.22 feet. We are putting in new curbs along Marjorie Street, and we are putting in new curb cuts.
can you see that? Yeah. You can, sorry.
That dimension.
That soupy dimension that says 37 feet? Okay. So when you're measuring the 37, what's that dashed line on the other side?
Curb.
That's the actual curb on the other side?
Yes.
Okay. And so, and on your side, you're putting in a sidewalk of what?
I'm not putting in a sidewalk, I'm putting in curb.
So why can't you put in sidewalks?
DOT didn't require it because they didn't see it as a high pedestrian street, and they noted that they had the existing loading docks there. And since I'm on loading docks, I just wanted to point something out. You had mentioned in the review session, Chair, that Marjorie was kind of like the Wild West, and you were absolutely right. The approved drawings, when the building was originally approved, showed the loading docks, but it showed the loading docks up here, and then there was space, and then the paving was down here. Somewhere between C of O and time went on, they raised the grade so that the grade went up to the loading dock. So you'd be able to drive from one side, from the Sharretts Road side, through the building and out. So it doesn't make grade for a lot of different reasons, for safety, for a car bottoming out. So our proposed drawings show the grade dropped again and the proper loading dock being put back into motion.
Okay, so which drawings are showing it brought to grade? Your plan or your BPP?
Both. We coordinated with the engineer for the BPP.
Okay, so I only can take your word for it because I cannot read this BPP. Everything is just kind of more or less vanished.
I could
So you're saying that in that 50% that's your domain of Marjorie, you are dropping the grade of Marjorie down, or you're dropping the grade of your front yard down?
I'm dropping the grade of my front yard down.
Okay, to meet the Marjorie Street, which
Correct.
you're going to repave.
Correct. I'm not going to be absolutely flat. I will have a little,
Sure, a swale or
yeah.
something. Yeah. Okay. Okay. Good. And then the other portion of Marjorie that your existing building is fronting, you're not required under the builder's pavement to?
Oh, our builder's pavement is for the entire existing building and for the new building section that we're adding, so.
No, the part where it wraps around. So Marjorie comes off of, whatever street that is, Sharrett's,
Yes,
right?
yes, because we're zero, they went right on the lot line with the side of the building, with the east side of the building. No, we're not doing anything on the east side of the building along Marjorie Street, correct.
But what's the condition of Marjorie along there?
That's the best part of Marjorie, actually.
Okay,
It's paved, there are no potholes, it's in pretty good condition.
okay.
I was just on the block. It's,
Speak up.
I was just on the block. The best part of it it is the best part of it, but that's not saying very much about that street.
Yes.
So, in terms of, and I think this is, is fire department still here? John, is he still? Yeah, I actually would like them to speak on this because fire department reviewed this application kind of, in terms of what I understand, as if the only access is from Sharrett's and that T-shaped access, right? Because they wanted you to keep it clear and no parking and the turnaround and all of that. But there isn't an analysis of Marjorie Street and how, for instance, it dead ends in a strange way with this diagonal bar, or I actually don't even know what that is. So, and then there's businesses across the street from you. So how does, normally there's a turnaround that's required on these streets when they're dead-ended, and so I don't know how
Well,
a truck goes down.
If I may, before the fire department comes up, if you look at the radius diagram, there are other buildings further west on Marjorie Street, and it doesn't just end there, it continues on.
It does?
Into another property. Into another lot.
Yeah, of several other lots. The road goes further down.
Not by much, right?
Well, yeah. If you look at,
Oh.
fif-
On the land use map, but
Yes.
in real life, it goes further down?
yes,
But your drawing shows, your builder's pavement plan shows this diagonal bar in the center. What's that?
That's to meet the existing edge of pavement of the adjoining property owner. So it's a transition, that's a curb, it's not a bar. So we've widened Marjorie by about, I want to say, 20 feet.
Wait a minute, so there's a point at which Marjorie necks down to less than 10 feet?
Hold on.
So then that's not a continuation of Marjorie, that's a dead end.
Marjorie,
I feel like we're talking about me.
Marjorie.
Yeah. No, but it's landscaped. I mean, there's trees in it. It's not actually passable. It's just shown on the radius map.
no, it's passable. You can drive down there.
No, can you take Marjorie and
If we
go
get-
all the way to Arthur Kill?
No,
Okay, so it just dies at some point?
yes.
It's an L with only one set of the roadway that is connected to Sharrett.
Correct.
Rest
And-
is not.
And the last building on that street, for lack of mispronouncing the name, is Lot 240R. It's on the opposite side from us, and it's at the edge of my radius diagram.
Not that one.
So not all of Marjorie past our property is improved to its full width.
Right, so that's the point, is your builder's pavement plan that reflects this bizarre diagonal curve or something is showing that it's not passable the way by a fire truck. by anybody, really,
Well, no,
other than a motor scooter.
There are large trucks that go down to that's
No.
it's a plumbing supply house.
Yeah, no, the trucks go down, but the only way they can turn around is if they go into the driveway, the private drives, and back up.
Or make a broken K, yes.
So,
If people still know how to drive.
but the broken K is being made on private property, right?
Yes.
So that's where I started in the first place, that Marjorie is effectively a dead-end street, because though it may be showing on the radius map, you can't drive there unless you have a motorcycle.
I see what you're saying.
Okay, so that's where fire department comes in. So let's see, and they may not have looked at this yet, but I do want them to look at it.
Good afternoon, John Daly, Fire Department. And I cannot at this time comment on this application. I am still waiting for our city planning unit in operation to get back to me.
Okay, so but do you understand what the issue is?
Yes, ma'am, I do.
Okay, so because all the comments that we got were about the direct access from Sharrett's Road to an interior T-shaped, kind of like a driveway,
Yes.
right? And fire department required sort of that refuge area, the frontage area, which I get, so that's how you fight the fire from that side. But Marjorie is an active, very narrow street, and the proposal and the existing use is a lot of truck docks. Wow. The proposal is a lot of truck docks that are coming down, trucks come down Marjorie, pull into these many truck docks. And the one thing I'm concerned about is that the front yard is only 19 feet deep, and I'm concerned about the trucks maybe longer than that. I don't know if that's the case, because it's not being used at the moment, right?
Right.
And then the other is whether the proposal in any way obstructs the ability of the existing businesses to operate. Those are my questions.
Okay, I understand what you're asking for, and I
Okay.
relay those comments to Bureau of Operations.
Okay.
Get back.
Great, thank you. All right. All right.
You also asked for no parking signs?
Yeah, on that T-shaped portion. So fire department said keep that area from Sharrett's to the frontage space clear.
Yes, we did.
Right, so you do that by having no parking indicated on that side, but to enforce that there's no parking, in fact, you should put no parking on that side. Otherwise, you'll narrow down what you're calling 30 feet clear to whatever, 20-something feet clear, 20 feet,
Okay.
right?
And then DEP sign-off, I had submitted a letter from our engineer, who, it was an exhibit also, who stated that the existing septic tank has the capacity to take the addition. We have not filed with DEP, but we explored the existing septic system to see if it had the capacity to take the addition. There are no storm or sanitary sewers in Sharrett's or Marjorie.
Okay, so we don't sign off on DEP's issues, DEP does, so that letter needs to go to DEP and see if they agree with you that everything is okay, which we did.
We'll reach out to them and see if they
Okay.
have any comments on that, if they're
What-
required to file anything,
Okay.
all right? That's up to DEP, sewer and permitting unit.
Okay. Are there any speakers on this? All right. Okay then, so need time for fire department to review, need time for DEP to get back on their issues. And I think that's really it, and then maybe a little bit back and forth between fire department and DEP, so 30 plus, so when are we, October, November, late November?
They need 1 month.
Yeah, he needs a month, back and forth, so late November, early December?
Okay. Submission November 6th for continued hearing on November 26th.
Very good, thank you.
Is that enough time? Is that good? Yes.
I think so.
Item number 19, 2018-178A, 2 Oak Tree Way, Staten Island. You could sign in later.
Philip L. Rampula for the applicant. At the review session, one of the comments was that you needed the community board recommendation. That was submitted, and they did vote in favor of this project. One of the other, if you don't have it in the record, I think you do, I'll resubmit.
You know, we're reviewing PDFs. Those are, sometimes it doesn't all make it into the folder, but.
That's okay.
This one?
It's not, do you know when you submitted it?
178. Take a look at it. Should be there.
No, I don't.
So I don't see it.
It's a while ago.
So earlier than June?
Yes.
Okay. No, it's not in there.
It's June 7th.
No, it's not in the June, not in my June folder.
What are you looking for? The community
Yeah.
board. Where's the community board? Not in there.
There's a DCP comment.
No, go back out.
I'll resubmit it, Chair.
Please, because
not in there.
it's not in our folder.
Void?
Doesn't mean you didn't submit it, it just means it didn't make it into the folder.
I understand.
Okay.
So here we are in the Toad Hill section of Staten Island on a lot that is unusually large in that it's, I think it's over 450 feet in depth.
No.
And it has at least 200 linear feet of frontage on Ocean Terrace. In addition, what complicates the lot is to the back and to the rear is New York State freshwater wetlands. So the first thing that we did is we filed with the DEC to get a wetlands adjacent area permit, which was granted by the DEC. Matter of fact, I'd just like to take a footnote on this. 90% of freshwater wetland adjacent areas are measured at 100 linear feet. They have what's called an extended adjacent area, which this falls under, so the adjacent area is in excess of 160, 170 feet. So even with an extended wetland adjacent area, the DEC saw that the proposal was sensitive to the environment. We declared an area of no land alteration to preserve it. I think our FAR is less than 0.20, 0.20.
Where, what's permitted?
0.5. The other thing that we strove to do was to preserve the existing single-family house that has frontage on Ocean Terrace and is serviced by a circular drive. That existing single-family house has a nice presence on Ocean Terrace. It's set back about 100 feet from the street. I've expressed this to city planning previously. One of the reasons that we've shown a cul-de-sac with a 20-foot driveway going to the cul-de-sac is that there's no parking permitted on either side of Ocean Terrace at any time. So you start to get the sense that the circular drives that was done for the existing house was done so that guests, deliveries, the post office, they can come in off of Ocean Terrace, park, service the house or visit the house. And we were doing the same thing with the cul-de-sac. Because we were more than 100 feet back from the street, we were concerned with the fire department and whether or not they would want a turnaround at the end of a cul-de-sac. It's not required for one single-family house, but we thought it would do double duty for delivery trucks and for the fire department. The fire department did indeed sign this job off, and they did approve it. We filed with city planning because we're in the special natural area district. City planning, and it was said at review session, At first, they had resistance to the project because they thought it was the typical house behind the house. But this isn't the typical house behind the house. The distance from the back of one house to the front of the proposed house on Oak Tree Way is over 70 feet. It's not your typical R3X, cram in as many houses as you can. It's one single-family house. When this project first came into us, we did an analysis. We took Oak Tree Way, we made it a 34-foot wide street with a cul-de-sac, and if we demolished the existing house that's up front, we could very easily fit 5 or 6 houses on this lot. So we've chosen only to do the one house, and that is hats off to the owner for only wanting to do the one house. One of the other comments that was made on at review session is that have we looked at coming in off of Woodhaven Avenue to avoid having to do this frontage on Oak Tree Way? Well, of course we did. But if you look at the radius diagram, you can see that that portion of that 5-foot that we own on Woodhaven Avenue is actually part of 370, and that roadway is owned by 370. The owner of lot 370 had no desire to sell any or all of his property to my client so that we can access off of Woodhaven. So we did explore that at the very beginning, and we were turned down flat.
So your client, I thought, that the real question was your client doesn't own 370 is the point. Okay.
No, he also looked at getting an easement off of lot 105.
Lot 105, okay.
Which is
to pass over that lot onto his lot.
Right, and gain access that way. And that didn't work out either.
Okay.
So yes, I would request that the BSA reach out to city planning as to why this is the only project in my history that they're looking for BSA approval before they grant natural area approval. It's the chicken and the egg. I've always gone to the city planning first, gotten city planning approval first, and then come to the BSA. Right. But in this case, they said, we want you to go to BSA first. I never really got a good response why they did that, and that came from Len Garcia Duran, who was the director at the time, who is no longer there. We have a new director.
So did you try, and you reached out to the new director?
No, I did not.
No. So it's worth checking again, but they had so many issues that had to do with things that are not our domain that really, those issues might change the layout of your street?
That comment letter that I submitted to you, I answered all those comments and made a resubmission.
Oh.
So they're pretty good with the site plan as we have.
But we don't have any response, right?
No.
So if there's another status letter that, I think it is quite odd that they're not taking this all the way through. We will reach out to them. But, yeah. And then, so we'll reach out to city planning, but in addition to which, we need your most updated status report from city planning. And we need to understand from the project manager at city planning, where this is in the certification process. Is it almost ready to be certified as complete? And the only thing they're not doing is certifying it as complete, or what, right?
Well, I'm on my third project manager since I started in city planning. So there's no continuity here. And plus, Mr. Hadwin is relatively new, so I don't even think he's familiar with what Oak Tree Way is. So they all have to be brought up to speed in order to make that kind of determination.
Right. Well, when was the last time you got your status reviewed?
When I asked, can we move this along, and they said, we're going to assign a plan examiner and a planner, and they did. And he said, we'll get done. His remark to me on the phone was, we'll get done with the BSA, and then I'll look at the case file. I'm inundated.
Oh, okay.
But I think a call from the BSA would be great.
Okay,
I would
we're happy
encourage
to do that. Because, yeah. It'd be kind of ridiculous. We decide on a shape, and then they say, no way, because you're destroying these trees and moving that boulder, and then that's,
Well,
yeah.
I had a pre-application meeting with them before I even filed with the DEC, and I'm still having problems with them.
With city planning or DC?
No, with city planning.
Okay. Okay. All right, we will reach out, that's all we can do.
Okay. This was another one where DEP had given a comment letter, and I knew from experience that there is no sanitary, nor is there a storm sewer fronting the property or in Ocean Terrace, or Woodhaven for that matter, if we could have gotten out that way. But you have to do a septic percolation test in order to put in a septic tank. Septic percolation approvals are only good for 2 years. I knew between city planning and BSA that I was going to be in here for more than 2 years. So we did not go forth with the percolation test.
Okay. But in terms of city planning's review, they require ultimately a perk test in order, no?
No.
Okay.
No,
DEP is going to require the perk test.
DEP.
But don't DEP and city planning work together ultimately when they're reviewing these applications?
Septics? No.
Yeah, I thought that was part of it in terms of city planning understanding the drainage concerns on a natural area. I thought part of it is that DEP looks at the drainage situation to make sure, and city planning to make sure that it's all being managed properly before it agrees on how you're modifying the natural area.
No, not to my knowledge, no. And I also think the DEC kind of trumps DEP. They made us do an analysis of pre-development, post-development stormwater to make sure that we had the same amount of stormwater charging the wetland post-development that charging it now. So it goes contrary to local law 103 of 89, where you're supposed to take 100% of your stormwater and dispose of it into dry wells. But when DEC is involved and they, they're a state agency, they want to make sure that those wetlands remain charged. So they kind of trump what DEP is looking for.
Okay, so to cut to the chase on this one, when ultimately it's before us, where we're able to decide, we will want DEP to sign off on this. So that's when you would, knowing kind of, your timing, then you need to respond to DEP's concerns, okay? So I understand that at the moment you don't have any idea when city planning is going to decide on this. So we'll clarify.
Okay, but as far as getting DEP approval for a septic test, you can only do septic tests during the rainy season from April till end of May.
I thought the rainy season is from January to December now.
It could be.
I believe you could do a percolation test.
We did a regular percolation test.
Yes, but you're saying you cannot do it except for within like a specific timing?
For septic. We did a percolation test to make sure that the dry wells would work on site. And that could be done 12 months out of the year. And we have good percolation rate there.
Okay.
But for the septic, it can only be done during the rainy season.
Mm-hmm.
So it's two sets of holes, 2 sets of perk tests.
Okay.
And the one that expires is?
Septic.
Septic. Okay.
That's weird that it expires.
It does. I have 2 houses on Toad Hill Road right now that we're redoing the septic test holes. We have to dig out the sand column, put in fresh sand, and then re-perk it.
Maybe because there's so much change in groundwater, or, I don't know.
No, it's
changes.
It's not related to the groundwater. It's related to the size of the grains of the dam itself. It's weird.
But what if the water table is rising, something like that? No? Doesn't affect it?
I don't know. I wish I did.
Okay. Okay. We'll
Do you know-
Google that.
Do you know which article says that it expires in 2 years?
I can find out, I don't know it off the top of my head.
This is nothing to do with the application, but I would be interested.
It's a stamp that goes on all the septic drawings. This
It
approval.
says only good for 2 years.
Right.
Ah, okay.
Okay, so this is like dictated by the DEP?
Yes.
Okay.
Okay. All right, good. So we'll reach out. I'd say that, in terms of the hardship analysis, we didn't see that. You need to do that. But this is more of the classic, what's the case? Browse case where it's one house?
I don't know the Browse case. This is the
Okay,
first
so
time hearing
you
it.
should bone up. So this is Browse v. what? Smith? And that, and actually maybe council could get you a copy if you have trouble getting a copy because we can access it online.
And it basically,
We have it?
in its dicta, it does discuss a very similar case to this as what it would consider something that should be granted.
Right.
I
And so,
appreciated the comment yesterday at review session, that for a single-family house, to map a street for a single-family house would be a
Right.
hardship.
so this is kind of a classic where a GCL 36 waiver makes sense. And so, but we need you to cover that hardship argument, okay?
Understood.
Okay, so I think mostly it's you're addressing the comments from city planning and fire department and DEP to the extent you can at this stage.
Right.
But the other part of it is that we need to find out from city planning how we're going to get this done because there's so many other approvals needed. I do note there's my question about the declaration of restrictions in favor of DEC. That wasn't recorded. What was the deal with DEC?
We usually, we're also required to send in a notice of when we intend to commence construction to the DEC. It's at that time that I usually put a package together of the notice letter and the recorded restrictive declaration. I don't like to encumber property with restrictive decks if I don't know if the other city agencies are going to grant the same approval.
Okay. And that's DEC's understanding also, that
Yes.
you don't record until permitting, basically.
Yes, they'll take it at any time.
Right.
They draw the line if I need a permit renewal. If the permit's good for 4 years, the DEC permit's good for 4 years, and if I'm coming up for renewal, they'll say, Mr. Rampoula, send in the recorded restrictive deck before we renew this.
Okay. And you got your DEC permit when? 2016. No, that's city planning. I don't know. Yeah, I didn't write that down. Somewhere in that neighborhood, though, 2015. Oh, it's a 2015 declaration, so you must have got it in 2015.
2016 is...
February 2nd, 2016.
Okay, so, all right, so you're going to need to renew it shortly anyway, so, right?
Well, I was just going to look to see if they gave me 5 or 4 years, but I don't want to take up your time.
Okay, that's right. Okay. All right. Are there any speakers in this? Did I already ask? Okay, so let's see. You can, I don't know how much time you need to respond to fire department and so on, but let's put this on kind of towards the end of November. It's going to take time for the back and forths with city planning and so on.
Can we do the same dates for Sharrett's? November 6th, then November 26th?
Yes.
Okay.
Okay, great. November 6th submission and November 26th hearing.
Thank you very much.
Thank you. Okay.
Zoning calendar decision.
Wait, this is a decision because this is a break now, right?
It's adjournment, right?
This is an adjournment, yeah. Let's just do that one.
Okay. Zoning calendar decision items, item 20, 15715 BZ, 3925 Bedford Avenue, Brooklyn.
Good afternoon. Lara Altman from the Law Office of Lara Altman.
Okay. So, I'm going to say this in the nicest possible way. It's really not okay to be submitting inaccurate materials, and to submit them late. They need to be submitted on time so that our planners, the commissioners, our council have time to review, and they need to be accurate when they're submitted. And it's not our job to check on the accuracy of any applicant's submission. We have to assume the submissions are accurate, and it's the job of council, your council as in the council representing the applicant, to scour through the materials and make sure they're accurate. And when we find inaccuracies over and over and over again, it's a waste of the board's time. This application started hearings here in August of 2017 and was adjourned 5, this will be 6 times, in large part because of failure to be responsive to the board or inaccuracies. And it's an unacceptable way to prosecute an application. And I'm trying not to be furious in public.
If I may, I'd like to point out that the reason this case was actually adjourned many of the times was because the homeowner's wife unexpectedly passed away of meningitis at 39 years old, woke up Saturday morning feeling ill, deceased on Sunday. He put the application on hold with my office repeatedly because he wasn't sure if he wanted to proceed. That is really why we kept adjourning the application. With respect to the submissions, we were here last Tuesday. We were asked to submit on Wednesday. We did submit on time with signed and sealed, revision date. Then we were asked, I misunderstood, I thought we were asked to mark in the attic the areas that were under 5 feet in height. What you wanted was all of the areas that weren't being included in Floria. I apologize, that was a misunderstanding on my part. When I did find that out, I then turned around and got you a new submission with that as well. But I did submit on time with what I understood to have been requested, based on the conversation in here.
So moving forward, because I feel like we're often getting, I'm sorry, I thought. If you listen to the videotape of that hearing, we were extremely clear about what we were looking for. And so in future, you must listen to the videos, and you must listen to the videos and do what is being directed to be done. And not assume that you've got it and then wait for one of our council or project managers to call you and say, no, you didn't do what you were instructed to do. And I don't want to go over it anymore, but we're going to adjourn this.
So what's the adjournment date?
Until end of November.
All right. So November 6th with a submission for November 26th.
Submission? I don't believe there's a submission due.
There's a submission. I mean, I don't know if what you submitted is accurate, right? So
Yes, it was already submitted, so what is our continuing? I apologize.
November 26th.
November 26th, but I would recommend very seriously that you look at the submission that you submitted and make sure that every single thing in it is coordinated, that every single number matches the other number, and so on, okay?
I will, and I'll ask the architect to do so as well.
No, yes, but you're to do so. Don't rely on the architect. Relying on the architect has not worked out on many of your applications, okay?
Okay. We'll come back in. We're going to adjourn. We're going to adjourn.
We're going to take
a break, a lunch break.
Yeah, so
Late
come
lunch
back
break.
at 2:45, is that right? 30 minutes?
3 o'clock?
Yeah.
Well,
Quarter to 3.
2:45. 2:45.
2:45.
It's surface, I think.
I'm gonna. Got it? There we go, sorry. Must have hit the cord. Okay, ladies and gentlemen, we're back on the record. Item number 20, zoning calendar decision items, item number 20, 15715BZ.
20.
I'm sorry,
21.
item, continued hearing items, item number 21, 4311BZ, 1926 East 21st Street, Brooklyn. You know this, sir? Right there. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Good afternoon. Lyra Altman from the Office of Lyra Altman. We did have somebody attend your executive session yesterday, heard your comments. We have already submitted revised existing plans, proposed plans, and zoning analysis form. The two errors that were found, number one, on the proposed plans, the perimeter wall height shown as 20 feet 20 feet 11 and 3/4 inches. That was correct. On the existing plans, it was inadvertently shown as 20 feet 10 and 3/4 inches. It was when they remeasured, they didn't carry that change over. And second, there was a mathematical error on the existing plans. What they took was 2,943 square feet. They deducted the 368 square feet. And instead of coming to 2,575 square feet, they came to 2,475 square feet. Those errors have both been corrected. The floor area FAR has been updated to .64. In addition, the open space and lot coverage were checked to match that as well, and the statement has been revised accordingly.
And then-
everything matches perfectly. I have checked every number on all
Really?
pages.
You're under
for you.
oath, you know.
I have checked every number,
Okay,
whether it's the
so-
yards, the floor area, the open space, the lot coverage, every number has been checked, every page is signed
Okay.
and sealed, revision date is on there, per my conversation.
Careful what you say under oath.
I
So
have
we
checked
found
every
a
number.
mistake on the zoning
Where do you see
calculation
it?
sheet.
I have checked
where
every
you're
number. What
saying
did you
yes, where, that it complies when it can't comply because you're asking for floor area waiver and whatever the other waiver is.
checked all of
And
the
you're
numbers.
saying
Oh.
yes, and
Oh,
then
the
you're
numbers.
saying, oh, look at that, they don't match. So here we go again.
No, all
I'm-
the numbers were checked, I apologize, I didn't check the compliance column, you're right.
So I'm not interested in apologies. I'm interested only in carefully checked, coordinated submissions, and I'm not going to give the same speech that I just gave. It's unacceptable to submit these materials that are replete with errors that our staff ends up discovering, and you and your staff can't find on their own. So we will adjourn this till,
Understood.
again, the end of November to give ourselves enough time to review thoroughly your resubmission of the materials, that you check thoroughly, and you do not rely on the architect to check. You check
No, I
them
did not.
yourselves, and I don't want any more apologies or excuses. It must be right.
Understood, I will tell you that we went through.
I'm not interested in hearing anything else. Stop talking. Okay.
November 26th?
Thank you.
With the November 6th submission.
Thank you very much.
Item number 22, 23115BZ, 5278 Post Road, the Bronx.
Mitchell Ross for the applicant. Our submission was late.
Yes.
That's the only reason for the adjournment. We're not requesting it, it's just required. And we've made a complete submission based upon our understanding of what was spoke about at the review session for the last hearing.
Okay, for your sake, I hope it is a complete submission, so given that we're adjourning this because it was late, please go through the last hearing on February 26th, listen to the review session and the video, and make sure that every single thing that you submitted is responsive to those comments.
I
Okay?
shall.
I don't want to have a situation where you have to be adjourned because it's an incomplete submission.
I shall.
Okay, okay, so then, again, put this something late in November.
The community board asked for after the Jewish holidays.
Yeah, so they asked for after October, so we would be doing it late November.
Okay, November.
Can you do November 16th, please?
No, this isn't,
There isn't one.
there isn't one.
It's
It's
the
not,
19th.
Oh, the night, forgive me.
I don't know.
It's already two financials on that day.
No, so the answer is no.
Okay, so November 26th with a submission, if any, on November 6th.
Okay, thank you very much.
Thank you.
And you want a dismissal warning letter signed?
Sorry?
A dismissal
Oh,
warning
yes.
letter.
So this application has been here for a long time. There were two postponed hearings. I think they were based on notice problems. I don't remember exactly. And this is the second adjournment, so I would like a letter to go out to the owner, and it will go to you as well, saying that it's the last adjournment, okay?
Understandable, thank you.
Item number 23, 2016, 4239BZ, 180 Mansion Avenue, Staten Island. There is a request for withdrawal.
Yes. So, okay, and, yeah, that's fine. So then I'd like to make a motion to withdraw.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Application is withdrawn.
Yes, and we'll notify DOB that this application's been withdrawn, so that's Chase's department, right? Just so they know.
Item number 24, 2016-4465BZ, 129 Anderson Street, Staten Island. There is a request to withdraw this application.
Yes. Motion to withdraw.
Chair Perlmutter?
Oh, this is withdraw without prejudice, if I remember correctly, right?
Yes.
Without prejudice, yes. So, motion to withdraw.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
This application is withdrawn. Item number 25, 2017-265BZ, 318-320 54th Street, Brooklyn. There is a request for an adjournment.
Right, she requested an adjournment until late December, and I just, again, if our project manager, Jella Prenga, can reach out to her and make sure she can make those findings, that would be good. So, late December. I'm not sure if she means submit late December or a hearing late December.
Well, she needs to deal with the objection first of all.
Yeah, so, okay, so maybe we should do it, a submission in December, in late December for a January hearing.
Because she has to notify, right?
Yeah, yeah.
It's an application.
So a submission on January 24th.
December 24th.
Or December 24th for a continued hearing on January 14th.
Item number 26, 2018-95BZ, 120 Avenue M, Brooklyn. Yeah, that's the wrong one. So, two, that's weird. As soon as he signs this, just in case you want me to say anything. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes. Good afternoon, Commissioners. David Rosenberg of Sheldon Lobel PC. On behalf of the applicant, I'm joined by Charles Schwartzapfel, the architect of record on this. We attended the board's review session yesterday, and last night we sent a revised restrictive declaration with the corrections noted by council, and we want to thank the board for their consideration in making sure this moves as expeditiously as possible.
So I appreciate how responsive your team has been, in particular the architect for making the kinds of corrections on the drawings that are responsive. And so I would just like, are there any speakers on this since it's still open? No speakers? Okay, Avenue M? No? All right, so I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition, which we've discussed, and it's part of the restricted declaration, that shuttle bus services to the parking garage shall be provided according to the terms of the restrictive declaration, that the restrictive declaration shall be recorded prior to permit, that facade enhancements as shown on the drawing shall be installed, and landscaping and parking for 2 vans also provided as shown on the drawings. Okay?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you,
Application is
Commissioners.
granted.
Thank you.
Item number 27, 2018-104BZ, 1234 to 1238 East 22nd Street. There is a request for withdrawal.
Correct. They're all been requesting a withdrawal without prejudice.
Okay, so for a motion to withdraw without prejudice.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you very much.
Item number 28, 2018-109BZ, 9-03, 44th Road, Queens.
We should forget.
Was there a submission early this morning on this? No. Oh, it's auto turn, that was yesterday, okay.
There was something else.
I thought something was this morning.
I didn't
Oh, and then there was a statement that spoke to some of the neck downs that have been proposed at the various intersection with the accident counts.
That was submitted this morning?
This morning, yes.
Oh, I don't have that. I just have from Monday at 5:14 PM. Okay.
Please state your name for the record.
David Schnackenberg, appearing.
You have to be sworn in.
Yeah, it's.
The team.
Everyone will speak.
Yeah, the team of 44th Road needs to be sworn in.
Just you two?
Anyone else going to be speaking? No? Okay, from the team, that is.
Okay.
Just have this one.
Just right here?
Yeah, I think this.
School safety request.
No, one of them had a chart with the respond. I think it came
They can be sworn in.
It showed the way the job works and had some activities.
And we asked them to display it.
That's good, Amber. Okay, raise
No,
your
it's
right hand.
taking forever.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to any questions?
This is just the rules of how you do the
Proceed.
school safety analysis. And then opposed amendment.
Hello there.
Hello.
So,
State your name again, please.
David Schnackenberg, Golden Harris, appearing for the applicant, their own construction.
And speak up into the mic.
Into the mic, is that better? Okay.
Okay.
So we heard your comments yesterday at the executive session, and we'd like to respond briefly. Just gonna pull my notes.
So I know we asked to have the crosswalks and so on explained to us on the drawings, so
Yeah.
that's what we're, okay.
Would you like us to handle that one first? There were a number of items. We can do that.
It's
first.
it's your show.
Okay. All right, yeah, go ahead. I'll find it.
Why?
It's taking a while, right, to download? Yeah.
Too many people online. State your name, too.
Amber Cartalian, Equity Environmental. We
Take the mic
listened
with
to
you,
the,
Yeah, take your mic.
we listened to the executive review, and I just kind of wanted to walk through the arrival and dismissal protocol and the shift of the building. I'm sorry, for whatever reason, this section did not print out on our print. So,
That's weird.
as you guys know, the building has dramatically shifted from what was previously in front of you. The entrance of the school is now directed towards the primary paths of student arrival and dismissal. And we have here, this is the main entrance of the school, and this is the gymnasium. So there's a proposed school no standing zone in front of the main entrance, and then a secondary one that would be only utilized by private cars along the 10th Street frontage. The majority of student trips are going to be arriving from 44th Drive, from the corridor where there's transit collection points over here. So this is like a main collection intersection over here, as well as Vernon Boulevard in both directions. And the yellow dots, I don't know how well you can see this here, are staff members that would be tasked with stewarding the loading and unloading zone. So basically escorting students on and off to school buses, private cars, and in and out of the building where they're held during dismissal.
So the staff will be in those yellow dots at what time?
So the staff would be there prior to student arrival. School is open for breakfast at about 7:30, and then arrival ends, I believe, around 8 o'clock. So for about a 30-minute period, they would be stewarding these corridors. The building, the number of curb cuts compared to what was previously proposed here was reduced, and the locations were shifted slightly. So based on the nodes of residential and the transit, we really only anticipate the possibility of students traveling past one curb cut. As an additional mitigation measure, we've proposed a trained flagger, so there would be selected staff that would be pulled out and trained on how to, during the morning, they would be stationed on the northern portion to hold arriving students and basically make sure that they make it past this curb cut, and during the afternoon along the southern portion and hold students from here and make sure they can safely pass. And in combination with this, we're actually, we've identified a passive pedestrian detection system that's a combination of in-ground LED lights in the building bays, building mounted sensors, and overhead pedestrian flashing warning lights that in combination will alert vehicles whether or not there is pedestrians approaching on any frontage of the building.
How do the in-ground lights work?
So they're connected to the sensors. So it's basically three components of this: the flashing overhead pedestrian, the signage, the sensors, and the LED lights. They're all connected so that when the sensor detects a pedestrian, the lights start to blink.
When the sensor detects a pedestrian, at what spot?
So anywhere approaching from either side, let's say over here, there's a student approaching from this direction, there's a building-mounted sensor that detects them, and the LED lights would go off. We are working closely with DOT School Safety Division on this to make sure that upon implementation, everything's calibrated and working. And
But the LED lights are located where relative to, it's to alert the driver in the truck dock, right?
Correct,
So
yes.
where are the LED lights installed?
On the furthest edge of the building bays, essentially, not outside on the sidewalk, but on the furthest edge of the opening of the warehouse space.
So in the ground, at the sort of the entry to the dock, is that correct?
Correct, and there's a spec sheet of all of these at the end of the architecture.
Yeah, I saw the spec sheets, but it doesn't show where they're going to be located specifically, so I'm trying to understand that. Because I actually thought those were alerts for the pedestrians, not for the drivers. So that's an alert for the driver to know before the driver pulls out. But aren't the drivers backing out most of the time?
It could be either, but they will be able to see that. There's also going to be mirrors that are mounted on the edges of the
Mirrors
bays.
are the old-fashioned way of doing it. Now you're doing it very super techy. Isn't there something for a driver whose front is at the dock so that they, when they look in the rearview mirror, they can see that there's something going on?
Don't they generally back into the dock so that they
That's
could
what I
open
don't
their
know.
The drivers are going to be nose out.
Oh, so
at
they're
all
always
times.
nose out.
I
Okay.
apologize, yes.
Okay. Okay. And in terms of so you have a flagger on, what's that street on the right? 10th Street.
10th Street.
Is there a need for flaggers on the opposite street that's
So we don't feel that there is, and the reason being during the AM arrival, we have somebody that would be stationed at Vernon Boulevard over here, and their job would be to direct students along the route of travel to avoid going down this corridor. And similarly, during dismissal, they would be stationed here to direct students away from that corridor. The idea being that we're trying to, and in the redesign, limit the block faces that students would traverse, and that the building was basically designed around the pedestrian path of travel of students. So realistically, we're anticipating only one curb cut along that path of travel, which would be, have a flagger assigned to that location.
Okay. Okay, keep going. You have more, right? So we just talked about the flaggers and the pedestrian alert signs.
Correct.
To pick up on what Commissioner Shanda was talking about yesterday, all of that.
Consideration of students coming from Vernon Boulevard, correct?
Right. I think my concern was that there is a bus stop at the north side of 44th Avenue in Vernon.
Right.
So those students who would be getting off that, I was not sure how safe it is, but now that you're saying there will be a staff member there directing students to not walk along 44th Avenue, but continue to walk along Vernon Boulevard and direct them to 9th Street.
Sorry, where does it show that on those drawings? What's the difference between so what does that green dot mean?
So this is during the morning arrival based on students coming this way. This staff person would be directing them this way, and then during dismissal, they would be stationed here and directing students away.
Okay, just keep going straight, don't
Right.
don't take that. Well, you wouldn't anyway, because it's a long way to get to the bus stop.
This is
Right.
the most direct path of travel, but just in an abundance of caution.
We like abundance, okay. Does that answer your question?
That answers my
That was the
question.
only one, and didn't you also talk
Well,
about coming?
I still have a concern with regards to that intersection on Vernon, 9th, and 44th Road. It's kind of a very weird set of intersection, and you have the city bike right there.
Right.
There's a hotel right there, there's a lot of drop-off pickup that's happening around the area, so just want to make sure that the conflict between the travel path of the students and the rest of the activity is minimized. Also, across the street is the Board of Ed's building where there's a lot of delivery happening, so.
Yeah, right.
So I just want to, can you walk me through as to how that you would assure that through this proposal?
So are you speaking to, let's say, the eastern leg over
Right,
here?
so
and
those students will be coming from the south on Vernon Boulevard.
Correct.
From the bike rack, basically,
Right,
right?
and from the bike rack. So that intersection is still, to me, not clear as to how you would prevent that crossing.
As of right now, we have not provided, we would be, or the school rather, would be requesting crossing guards at this location and this location. We felt just based on the primary points of collection where a majority of students are anticipated at this intersection and then at this intersection, because we feel this is stop controlled, partially stop controlled, and this intersection is fully signalized, that because of this intersection is fully signalized. And just to put it into perspective, there was some shifts in the building and some shifts in routes of pedestrians. I have looked at probably upwards of 40 intersections in the whole neighborhood of Long Island City here, reviewed crash data, reviewed intersection controls. For this intersection and this intersection, they are proposing to do all high visibility striping where there's currently not, as well as the northern and southern leg of the intersection of 44th Avenue and 10th Street.
So, question though, so if they're coming from the south, they happen to be, so we talked, Commissioner Shanda yesterday was talking a lot about the change in the neighborhood as it's becoming more and more residential, and there are more and more people who will be coming from other places than kind of what's the current state of affairs, right?
Right.
So if there were people coming from the south on Vernon, so you're saying that there is a stop, because there's a traffic light there, but wouldn't where is the traffic? So really what you want to do is be on 9th. As a student walking, you would be kind of cutting that to 9th Street and crossing 44th Road.
So my concern is how will you prevent somebody not walking along Vernon?
Yeah, exactly.
Here, for instance, we evaluated not only curb extensions at all four corners, but there actually is, under existing conditions, a pedestrian ramp here. We're proposing, on one hand, to remove that pedestrian ramp because it provides a false sense of security and enables people, or encourages them, rather, to cross through this leg. We would just have that there. And with a steward here, in combination with potentially, the stewards that are manning the bus drop-offs and pickups, we feel that this would ensure that
But
students would
that's
be
not
directed this
the
way.
natural way that a person would cross. You're always, you see where you want to go and you go for it, right? So wouldn't you be going on, whatever that's actually called, that's sort of like an extension of 9th Street, and you cross 44th Road to get to the corner of the school building, right? So you're saying you're trying to discourage people from doing that, but it's the natural way to go if you're coming from the south.
I think I think you're pointing at the school dismissal, and we're talking about arrivals.
Yeah, we're talking about arrivals.
Arrivals.
Oh, that's a good point, yeah.
So you mean during arrival?
There's, behind you is...
Right, so during arrival, we have somebody coming from the south. You're saying that you're trying to discourage them from making this movement?
Or not discourage them, deal with it,
Deal
because
with
it's
it.
what's going to happen.
Understood.
So that's why it's kind of one more crossing guard or something.
Yeah, I
there.
think that the school would be willing to provision somebody then. During arrival, we can show that and amend the safety
Okay.
plan
And we
accordingly.
also have a what is it called? The crossing, indicate the crossing on the 9th and 44th at that
Say again?
intersection.
Oh, indicate that it is a crossing
It is a
intersection.
crossing.
Yeah. On your drawing.
Unless you want to prevent that completely.
We wouldn't want to just encourage it, so there would be a safe routes to school protocol at
So you're saying
commencement.
you will
and-
have a guard who will monitor and ensure
Enforce
that crossing
Correct.
just does not happen.
That's,
David?
yeah, if you speak, you have to be at the mic. But I don't understand, how do you discourage natural pedestrian flow? That's the part I'm not understanding. If I park one of my bikes, and I park right there, and I step behind the bike rack, obviously, the way to get to school is straight, beeline, crow's line, et cetera.
So the school is willing to employ another steward
Yeah.
at this location, and then the
Right.
steward would be there to direct them cross through a signalized leg of this intersection.
Oh, so they would force them to go
Force
the
them.
long way around?
Correct.
I'm trying to understand, why don't you want them to cross the short way?
Because it's an uncontrolled leg, I don't think that it's going to trigger any kind of stop control or anything further than this. So to have students crossing through the middle of the street with no leg and no...
But is it the middle of the street? It's
Right, I have
get
a
that.
question. There is a stop sign there.
The stop sign...
Microphone.
The stop sign is right here. So this coming out, this is a one-way, right? This is stop controlled. Coming up to this approach
There isn't a stop.
is signalized.
Right, but before the signal, isn't there a stop sign and there is a white line that's drawn on the ground for vehicles? I think if not, I would recommend, that's an
Yeah.
easy solution, to have a stop sign or a mark on the ground that says stop for vehicles, so at least they are alert that they have to stop there before they get to the red light.
We can coordinate.
Because there isn't enough of a space in between that for a vehicle to stop.
Understood.
That's the point. Like to get to that stop sign,
Right.
and in between, it's just wide enough for one truck.
We can coordinate
So
with
I'm just-
DOT school
Yeah,
safety
if
and discuss with them and see what they would want us to look
Yeah,
at there.
if they can look into that. The reason I'm saying is that then otherwise you're looking at a truck coming very fast and then will come right to the stop sign. And I don't think you want that. You do want to make sure that the truck is somewhat watching where the students are going before they come to the stop sign.
And a part of that is the proposed curb extensions here, because it does slow vehicles, it does improve student visibility, ensures crossing distance of students, so that is, the purpose of these curb extensions.
Yeah, I'm looking, there's no stop sign,
Yeah.
there's nothing, according to,
Yeah, I don't remember.
yeah, no.
Yeah, but if you put a stop sign, you have to go to a different
See,
division.
there's nothing on either
Yeah,
side.
they would need to put a stop sign there, it's my understanding that they would need to do a stop warrant analysis to look at the existing and with action volumes of traffic to see if it's warranted. And my guess is, based on the existing volumes, that it likely wouldn't trigger A stop control, and then we would have students crossing through an uncontrolled leg of the intersection. I just feel like it's a little bit, rather than just proposing somebody here to steward it, I think that's probably a safer option.
Okay, well, it's something to discuss with DOT because, with school safety, because I just know humans take the path of least resistance, kind of, unless someone is really standing in the way, saying, don't go there, or we'll give you a demerit on your report card, right? So why wouldn't I go that way?
So we'll speak with DOT School Safety and get back to the board with a written submission.
Great, okay, thank you very much for this. Okay. I think that was basically it in terms of the intersections, right? So then we had some other questions.
Amber, do you want to pick that before somebody falls all over it, including you?
So there were some other comments from the board yesterday. Let's bang out the really easy ones. The second floor roof access, there is no second floor roof access except for the maintenance of the building. There's no seating, there's no gardens, just a roof. There's no IFAS. The building is brick. At the second and third floor, there's a metal panel with brick. The cladding.
So say that again, it's a metal panel and what?
Metal panel with brick, but there's no IFAS on the...
No IFAS, okay, great.
And the point of potential interaction between school children and warehouse employees, you'd mentioned the shared egress corridor. So I'll refer you to A201 of the plans, just so we know where we're looking. So if you're, that's loud. If you're looking up this shared egress corridor from the gym, this is your view now of what's there. This picture was taken yesterday. As you can see, there's a column, there's a door, there's a bay door here, and so we actually don't have the room to put in a parallel egress corridor. Also, because the loading berth by code needs to be accessible by all the warehouse workers, there has to be that avenue. One thing we did notice...
There has to be that what?
There has to be at least the potential for access to the loading berth for all of the warehouse spaces. We did notice after reviewing your comments, however, that there is a door here from the northeastern warehouse that can be relocated to the other side, can be relocated here, so that we will eliminate that door into the egress corridor. And what we would propose is that during any fire drills or any drills where students would be accessing this emergency corridor, which is required because this is a public assembly space, the corridor would be shut off to non-students.
But you can, it's a required means of egress.
Well, just during the fire drills. There would be, during the fire drills, we would not allow...
Still a required means of egress.
Right.
How do you do that? What happens during a fire, if there was a fire drill during a fire? Just saying.
If there was a fire drill during a fire, then there would be, we rely on the security cameras and the school staff. We could not think of any way to engineer around this that's already built.
So you're saying that you have a column in the corridor.
We have a column, we have a bay door here at the end that's already constructed.
What about if the bay door swung in? And what if the corridor on the left side of the column went down along the left side of the column, and before you get to the bay door, which I can't really see where the bay door is.
So, I'm sorry, Madam Chair, you're suggesting putting a parallel column that would sort of eat into this warehouse space here?
Yeah, exactly.
That,
And then swing it in, or frankly, move the bay door.
well, I don't believe the bay door can be moved because of it's already been constructed, and that still wouldn't address the issue entirely, because this warehouse space would still have to cross over to get to that that parallel column.
Why does the warehouse space have to cross over? I don't understand that. Why does the one on the right have to do with anything on the left?
Because these warehouse spaces need to be able to access this space because of the loading berth. And so...
Oh, but so according to that, but they all have loading berths. That's the part I don't get.
They all have bays, but they don't have a loading berth.
So that one on the right is an official loading berth?
Correct.
And the others are bays?
Correct.
Oh. So then that reinforces what I'm concerned about. This isn't an egress route, this is an access route to the loading bay, so that's going to be used all the time by the commercial user.
Yeah.
Yeah.
So the applicant would like to speak to that, but
Yeah,
I
yeah.
believe it is not going to be used at all, but of
Okay,
course-
so let's, yeah.
All right, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
Yes.
Go.
Hi.
Hi. State your name, please.
Sorry, Scott Barone, Barone Management. So the term loading berth is a code definition, and buildings with an excess of 25,000 square feet of commercial space in this use group have to have a loading berth by code. So for DOB, it technically has to be accessible to everybody else in this commercial space. In practice, it won't be. This is going to be an independently rented warehouse. But we need to theoretically have the ability to access from here to here. With regards to swinging the corridor further out, because of the construction that's already in place, if I was to swing this out over and around, the ability of a truck to back in cleanly is going to be inhibited because you're going to have the corridor in the way there. So we've just, with all the changes to the building, we've gone beyond a point where we could change certain things.
What if,
Oh, okay.
just throwing out ideas, what if instead of egressing to 44th Avenue, your egress corridor, your actual egress corridor, as opposed to this sort of convenience one that you say is not going to be used, egresses to 9th Street? So you build a corridor parallel to the bigger truck dock, go right out to 9th Street, see what I mean? Perpendicular, that one, right there. And then that becomes your means of egress for your commercial businesses. And I understand this whole thing about DOB, so it'll just look like what you're supposed to do, but that way we would know that really only for egress purposes would the school be using that route from the gym and from their staircase. A little bit of a corridor, no big deal, you know? Wouldn't mean much construction.
No, but
Chipboard.
Well, the way, and specifically the way we've gone through developing, because this building, we got IDA incentives, all right, so they want to promote, commercial growth. We're not to market yet on this space. One of the goals that IDA really liked and we liked is the ability to tandem off. So you've got flexibility where if somebody rents, let's say, 2,500, you could connect to this warehouse or connect like this. If we bifurcate that and split it down the middle, I've eliminated the connectivity because I have to keep the means of egress corridor in place. It's not ideal. I would remind you that in the prior iteration, we had 4 connection points like this where the school and the office could have, or the commercial tenants could have interacted somewhat. We've really just got it down to one spot, which we've already spoken with the school, where the plan is, in the event of a fire drill, they are going to man that. This corridor would be alarmed by practice, as in the door would be alarmed by practice, and it's got full camera, which the school does have full-time security with cameras at the station. It's a low likelihood, plus the building, the fire alarms they have to be interconnected to speak to one another, but they're going to have separate addressable panels, all right? And so even in the event that the school was running, say, a fire drill, so it's not going to disturb whatever's going on in the rest of the building. Fire drills are scheduled, they know they're going to have the ability to put somebody there. It's not ideal, but it's a thankfully vast improvement over what we had before.
Yeah.
And, we've just gone beyond construction.
No,
at a certain
agreed, you
point.
made this a much easier application by your changes. Yeah.
Thanks.
Okay, so then I have a question for the school. I don't know if the school rep is here. Thanks.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? I do.
State your name.
Yes, Mark Crisante, I'm the Director of External Relations for our Old Neighborhood Charter Schools.
Great, thank you. So my only question, which you may not know the answer to because it's more of an operational question, but is the gym going to be used for sort of sporting events or assembly or anything like that, where you have lots of parents coming or other kids from other schools coming?
The gymnasium would only be primarily used for our school students and our parents. It wouldn't be other schools or other networks.
But it might be used for, say, watching a basketball game or watching maybe a performance,
Yes,
something
ma'am.
like that. So my question is, in the event of a performance and letting people out during the day, I'm not concerned really in the evening about this, during the day, in terms of egress from that gym, to just let people out, right? Would they be going out through that back door or only out through the main lobby?
It would be the main lobby.
Okay, so that's something we should include in the operational plan, that for events that are being held in the gym, egress should always be through the main lobby, and that route is for emergencies, not for daily operations. We often see that, like with movie theaters, you end up...
It's going to have a panic bar as well with a
Okay.
alarm on it inside the gym, so if some kid decides he's going to go home early on his own, it's going to ring as soon as it goes off.
Okay, good. So please include that description in the operational plan. Okay,
Yes, ma'am.
thank you very much.
Thank you.
Any other comments, questions from commissioners? Okay, so we don't have sign off from school safety yet. That's really the issue. Open, I think?
There are also,
Right?
there are also secret items we're waiting for sign
And
off on.
seeker, yeah. What were the open seeker? We had open air quality, noise, DOT, and school safety, right? Okay, so we can't really do much with, okay. Are there any speakers on this? No? All right. How much time do we think we need for all of those things? Any idea?
Respectfully, we don't want to waste the board's time. The staff has been tremendous on this project. We really appreciate it. So rather than, ask for an earlier hearing that we're going to have to adjourn, we were thinking December 17th. We think we'll be able to get everything back to any of the agencies that requested of us. We're certainly going to prioritize it.
Great, okay. Makes sense.
Okay, so a submission on November 27th and continued hearing on December 17th.
But as with all environmental review projects, that's more formal because we're not expecting anything else except maybe a revision on the operational plan. So the back and forth with the various agencies should be constant.
Yes.
And if we got to sign off pretty literally on the day before the hearing, that would be fine, Okay.
Thank you.
Great, thank you very much.
Item number 29, 2018-168 BZ, 1769 East 26th Street, Brooklyn. Raise your right hand. Okay, you sign it, sorry. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
Good afternoon, Lyra Altman from the office of Lyra Altman. We had somebody attend your executive session yesterday, heard your comments.
Ms. Altman, pull the mic a little bit.
Yeah, you can't hear you.
This better?
Yeah.
Okay. We had somebody attend your executive session yesterday, heard your comments. We also spoke with some of the neighbors, and we understand the concern regarding the height, so we have agreed already without even discussing the height with your board. We did some research on the block. What we saw was on our side of the block, on 26th Street, 7 houses are already 31 feet in height, another 3 are 30 feet. When we looked at the opposite side of 26th Street, of the 22 houses, 7 were 31 feet or greater, and another 7 were 30 feet. Some of them ranged up to 35 feet, including the one almost directly across the street. So what we've done is we've reduced the height of this building.
Tell the truth, you're watching video. Okay.
We've already reduced the height of the building to 31 feet.
Sorry, say that again?
We've already reduced the height of this building to 31 feet, which is more in keeping with what is currently on the block. In addition, we've added on the calculations, a calculation below the planting chart as requested, and we got rid of what you referred to as a flying number, which was that 7 foot. I've already received these plans. We've gone through a number of revisions. I would like another opportunity to review them just one more time to make sure that there is nothing that could possibly be found, although I have gone through them. As you can imagine, the last set came in at 11 o'clock today. I haven't been able to review them on paper.
Okay. Okay, are there any speakers on this?
You have some neighbors?
Yes, please.
Yeah, you want to give it to me? No, you don't have to be
No,
sworn.
you don't have to be sworn
You can
in.
sign. You can sign when you come back. Okay.
I'm sorry, actually.
No, that's okay. Are you going to read from that, or you want to give it? Okay, fine, then you can give it to me later. You'll have 3 minutes, as I said.
All right, okay, it's not going to be long. So,
State
I'm a
your name.
neighbor, Evgeny Appelman. I live on East 26th Street, 1763, right next to the proposed...
Adjacent to, not behind.
Adjacent, yes, across the driveway. So, basically, when I learned that about the plan, it obviously made a lot of... it's been very different than we discussed with the owner before, and obviously it makes me oppose the whole plan because two reasons. First is the size of the building. The proposed plan puts a huge building in a small lot where, first of all, the height of the building is going to be over the roof. It's going to block my entire house. The proposed length as well is close to 30 feet extension. It's going to go right through the backyard and block everything on my right side, which is unacceptable. So basically, it's some sort of hotel, not the house, on the block.
So they're going to be reducing the height of the building because we instructed them to do that. I believe, without being able to look really quickly, that your house is somewhere in the 30-foot high range. Your 2.5-story house, right?
Mine is the same as all other buildings. I don't know where they found 6 buildings over 31
No,
feet
but
high.
so let me see, do we have that front study?
If you look in the front of the building, mine is on the
Yeah,
left.
so are you 1763 or?
Yes,
Yes?
1763.
So according to their information, your house is 27 feet high.
Okay.
Okay, and they're going to be reducing the height of their building to 30 or 31 feet high? So that's
I don't
only...
know that. I'm
No, that's what they're telling us. Okay? But, and you're right, that the current drawings show it at 35 feet high. So we're asking them to bring it down by 5 feet, right? So at which point, their building will be, 4 feet higher than yours, as opposed to basically 10 feet higher than yours.
Well, okay.
So that's one place.
Fine, so,
Okay.
I mean, okay, I'm not going to agree with that, but regardless, if that's the plan, but still,
That's what
I'm
they're
objecting.
proposing, I just
That's the
want you to,
proposal.
okay.
Okay, so my bigger concern, okay, the height is a concern of the neighbors, and I have letters from 2 neighbors across the street who objects the whole, I mean, the way the height and everything.
Mhm.
I have an objection from a neighbor who lives behind the building, who is concerned about the extension of the building into the backyard, because once it's going to be completed, then basically the building is going to be right next to next to the property line, very close.
Well, actually, their rear yard, so they're here for certain kinds of waivers, and originally they wanted to have a much deeper rear yard, much deeper building with a very shallow rear yard, and we directed them to have almost a rear yard that complies with the zoning. The zoning requires a 30-foot rear yard, which they could do without asking.
Right.
Right? And we asked them to increase the size of the rear yard from what they proposed to 27 feet. So that's 3 feet less than what's required. So in other words, it's a much bigger rear yard.
I mean, okay, in terms of footage, I'm not sure, but the point is, look, if the building is going to be built the way it's been proposed,
right,
or close to it, it's going to be completely out of character,
right,
whatever the neighborhood looks like. So if I look from my backyard, there are some houses that extended in the backyard, and as you just said, it probably in compliance with the zoning. So
Maybe,
maybe,
or not.
yeah, exactly. We don't know.
We don't know.
So if they do this, that's going to be fine with me. But what I see is additional at least 10 or 15 feet into the backyard. So they're going to actually be very close to the garage itself. Like they have a garage and the driveway, and it's going to be just right there, right in front of the garage. I don't know what they're going to do with it, just how they even going to like use it, or
Okay, I'm just.
are they going to
looking at what-
demolish the garage? I'm not sure.
Okay, so the proposal that you may have looked at before, which they submitted to us in March,
Okay.
is different than what we are looking at now. So if you want to understand what they're actually proposing, so you're talking about the same thing, the applicant
Okay.
will give you a copy of the drawing,
All right.
so at least you can all be aware of what it's really going to look at, like, right? Because originally it was a 24-foot yard with, plus a porch,
Yeah.
and now it's a 27-foot yard, so it's a deeper yard, no
So
porch.
it's 3 feet difference?
It's bigger, it's almost complying. The law is 30 feet. We have the authority to waive it to, down to 20 feet. And we said, in response to the neighbors, pull the whole thing back to 27 feet. So it's 7 feet more than what they normally could ask for.
So, okay.
Okay? So, but they'll give you a copy of the drawing so you can understand
Yeah, I
better.
can understand that.
And the
Okay.
garage, and the garage is not, the garage structure is proposed to be removed.
The garage is going to be removed.
Yes.
All right.
Yeah, okay.
Okay, so my another concern is with this type of construction, that's like very costly construction, obviously. So basically, it's like you building brand new house there. I did mine, it cost me a lot of money, but I didn't file for any deviation or anything like that. My concern is that what's gonna happen if they run out of money, for whatever reason, they're gonna freeze this thing, it's gonna stay like this, because this is like really, really expensive
Yes.
thing.
So.
The way I see it's like they're not really like doing maintenance there much and stuff like that. So it's not, if they're referring to the house across the street, yes, they're like, there's a millions of dollars there, but here it's a little bit different. So this is my concern. I don't know how you
Right,
you
so
wanna
we
approach
don't,
this, but
you
obviously
know,
you don't.
we're not a bank, and we
Right.
don't lend money, and we
But I'm
don't
saying-
control this part of it. Yeah, right, well, the special permit, you're right, it's valid for 4 years, but then they could come back for a renewal.
Right.
So, except in
So
one
if there is a
area.
there is a reviewed renewed plans, the plans that been changed, I guess, since March.
Yes, so that's what I wanted to say. So, their lawyer will give you a copy of the plans that are currently proposed, no, not currently.
I said, what I can show him is the draft that I have in my pocket, I'll show him now, which obviously we haven't submitted to you yet because we haven't checked them all, but I can show him just so he gets a concept of what we're
Okay.
revising the plans.
That's good. So that's including, Ms. Altman, that includes the 30 or 31-foot height,
Yes,
right?
yes,
Okay,
of course.
good, okay.
And it's
Good.
already, the image has been lowered as well, so he'll see a proper scale.
Okay, okay, that would be helpful. So at least you're informed about where we've gone, okay? Thank you very much, sir. Appreciate you coming. Are there other speakers on this?
Yeah.
No other speakers on this? Okay. So to give you time to work with the neighbors, and just in case there's anything else you can do to work with the neighbors, I encourage you to do so, because as you know.
As I said earlier, that was one of the reasons that we lowered it. We started working on lowering this well before yesterday's executive session. Last week, my client became aware that some of his neighbors were unhappy, and these plans have been in the works since last week. That's why I already have them.
So, and as you know, neighbors can often slow down a project indefinitely, so I really recommend you continuing to meet with the neighbors on
Absolutely.
all the sides and come to some reasonable response to their concerns. But I do appreciate that your owner is willing to make the concessions they've made so far.
He did.
Okay.
We tried to see how low we could go and still maintain some space in the attic, because he's not able to enlarge back as much. He just needed the extra bedrooms.
Okay. Okay, so then I'd like to put this on also for sometime in November, because to give you time to...
Would it be possible to do November 19th?
Can we do the following week? I think we have too many applications.
Okay.
We're going to do the following week.
So November 6th submission with a November 26th hearing.
Thank you very much.
Thank you.
Item number 30, 2018, 171BZ, 1 East 70th Street, Manhattan. Gary, you're the only one speaking, Mr. Tarnoff?
Yes,
Okay.
initially.
Initially. In other words, you
Raise
never
your,
know.
raise your right hand. This is for Frick? No, not you, man. I'm sorry. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Thank you.
Good afternoon, Chair Promoter and Commissioners. My name is Gary R. Tarnoff from the law firm of Kramer 11, Nefthaus, and Frankel, appearing here today on behalf of the Frick Collection. Representatives of the Frick were at the board's executive session yesterday. I watched
Mr.
it.
Tarnoff, you want to move the mic up just a little?
Yeah, it's actually a little hard to hear, yeah.
I watched it on video. The board didn't identify any issues that it would like the Frick to address today. So I'm not going to speak to any, except to address two issues that were raised by the last submission of Hiller PC that were not discussed at the executive session.
Okay.
And I'll try and do that briefly. The first is an allegation that the Frick management apparently, so I'm quoting, apparently plans to expand the special event banquet division of its organization. This is speculation. There is no special event banquet division of the Frick Collection. The Frick does provide a membership benefit to members who contribute at a certain specified level, allowing them to have one event at the Frick during their annual membership. They're responsible for hiring and paying for any personnel that or vendors that are necessary for that event. There were 12 such events in fiscal year 2019. The Frick has absolutely no plans to change that benefit. It's also contended that doing that is not permitted by zoning. We submit that that is a permissible accessory use to a museum. It's clearly incidental and customarily found with museums in New York City, such as the Guggenheim Museum, the Metropolitan Museum of Art, Cooper Hewitt, the Jewish Museum, the Morgan Library and Museum, and others as well. It's being done on the site for the benefit of its members and visitors.
I'd like to add, I've been to many events at the Morgan Library, unrelated to the Morgan Library specifically. They're fundraisers for other purposes, so, Christmas parties.
Okay, the second issue is there's a allegation that there is a limit of 50 persons in offices under zoning at the Frick Collection. I think Hiller PC is misreading Use Group 3 of the zoning resolution. There is a category of Use Group 3 called nonprofit institution with sleeping accommodations, or which does have a limitation of 50 persons in central office functions, but the Frick is not classified as a nonprofit institution with sleeping accommodations. I don't believe there are any sleeping accommodations at the present time.
Isn't it all?
It's a Use Group 3 museum, and there's no such limitation.
It also applies to non-profits without sleeping accommodations,
That's
I
correct.
believe,
That's Use
but-
Group 4, and it applies to that as well, but our classification is as a museum, and there is no such limitation. I don't have anything further.
Anything else? Yeah, I'm just looking at libraries, museums, or non-commercial art galleries are a separate use from wherever that one is that says nonprofit.
It's further
Nonprofit,
down, I
something
think, on the
else.
list.
Yeah, I don't know, didn't find, okay. Oh, philanthropic or nonprofit institution, oh, that's the one with sleeping accommodations. There's also use group 4
Correct.
that has nonprofit, philanthropic or nonprofit institutions without sleeping, where they limit to 25% of the floor area for central office. Right, okay. Anything else you wanted to add?
I don't have anything to add.
Okay, all right. So, and then the only other issues which we talked about yesterday are open environmental issues. That's under review by the various environmental agencies at the moment. And we cannot close the hearing until we've had the full review with giving a hard look at all those areas of environmental concern, which is in process at the moment. So I would like to move to public testimony, but only with respect to environmental considerations, because the board has already spoken yesterday that it agrees that the programmatic needs analysis provided by the FRIC supports their request for the various waivers, and that in spite of the many submissions of alternative plans by opposition's architect, that the board was not persuaded that those plans would satisfy the programmatic needs, which we find to be reasonable, expressed by the FRIC. And this is also based on the board, everyone, all the board members' visit of the FRIC and being taken into kind of all of the underground and strange areas where their staff works in the strangest, the most cramped conditions, and it's very evident that they must make these changes in order to continue to function. And also, I had the pleasure another time of having a meeting in the second floor with all the glorious rooms on the second floor that are not open to the public, and the idea of those rooms, and for clarity, those rooms are going to be restored, the way I understand it, to their original condition, where historic preservationists are looking at like the wallpaper that was originally there and the moldings that were originally there, and it will be restored to that state. And what is there currently is actually a modification that was made in the 70s, I think, to be sort of historically 70s, as opposed to actually a historic restoration. That's my understanding of it, and it's one of the questions that was raised, whether those upstairs floors would be turned into what was described as institutional gallery space. The answer is no, they will look like the home. Correct?
That's correct.
Okay. Okay, so if the people would like to, if members of the public would like to speak solely on environmental questions, because we've already had hours of hearing on other issues that have been, that the board has decided has already been addressed. All right.
Do you want to have any electeds?
Are there any electeds here who would like to speak? Yes, okay, sorry, elected. Are you the only sorry? Are there any elected officials who would like to speak? No? Okay. Go ahead. State your name, please.
This is Michael Hiller PC. I just want to get a clarification. Will the board be hearing from organized opposition?
Yes, but with respect to the open environmental issues.
Madam Chair, we came here today with the purpose of doing two things. One, speaking to an environmental issue, which we consider to be very important. And the second is to address the chair's comments and comments from the board with respect to the plans that were filed on July 3rd and to which there was not a response by the FRIC. And so with the board's permission, I think it's very important that Mr. Halpern be afforded the opportunity to explain why it is that the programmatic need assessment that's been provided to the board by the FRIC is satisfied by the adjusted plans that were filed on July 3rd. And he came here today with the presentation so that he could provide that to you, so that you would have the opportunity to see it.
So we've already reviewed those drawings. They were submitted to us on July 3rd, right? And we looked at those drawings in comparison to both the Frick's architect's comments about the last set of drawings, and also in comparison to the Frick's own programmatic needs analysis. And yesterday at the review session, made our comments about the the July 3rd submission, and found that we didn't think that it satisfied the programmatic needs that we understood are the actual needs of the Frick. And I also stated, and if you listen to the review session,
Which I did.
I also stated that in understanding, because I have great respect for Mr. Halpern's work, that he's not the architect for the project, and as such, he can't possibly be privy to all of the field conditions, program issues, for instance, meeting with the conservators and finding out what their needs are, and finding out whether this space is properly adjacent to or high enough for, and so on. And so this idea of using an alternate set of drawings and saying, go with those, actually doesn't work unless it was a very specific suggestion. For example, change this to this and move this here, and then that's sort of the end of it. But what we're being asked to do is look at a set of plans that throws the entire proposal by the Frick up in the air, like throws it out, and says, use mine. And we can't do that, right? And so we're not able to do that, and it's also possible to review the Frick's programmatic needs analysis and say, well, that's not meeting that adjacency requirement, et cetera. So we did conclude that the July 3rd plans are not solving the Frick's programmatic needs.
The purpose of submitting the July 3rd plans was not to, in a sense, ask you to throw out one in favor of the other. It was to show simply that a more minimal variance is possible, and therefore the applicant cannot meet 7221E of the zoning resolution. And so our purpose in providing those plans was to show you this is another way to do it with a lesser with several lesser variances. And the reason why Mr. Halpern came here today was so that he could address the board's comments that were made at the public review session, precisely because, as Madam Chair, you said yesterday, that there were adjacencies issues and there were programmatic need issues, although the applicant hadn't responded to our plans. And I would respectfully submit that if Mr. Halpern would be able to afford the opportunity to go through those adjacency issues that you raised, you would be, in a sense, you could be persuaded that 7221E cannot be met here because there is a lesser variance plan that could work here. And without that, I don't know how we can...
So you're actually making, you just stated again, that our proposal, as in the July 3rd proposal, is a better proposal than the Frick's proposal and will satisfy all the programmatic needs. You're not saying that, so therefore, we would have to look at that set of drawings, which we did, and conclude, as you would like us to conclude, that that set of drawings meets the programmatic requirements of the Frick, and we did that and concluded that it didn't meet their requirements. And the other thing that I do want to raise is, not to consider this application completely in isolation, in a vacuum. The Frick has been at this project for, I don't know, 6 years, 8 years, something like that. And there was a much larger project proposed in 2015, and Mr. Halpern participated in a proposal way back then that looks very similar to the proposal that we see before us. So I think I think the Frick has come a long way in pulling back from what originally it wanted to do in respecting the garden, in respecting the amount of addition to the existing buildings, in responding to the concerns of the community. And the only real difference between Mr. Halpern's proposal and the Frick's actual proposal is 1 story on the lower portion of the building and some depth on what's being added to the library, which is a very minimal addition. I think it's a 19-foot addition to the front of the library. And the idea of having a little bit less added here and a little bit less added there, and not fulfill the programmatic needs of the museum that's been around for almost 100 years, seems unreasonable. And then I added yesterday, I don't want this project to go the way of the Whitney Breuer, where finally the community whittles down a project to such an extent that then the museum has to close down. That doesn't serve the community.
Madam
Right?
Chair, I listened to your testimony, your comments yesterday, and I recall what you said about the Whitney, and what concerned me about that is you talked about crunching the project to the point where the museum could not function. And what troubled me about that, and which is something I wanted Mr. Halpern to talk about today, is that actually the square footage of Mr. Halpern's alternate plan is actually equal to, and in some respects, greater than what's been proposed by the Frick, so there is no crunching down. Now, I'm not, to be frank, I'm not competent to address that. Mr. Halpern should be talking about that.
Okay, so we're not going to do this, but I wanted to say again, for the record, and as was said by the architects who submitted on behalf of the Frick their response to the last version, numbers aren't what you're going for. It's functionality and adjacency and adequate ceiling heights and handling this very strange mechanical crossovers and so on that exist in the subterranean levels. And just because you hit the floor area, or let's say the gross floor space, doesn't mean you hit the solution for programmatic requirements in an existing building where, again, an outside architect can't possibly be aware of all of the intricacies. And I think we've covered it. I feel like that's the circle. I just completed the circle. So I would like to take any other kinds of testimony related to environmental concerns or move on.
If the board isn't going to hear it, there's nothing I can do about it, but I would submit for the record that we had more things to say about that today. I'm going to be speaking about...
Do you want to say something?
I don't believe that...
Pull the mic.
I don't believe
closer.
that if you're under the impression that you can keep submitting new plans and making new arguments every time those prior plans are proven not to work, that's not how it works.
Well, I'm not suggesting that the last set of plans doesn't work. I think that if Mr. Halpern were afforded the opportunity, he could walk you through it, and he could persuade you that it does work. I understand that the board is taking the position that it doesn't. I would only say that after we submitted our plans on July 3rd, the Frick did not submit any response because under the briefing schedule they weren't going to. So there really was no response from the Frick that said, for example, oh, these plans, which changed, don't meet our programmatic needs. That's an assessment that apparently members of the board did on their own. But I would have wanted Mr. Halpern to go through that with you. I understand your position, and obviously I'm not persuading you guys to change your minds, although I'm doing my best to try, Commissioner Scabetta. I just think it would have been a helpful exercise for us today to do it. If you're not going to hear that, I'll just turn to the environmental issues. The environmental issue that I came here to talk about today, that I was prepared to talk about today, and that pertains to the music room. During the review session, Madam Chair, you said that the words you used were something to the effect of, we all wish we could preserve the music room. And I took your...
No, I didn't say all. I, personally.
Okay, if I missed...
I don't speak for anybody else.
Well, then I'll address my comments directly to you. I think you can preserve the music room, and here's how you can do it, because it is covered under SECRA and SEEKR. Yesterday, you indicated that the BSA had referred to SHPO and LPC the issue of whether the music room is worthy of protection, and both agencies indicated that it was not worthy of it. You also indicated that the BSA, in any event, lacks jurisdiction to consider whether to retain the music room because it was not the subject of a specific waiver requested. I don't share that interpretation, and I want to give the board the opportunity to, or at least Madam Chair, you the opportunity to try and save the music room today. First, with respect to the LPC and SHPO, you said, and I quote, "We reached out to two agencies that are experts in the subject of historic preservation, and they advised us that the music room does not rise to the level of something that would need to be individually protected." With respect to SHPO, you referred to an August 26th letter, which you described as follows. The building, the Frick, is listed on the state and national register, and as such, it is considered as an entirety. In other words, such listing does not distinguish between interior and exterior landmark status. However, unless the building requires state or federal permitting, licensing, or funding, no restrictions are placed on its use by the state or federal agencies in charge of that project. Now, I read through the August 26th letter, and to me, it appeared you were referring to 2 paragraphs of that letter and combining them in that thought. And the first paragraph to which you referred is actually states as follows: the listing of a building on the state national registers and designation of a National Historic Landmark covers the entire building inside and out, which is similar to what you said. No distinction is made between exteriors and interiors for listed buildings, also similar to what you said. But then it continues, the whole building must be considered and significant features identified. In the next paragraph you appear to refer to, this is a really important one. The language is as follows: under both federal and state historic preservation laws implementing Regulation 106 of the National Historic Preservation Act, the listing of a property in state and national registers or its designation as a National Historic Landmark places no restrictions on what a private owner may do with their property unless the property is involved in a project that receives federal or state funding, licensing, or permitting, which is what you said, or requires review under SECRA, which you didn't say. And that's critical, because we all know here that SECRA review is required. So there are restrictions that can be placed on a private owner in terms of what they can do with their property, and that makes sense, because under the SECRA Technical Manual, Section 160, it specifically says that all properties listed on the National Register of Historic Places, and the Frick is such a property, are always considered historical and cultural resources. And since the National Register does not distinguish between interior and exterior spaces, and it must be considered as a whole, that means the music room is considered a cultural and historic resource. And with respect to that, as SHPO pointed out in its letter, the whole building must be considered inside and out. I do take issue with the notion that the SHPO said that the music room was not worthy of protection. I've read the August 26th letter several times. I don't see any language that says that. What I do see is language that says that SHPO believes its jurisdiction to comment on the music room, and it lacks jurisdiction because there was no state or federal funding involved. You see, SHPO's jurisdiction is limited by whether or not there's federal or state funding, but your jurisdiction is dictated by whether or not it also has the additional consideration, which is SECRA. So when SHPO responded, they said they could not answer you. They said they could not comment. Quote, absent state or federal involvement, our agency has no jurisdiction for making comments on the proposed undertaking. So the SHPO did not say that this is not worthy of protection. They said that because there was no federal or state funding, they couldn't offer an opinion on it. And as I said, because you have the opportunity under SECRA to protect cultural and historic resources, you can protect the music room, or at least investigate whether or not it meets the low bar for environmental review under SECRA, and that low bar is whether or not the proposed project may have an adverse impact on the environment, which includes these 21 different categories, one of which is cultural and historic resources. Now, the question as to whether or not this is a cultural and historic resource, or an important one, I think is an easy one. As the Observer wrote in 2017, since 1938, the music room has been the host of one of the most distinguished music series in the world. In fact, the Frick thought so much of the music room that it has kept track and meticulously documented every single performer and every single performance that has ever been performed at the music room since 1938. And I think it's important, in addition to that, that each of you, oh, and by the way, some of the artists we're talking about are people like Arthur Schnabel, who's considered one of the greatest pianists in the 20th century, Isaac Stern, who I presume you all are familiar with, and Gregor Piatigorsky, who is considered one of the greatest string musicians of all time. And aside from that, I know that you went to the site visit because I was with you and I saw you, but I'm sure you all remember that you weren't allowed to get into the music room.
It wasn't not allowed, and anyway, it's open to the public. I've been to the music room.
Okay, I don't know if the rest of the commissioners have, but I actually have pictures, which I'm glad to provide to opposing counsel. May I?
Mm-hmm.
This is the room. This is the room that the Frick is planning to demolish. And as I said, you weren't able to see it on the tour because you were told it was being used for something else. I was since provided with a picture. There were just a few boxes in there that day. You could have seen it. I genuinely believe they didn't want you to see this picture, this room. This is the room. This is the last salon space left in New York City that provides this type of experience. And the question that you have before you, simply put, is whether or not the proposed project may have an adverse impact on this cultural and historic resource. Now, I also know, Your Honor, Madam Chair, you suggested that SECR wasn't applicable because you said that the specific waivers requested did not specifically relate to the room.
No, I didn't say secret. No, don't mix.
Okay.
There's the variance, so
Right.
we look at the findings under the variance.
Okay.
And under the variance, we're not being asked to waive anything that's related to the music room.
Okay, but for-
Right? SECR is its own pursuit.
Okay, I'm glad you mentioned that, because I was about to make that point. So you do, as undertaking your secret analysis, you are within your rights to undertake a review as to whether or not this cultural and historic resource may be adversely impacted by the project. And since it's going to be demolished, I think there's really no doubt that it will be. So I would respectfully ask the BSA to follow up with this. You said you're not going to close the hearing because you want to have further environmental review, and you're still waiting to hear back from other agencies. I suspect that some of that has to do with DEP or DOT, but I would respectfully ask you also to look at this one. I have contacted SHPO to confirm what I told you today. And what I told you today, that they are not commenting on this, that they are not giving an opinion, I urge you to double check me on that, because I can assure you that's what they told us.
What's what they told you?
That they can't provide an opinion on this because there's no state or federal funding. That's the limit of their jurisdiction.
Right, but they didn't tell you that they didn't, as the State Historic Preservation Office, say anything about whether we have to individually, as a non-historic preservation office, look at the cultural whether this cultural resource is going to be impacted. They didn't say that under SECR, so it's actually a question of arguably the State Environmental Quality Review Agency, which is
the State Environmental Quality Review Act and the City
Right.
Environmental Quality Review require the analysis.
Okay, so.
But SHPO would not, it's not within their purview to tell you what to do. Whatever SECR requires, and I'm sure your counsel is familiar with it, he'll tell you, or maybe you'll know on your own, what power you have with respect to SECR. And with respect to SECR, as I said, I don't want to be repetitive here, but there certainly is the power, this board has the power and the jurisdiction, and I would respectfully submit the obligation to investigate this issue to determine whether or not the demolition of this room would have an adverse impact on a cultural and historic resource in the city of New York. I just want to mention one other thing, if I may have a moment. I just want to mention one other thing, and that you mentioned the 2015 Helpern plan. And I'm not going to get into the details of adjacencies. I just want to point out that to the extent that there's any ambiguity, if you read our March 19th submission, you will see that front and center, we specifically say that we urge the BSA to preserve the music room. We have never questioned, and I presume it's clear, we have never wavered from our effort here to preserve the music room as an historic and cultural resource in the city of New York. The last thing I just want to mention to you is I have, with respect to the issue of cultural resources, letters from Terrence McNally, Valentino, the designer, Kelly O'Hara, I believe an actress, Allison Brewster Franzetti, a pianist who I believe performed in that room, John Corigliano, David Hyde Pierce, wonderful actor, Joanne Haynes Rhines, and lastly, the Crown Prince Pavlos of Greece, all of whom have urged this board to take serious consideration about the preservation of this historic and cultural resource.
I have a question for you.
Sure.
which I'd like you to research, and I'm going to ask the owner to research as well, owner's rep. So I'm aware of a number of state and federally designated landmarks that are not city landmarks. So for instance, I can think of ones in other cities outside New York, right? Or other areas outside New York, where in the interest of preserving the cultural resource, the State Historic Preservation Office, on behalf of the National Register Office, has allowed significant modifications to the resource in the interest of preserving the resource. So like I can think of Bell Labs, for example. Bell Labs, which was gorgeously restored, had to modify certain things that you could argue were integral to the original building in order to preserve the resource. So how does that fit into what you're talking about? So the resource, by the way, is the entirety of the Frick, right?
Absolutely.
All the interior spaces, especially the ones that are from the original home. I mean, those are the ones we're really talking about as being of enormous historic, architectural, and cultural significance, right? And so in the interest of preserving those, sometimes you have to sacrifice others, right? So I would like you to look at that and help us understand that perspective.
First of all, I greatly appreciate that question and that homework assignment. Thank you. I would say to you, just preliminarily, that under SECRA, it's in the first instance, the obligation, I guess, of opposition counsel to point out whether or not a project may have an adverse impact on an historic cultural resource. I believe I've done that. Once that happens, the next phase is that an environmental impact statement is prepared. And it's in that document.
No.
Well,
No, that's assuming that you have a positive declaration.
Correct.
Right? So we're
So-
nowhere near any of that, right? We're just talking about.
If you
What,
find that there's
right?
if you find that there may have an adverse impact on the cultural resource, then there's a review that's undertaken, and that review may conclude. I don't believe it will, but if someone were to come forward and have some sort of explanation like you described, that may ultimately be an outcome where you say, in the balance of what happened, we're going to allow this to move forward. But that hasn't been done yet, and that's what I'm asking this board to do, is to take that next step, not close off the issue of the music room, as appeared to be the sentiment in the review session. You felt like you couldn't do anything. And I came here today, one of the things I came here today is to try to persuade you that you do have that power, and to the extent that you do want to preserve this historic and cultural resource, you can. When I think of what this board does, and I understand the importance of a zoning board, especially in the city of New York, I recognize that you have lots of things which can sometimes seem mundane. Will this rear yard waiver go from 30 to 20 feet? The way I look at it is, this is the most important issue that could be placed before the board, because it is, as I said, is a one-of-a-kind, last-of-a-kind space. So that's why I would urge you to give every possible consideration to its preservation. Other than that, since I have been told that we have nothing else we can say on the particular plans in question, I will say thank you very much for your time, and I look forward to making that submission that you suggested.
Thank you. Okay. So don't we, yes, just a second. I think we have another opposition counsel. That's the way it works. We hear from elected officials, and then we hear from council, and then we hear from the public. Okay?
Thank you, Madam Chair.
State your name.
Stephen Cass, Carter, Ledyard, Milburn, counsel for the East 70th Street Block Association. As you know, our focus is considerably narrower than the previous speaker. And our focus is exclusively on the construction period. We do not oppose the project. We take no position on the interesting and arcane issues you were discussing. But we do think that the construction period does raise environmental issues. I know you have referred them to DEP, particularly the ones we have raised, which relate to noise and air quality during the construction period. I gather you have not heard back yet from DEP though it has indicated at least once, and possibly more often, its preliminary views on this. Our position, you may recall, was simply that the applicant's analysis did not include all the appropriate receptors, particularly two buildings on 70th Street directly across from the garden and the project. It did not take adequate account of the types of construction equipment and did not include adequate mitigation for either air quality or noise impacts on adjacent properties.
It didn't,
It did not adequately include mitigation for potentially significant impacts from construction noise and air quality. That there were references to commitments in the EAS prepared by AKRF, but they were not actually backed up by the applicant itself. So AKRF's conclusions, we felt, in fact, demonstrated the need for the commitments that we had asked for. We felt even more strongly with respect to noise, that noise levels had been understated, even without reference to mitigation, and without reference to the inadequate number of receptors, that upon further review by DEP, we thought it likely that those noise levels would have to be adjusted, that the applicant would be requested, probably by DEP, to include specific mitigation measures. You may recall I referred to the importance of screening noise for the upstairs windows adjacent and across the street, not simply at ground level. And there were other important construction activities, heavy construction activities here that were going to require specialized mitigation. I'm pleased that you're waiting to hear from DEP on those issues. In anticipation, and our expectation that our objections are sustained, and the DEP staff concurs that more specific mitigation is required, we respectfully reiterate our two previous alternatives. Either there is a targeted EIS that will be required, targeted, focusing on these issues, because of the likelihood of a significant air quality impact, or the applicant includes those mitigations in its revised application to you, and that you incorporate those commitments satisfactory to DEP, as well as to yourselves, in any approval for the project, and indicate that those conditions are to be reflected in a building permit. We know that you do not have enforcement responsibilities. I'm sure you're pleased about that. But DOB does. And if those conditions are reflected in a building permit for the project, we at the very least will have the ability to go to DOB and say they're not complying.
Sorry, just a question. You're saying reflected in a building permit. How are they reflected in a building permit?
Well, they can be reflected in a building permit that's issued by DOB.
By them being, no, I'm trying to understand the mechanism for having it. We don't control what's reflected in the building permit, only what's reflected on the certificate of occupancy or, yeah, with respect to environmental issues, right?
I think it would be fair to say that would be part of your negative declaration. As a lead agency, you have that obligation. You could say that the negative declaration that we are issuing today relies upon these commitments, and to make them enforceable and make them and give us the confidence that they will be complied with. Our condition is that they be reflected in the building.
So you're suggesting a conditional negative declaration, right?
Either a condition negative declaration is one possibility, Madam Chair, exactly right. That would be the case if it's not treated as a type 1 matter.
Right.
If it is treated as a type 1 matter, you can issue a negative declaration that is not technically called condition negative declaration, but in fact has those conditions in it because they are reflected in an amended application.
Okay.
Those are the two options. The third, if the applicant continues to take the view that it's not ready to make any such commitments, then it should withdraw its application and resubmit it at such time as it is ready to do so. That is our only suggestion to you. I appreciate very much the attention you're giving to the issues we've raised. And I will not trouble you further unless you have further questions.
Thank you very much.
Thank you, Madam.
Okay. Anybody else, opposition counsel? Do we have any more opposition counsel I don't know about? I know. Okay, so now we're going to open this up for testimony from neighbors, but what I want to be clear is the only thing we're taking testimony on relates to environmental impact, okay? So please speak to environmental impact. And you're welcome to come up, sir. Oh, you don't have to come up. We can give you the mic. Just a second. No, you don't have to come up. That's fine. No, sir, you can stay there. We can just bring the mic to you. State your name, please.
My name is Edward Shufro, S-H-U-F-R-O. I live right across the street at 10 East 70th Street. I've lived there now for 27 years. I bought the apartment I bought primarily because of the view of the garden that we've enjoyed all these years. It contributes enormously to my pleasure, but I think also to the pleasure of most of the people who live on the block, most of whom feel very strongly about this issue. And I've also learned as I walked through this whole contest, going back 5 years, that you cannot rely upon anything that the management of the Frick says about its plans. That I have learned for sure. Now, as far as the environmental questions are concerned, everything is an environmental question. Let me give you an example. They're planning to put in a cafeteria and a dining area or a kitchen area to provide for the cafeteria. This is going to bring rats into the building no matter what they may try to do to stop it. And besides which, they're trying to imitate the Metropolitan Museum or the Museum of Modern Art, where people come and spend most of the day at a museum and need to go someplace, whereas most people, when they visit the Frick, are likely to spend an hour, half an hour and a quarter. They don't come there to spend a great deal of time. It's not that large a place. To knock out the music room to create a cafeteria strikes me as a terrible thing to do. This, after all, was a man's home, and he left it he left this home for the pleasure of the people who came after him. And what they are trying to do is to make it into an institution that draws lots of people but loses its character.
Okay, thank you. Thank you. Next speaker, please. We're going to stay to environmental issues, please. And take the mic with you. Environmental issues, I don't want this to be a 4-hour hearing. We already had a 4-hour hearing on this, okay?
Not sure how to work that. Can you hear me?
Yes.
Okay. My name is Catherine Bristow, and I am here on behalf of the East 70th Street Block Association to supplement Mr. Cass's remarks to you. I would like to reiterate, as Mr. Cass said, that the Block Association is not opposed to the Fricks project in principle, but we are opposed to the issuance of the zoning variances that are required for the Fricks project without a commitment by the Frick to implement reasonable mitigation measures that will help us during construction. The Frick has not done so, and I think you know the history here. We've met with them, we've provided them with a list of things we would like them to do, and they've said in writing that our requests are not unreasonable, but they won't commit to them. Those who live and work on East 70th Street will bear the brunt of the air pollution, the noise, the vibration, the increased traffic, and the other disturbances that this project will cause. There are a number of cancer survivors among our population who are deeply concerned about the air quality outdoors, as well as the air and dust that will seep through air conditioning units and windows. There are homebound elderly people who are unable to leave their apartments or can do so only in a wheelchair. They will be utterly unable to escape the construction. Air quality is a major concern. While the Frick has stated in writing that it's willing to commit to several emissions-related restrictions, some of which, by the way, are mandated by law, it is stated that it will implement others, quote, to the extent practicable, close quote. This is a hole you can drive a truck through. We believe that the Frick has understated the amount and duration that its project will cause, of noise that its project will cause, given their over-optimistic estimate of the construction period. They say 2 years, while other recent renovations of jewel box New York museums have ranged from almost 3 years to 4 years. The Frick's own EAS states that noise levels will, during some periods, be unacceptable, quote unquote. As I said earlier, last January, we met with the Frick, provided it with a list of best practices, reasonable mitigation measures that we would like them to agree to minimize the misery that its project will inflict. As I said, they wrote back that our measures were not unreasonable, but they refused to commit to them, stating that the construction process was 18 months away and many items still required further planning and city review and approval. Now, that planning has occurred and the Frick is on the cusp of city approval, so that excuse no longer suffices. We strongly but respectfully request that the board require the Frick to enter into a binding agreement to enact mitigation procedures as a condition to granting necessary zoning variances to the Frick. Thank you.
Thank you.
Next speaker.
Other speakers? Come. Please come.
Speaking in support of the project, good day, Chair Perlmutter and Commissioners. I'm Andrea Goldwyn, speaking on behalf of the New York Landmarks Conservancy. For nearly 5 decades, the Conservancy has been dedicated to preserving, revitalizing, and reusing New York's buildings and neighborhoods. Our Public Policy Committee supported this proposal when it came to the Landmarks Commission in 2018. We believe that the proposal would not alter the character of the neighborhood and that the proposed variances should be approved. The Frick is one of the city's finest buildings and most beloved museums. This overwhelming success has triggered the challenge of expanding space for various needs. We thank the board and staff of the Frick for listening to concerns generated from their previous proposal, which we did not support. They started over, conducted community outreach, and responded to the concerns previously raised. The architects have developed an intervention which is appropriate for the landmark and meets the institution's goals. Since Carrere and Hastings designed the mansion in 1914, there's been a series of careful additions and alterations. We believe that this thoughtful proposal continues in that tradition. Our committee considered the height, massing, and configuration of the proposed additions and found them appropriate. They draw inspiration from the historic buildings of the complex in a respectful manner and relate well to other buildings within this block of the historic district. We urge you to approve this application and thank you for the opportunity to present the Conservancy's views.
Next speaker.
Thank you. Again, please try to restrain to environmental considerations.
I'm sorry, I'm a little short for the microphone. Chairman Perlmutter and other commissioners, I've spoken before you before. My name is Martha Frick Sanger. I am a great-granddaughter of Henry Clay Frick, but more important, I am the recognized family historian. I know Henry Clay Frick, and I have known the Frick collection for 75 years. With the weight of being the Frick family historian comes the heavy responsibility. Indeed, the obligation to protect the integrity of Henry Clay Frick's cultural and historic resource, particularly the music room. Since Frick's death in 1919, the Frick collection has protected this resource, all the way through John Russell Pope's renovation of the house for a public facility, and including the 1970s edition, and thence to 2005, when unfortunately came a group of over 20 ambitious museum-oriented individuals who want to demolish the music room, a great and very important cultural resource. And this they want to do with no regard for the institutional memory, which they have absolutely thrown out the door, in an attempt to place their own highly visible, discordant architectural mark on this historic resource. This to showcase their own taste, not the intellectual, cultural, and historic tradition of the Frick, and to satisfy their own ego and to create their own architectural legacies. You can hear from the tremor in my voice voice that I am extremely upset with the way the zoning commission has handled this. I think that the BSA will set a dangerous precedent if it accepts the Frick's variance petition, including demolition of John Russell Pope's one-of-a-kind music room. The BSA would thereby set a precedent, irreversible, for another administration more zealous than this one to come in, maybe bulldoze, oh, what fun, let's bulldoze the John Russell Pope Oval Gallery, let's tear up the East Gallery, particularly the Garden Court, why not, if the precedent has been set, and the Boucher Room. Let's go ahead and raise the roof of the Frick Collection to make still more out-of-character exhibition space. Gone forever would be the Frick's cultural and historic resource as it has been for 100 years. It is irresponsible to permit this to go through. Each and every one of you, commissioners and the chairman of this zoning board, will go down in history, and I mean go down in history, as the authors of this dangerous precedent. Please do not allow it to go through. Please preserve that music room. This is absolutely the wrong direction to go, and it opens the door for untold damage to this beautiful cultural, historic
Yes, so, okay. Your
resource.
time is up. Thank you. Please. Just to let everyone know, these are case-by-case bases. They're not precedential. Every project is reviewed on a case-by-case basis. Next speaker, please. Any other speakers on this?
Hello, I'm Pat Lunka from East 71st Street.
Speak into the mic.
Hello, I'm Pat Lunka from East 71st Street. And I guess in limiting my comment to the music room, it is the responsibility of the BSA to evaluate the impact of construction and zoning variances on the neighborhood and on the environment. It is your obligation to carry forward this secret assessment. It is part and parcel to the entire review of this situation. And I think the gentleman in the front summed it up very nicely, that to trade off the music room for a cafeteria is really hard to comprehend. And I guess my final statement on environmental impact is no more will that sweet music play from that room. And I would argue that is environmental. It evokes peace. It invokes reflection of the past and the period of time in history when salons were in vogue. Thank you.
Thank you.
Any other speakers? Please come forward.
If you could please take a copy and pass it down. My testimony is heavily illustrated.
And you know you're limited to 3 minutes, right?
Thank you, Chair. Good evening, Chair Perlmutter, Commissioners, and staff. My name is Theodore Grunwald. I'm Vice President of the Committee to Save the New York Public Library. Our organization initiated a successful 2013 lawsuit against the trustees of the New York Public Library to halt the Foster and Partners proposed demolition of the stacks at Carrera and Hastings, 42nd Street Central Research Library. This evening, I am here to address the loss of an irreplaceable cultural and historic resource, namely the music room and the reception hall. After World War I, for example, I'm using this Bank of England by Sir John Soane as an example. The Bank of England created a masterpiece designed by Sir John Soane that he worked on for all his life, for 40 years. The bank, even though alternatives were available for expansion adjacent, demolitions of Soane's interiors began in 1925 amid a public outcry so vehement and impassioned that the distinguished architectural historian Nicholas Pevsner described it as the greatest architectural crime in the City of London in the 20th century. As appreciation of Soane's work grew in the post-World War II era, Soane's brilliant handling of natural light and astonishing play of scale cemented his reputation as one of the world's greatest architects. The irony, of course, is that today the bank is reconstructing rooms that were demolished over 75 years ago. And they're recreating the demolished spaces in a 3D virtual reality mode on computer. Now, we're on the verge of losing something that's central to New York City's musical and cultural history. You're in a position to prevent another similarly historic "what were they thinking" moment in New York City's history. Now, also, another thing that I'd like to bring to your attention is that assertions have been made that the music room and the reception hall are, quote, "not important." I direct you to my May 29th request for evaluation. These statements are uncompelling, and new scholarship is uncovering new and unknown information about the architect John Barrington Bailey, who was a pivotal figure in not only postmodernism, but in the nascent historic preservation movement in the 1960s. He's a really important guy, particularly in New York City history. He was a member of the Landmarks Commission at its inception, and he was a very visionary, dedicated civil servant and a great architect who dedicated his life to historic preservation. So in closing, I'm encouraging this body to please wait. Please consider the over 5,100 signatures that I'm submitting to this body in favor of the preservation of the music room and the reception hall. And I urge you to make this decision very, very carefully. Please do not give us an "oh my God, what were they thinking" moment.
Thank you.
Thank you.
Next speaker.
Next speaker, please.
Hello, my name is Jane Berger, Madam Chair and members of the board. I came here today with a completely different idea of what I was going to speak on, but now, per your request, I am going to stick with two things that I think are most important about this whole issue here. First of all, Council Hiller also has a letter from Tyne Daly, which I believe he either has or will give to you as well. She was adamant about the saving of the music roll, and she has right to be because she's very interested in music and has been a big part of the music community in New York City and feels very strongly about the preservation of this music room. I am adamant about asking the Frick to figure out a way to fulfill the programmatic needs without destroying this world-class, one-of-a-kind, acoustically perfect music room. The Frick by now should be aware of the public outcry to save this music room, and if they choose to turn a deaf ear to it, I wonder how they can sleep at night. Most directors of museums want to preserve the building that the museum is in. For whatever reason, this director has chosen to take a different path. He wants to destroy and rebuild and replace with things that have nothing to do with a home that is like this beautiful mansion. You've made it clear, Madam Chair, that the public is not a co-applicant. However, we do not have public hearings for the reason other than to discuss this. The second thing I want to bring up is we are talking about the environmental impact of the sound and the construction and the breathing quality and so forth. I believe the first lady, the woman who spoke very emphatically about the people who live in the neighborhood and who have their elderly people there who can't get out. Their air quality is going to be very bad. I cannot begin to tell you that I strongly doubt that this project will take anywhere near 2 years to complete. It'll be more by the time we finish it, it'll be more like 3, 4, or 5 years. I've seen what is going on 72nd Street, right behind where I live, and a simple townhouse that was rebuilt. It has taken 4 or 5 years, not the 2 years that they thought it was going to take. This project cannot be completed in 2, 3, or 4 years. That's the good news. When it is completed, you now have buses that are going to be traveling up and down that street. The buses in the winter are going to be left running so the best bus drivers can be comfortable in the heated bus. In the summer, they're going to be air conditioned so the bus drivers can be comfortable waiting for the children to come out and have their comfort to be comfortable in the bus while they're waiting.
Please wrap up, your time is up.
Thank you.
Okay, thank you very much.
I would, just to say, you as a board have the opportunity to finally put a stop to, or at least a hold, on desecrating rapidly disappearing historical landmarks. I implore you to seriously think hard about your legacy as a board, and be known as the board who put a stop to irresponsible development to save an important New York City landmark. Please do not allow the FRIC to go beyond what zoning has set as current standards and enable them to go beyond what others must adhere to by granting them these variances. I implore you not to grant the variances. Thank you.
Next speaker, please.
My name is Arnold Clipper. Since you limit...
Can you move the mic closer to your face? Yes, and speak into it because we can't hear you.
You limit this to the environmental impact.
Yes.
Clearly, a 3 to 4 year construction and demolition has a tremendous negative impact on the environment. In the process, one of the nicest music rooms, perhaps in the world, is being destroyed. You have rejected Mr. Harper's plans because you feel that programmatically they don't fulfill. The FRIC has now the opportunity to become a good New York citizen. Across the street is the former Epstein mansion that unfortunately has a very bad reputation. The FRIC has now the opportunity to turn this around. It's one of the largest mansions in the city, and probably could be converted to the FRIC's needs.
It can be converted to what?
To the FRIC's needs.
Oh, in other words, expand into that mansion, is that what you're suggesting? Across the street?
Yeah.
Okay, understood. Thank you.
We're done? Yes, no? Are there no other speakers?
Any other
please?
speakers on this?
Please stand up on the side there, so I can see that you're coming up. Thank you. Not last minute.
Hello. My name is Jennifer McBride, and I'm deeply concerned about what I've heard here today. And I thank you for listening to what we have to say, especially as it relates to the environmental impact, which is very important. Not only to me as a parent who has 2 children that are young and developing, and as we know, children these days develop much quicker than they did when we were growing up, with all due respect, because of environmental impact. It's not just what they eat, it's not just the hormones in the food, it's the air that they breathe, it's the water that they drink. And so by instigating this expansion, you are releasing additional toxins into the air, which our children will be breathing, which our elderly will be breathing, which our neighborhood will be breathing. Also consider Central Park as part of the neighborhood. There's a playground on 71st Street where children play 7 days a week, as many hours as they can, because this is New York City and kids need to get outside. They will be breathing the air that is disturbed by the FRIC expansion. Aside from the fact of the 3 to 5 year, let's be real, construction process, the bus is idling, as previously mentioned. I'd also like to call to attention that the reception itself is, come on in, I will receive you, I will have a party here. So to Mr. Tarnoff's point that they will not be having more parties, they're designing a hall to have more parties. In fact, part of the plan that they are proposing has space specifically for party rental equipment that they will have on site. That was told to me by Joseph Shadoff in a meeting that we had with David Halpern, Chair Perlmutter. I gave you a letter with regard to that meeting, which I'm sure that you have seen. The ADA access on 71st Street, if you would restrict it just to ADA access, that would be great. But truth be told, the real ADA access for that to get into the galleries is through 70th Street. It is a circuitous path to go through 71st Street. It is for getting catering in to the cooking facilities, into the kitchen, and for the reception. This is a wolf in sheep's clothing. What they are telling you is not real. They tell you one thing, then they tell you the other. When Mr. Tarnoff earlier said that they will not have more parties. That's not true.
Sorry, please don't have a
They will not
conversation
have
like
no
that.
Okay, yep, you're right, my
Right.
bad.
But I just want to point out
Sure.
that the thing that's called reception hall is
Yeah.
called reception hall on the existing plans. That's what it is. It's the place where you arrive and you take off currently, you arrive in the entrance, you take a right, you leave your coats, and there you are in the reception hall, and you go to the current museum shop. It's the same location as the proposed, so I'm not really sure.
But it's an expanded reception hall. It blows
Because,
out into
because
a
if you've been
larger
in the
area.
reception, which I've
I
been,
have.
in the middle of the day,
Yeah.
where they're receiving all the visitors, there's no place to stand. So you obviously need to make it bigger. In other words, otherwise, there's no place to stand. You end up getting crowded into the hallway.
And the applicant has provided documentation indicating the growth the museum has seen in its visitors, and the space that is currently being used as a reception area is not adequate to handle the crowd that visits and the expected growth. We were convinced by that argument.
So with all
I
due
was.
respect, and I'm so glad that you had a chance to see it yourself, but I went to the Frick every single day at different times during the day for multiple visits over the course of several weeks. I never saw more than 10 people lined up to buy tickets to go in. It's not this serpentine-like experience that you experience at the Met Museum. And I'm sure you didn't see that either. Perhaps when there's a free night or there's a special exhibit, but those are once a month. I went today, this morning actually, because I wanted to just really bask in the glow of how magnificent the space is. There were 3 high school groups in there, in different rooms. Also, one of the galleries is closed. So with one of the galleries closed, 3 school groups huddled in different areas. It did not feel like I had to step around or couldn't easily move around. There was no one in the reception hall. There was a bus idling on 71st Street, and there was another bus on 70th Street. This is before having the expansion that they're talking about. So I'd be happy to compile data for you based on experience that I have and the numbers. I went in, I took very clear data about the day, the time, how many people I was seeing. It's right there. It's not what they say it is.
Okay, thank you very much.
Yeah, and I really hope that you will consider the music room as a very important part of our culture and our community. Thank you, I really do appreciate all of your attention.
Thank you. Next speaker, please. And we need to stay on environmental issues.
Just go bring the mic down.
Hello, my name is Catherine McBride. When I went to the Frick, it was magical. The room where the books, fireplace, and the painting of Lady Hamilton was a place where I could imagine myself getting lost in a book. When I stepped into the music room, I was amazed. The fabric on the walls, the dome ceiling, and the thin gold line, where the top of the ceiling meets the dome. I was truly inspired. I was inspired about how detailed the gold lines were around the room. And then I noticed the 10 people watching a film in the room. Then I realized that they probably would not be able to sit in that room the way it was now. And that made me sad. Please deny the variances that they are requesting and help preserve the Frick. I also have almost 1,000 signatures that me, my sister, my mom, and my dad collected. Thank you.
Thank you. Any other speakers?
Hello, my name is Joni Lane.
Sorry, speak up and lift the mic up.
Hello, my name is Joni Lane, and I have a degree in environmental management systems, and I'm a LEED accredited professional. And it looks like this expansion will have significant, numerous negative impact on the environment. And New York City, as you know, is trying very, very hard in their recoding to straighten out all the pollution and environmental problems that have been created. the environmental problems are too numerous to go into detail about at this time, but during both the construction and afterwards, the variance that the FRIC's asking for will impact and should greatly be concerned about idling buses, the air quality, the shadow impacts, and it's just not in accordance and accepted with what could and should be done in today's times.
Thank you. Thank you. Next speaker? Any more speakers? Are we done after this gentleman? Are you speaking also? Okay.
Good afternoon. My name is Mark Alexander. I'm the president of Civitas. Civitas is a civic association located on the Upper East Side of Manhattan. Our focus is on environmental and quality of life issues, zoning and land use. And we've become a respected member of the community over a period of 35 years because we try to weigh in a civic and pragmatic manner, looking at both sides of an issue and trying to be careful and thoughtful in how we respond to multiple requests over the years from any number of institutions looking to expand, looking to how to mitigate the effects of the Second Avenue subway, looking how to improve the environment on the East River Esplanade and so forth. We looked very, very carefully at this plan in comparison to the original plan that was proposed by the FRIC in 2016. And with respect to its environmental impact, we see very, very little impact here. I mean, there's modest intrusions on the skyline that are barely perceptible from Fifth Avenue that are going to have a de minimis impact on shadow lines. There's anything that they do, they're going to be doing an extensive reworking of their HVAC system. Any such endeavor is going to have significant positive impacts on the environment. A lot of the testimony from the opposing attorney frankly sounded like sour grapes. We've lost our argument, and so we're going to suggest that there is somehow an environmental impact caused by losing a music room or losing some other feature in this building. I suggest to you humbly that those arguments are appropriate and decently provided in direct contact with the museum and their staff. This is not the forum to suggest that the loss of a music room is an environmental concern. We think that the process, the very lengthy process associated with a BSA hearing is perverted when these types of arguments are brought. It is not the appropriate nature to take arguments of this sort and try and suggest that there's something else. We've thoughtfully looked at and reviewed the models. We've engaged with the staff at the FRIC. We've engaged with other community members, and we believe very, very strongly that this is an appropriate and very thoughtful endeavor to expand the FRIC with a very appropriate and thoughtful considerations of the environment in the process. Thank you very much.
Thank you very much. Next speaker, please.
My name is Ned Van Zant, and I'm a New Yorker. I'm an actor. And I'm limiting my speech because of environment. But I do think that the destruction of the music room impacts the environment. The building, I've heard a lot of testimony about that the entryway is not going to be commercialized banquet room, and I think that's false. I think the fix is in, and this board respectfully has an opportunity to stop it, stop this corruption. Thank you.
Next speaker.
Hi, my name is Isabel Fernandez, and I'm a student at Hunter College. I just want to say that I love the FRIC, and so do my friends. And the environmental impact on us is a positive one, increasing access, welcoming students, and making the Frick a part of our lives. Thank you.
Thank you.
My name is Miriam Clipper, and I'm just getting up to respond to the presentation of the gentleman from Civitas. I regard the proposal as an environmental upheaval. This is an area of elderly residents who will be impacted adversely by this environmental upheaval, as was pointed out by many people, that will last many more years than projected. Of course, that is what the Frick would call conjecture, but that is something that could be put into the agreement, that the Frick will stop work after 2 years, period. Yes, hardly something that will happen. I also want to say that this entire process, I'm an attorney, and I'm a former assistant district attorney in Manhattan County, New York County, and I am always disturbed when I see conflicts of interest. I find this whole process has been riddled with conflicts of interest in terms of who is really acting for whom in this whole process. So that's the end of my protest, except for the fact that the music room, I should point out, I have read, is not only to be admired, to be lauded, but it is the only venue of that nature for chamber music in the entire city of New York, and who knows, perhaps in the entire United States of America. Thank you so much.
Any other speakers? Last call. Okay. Mr. Charnoff?
Let me just respond to Mr. Cass and Mr. Hiller. I think Mr. Cass's objection is that the Frick did not want to enter into an agreement with the 70th Street Association about what...
Yeah, it's hard.
With the 70th Street Association about what commitments it would make and what it would do during construction. But as the board knows, the project is being reviewed by DEP, was reviewed by DOT at the present time. If that agency wants us to use particular equipment or construction equipment, as indicated in the EAS, we have every intention of doing that and would make a commitment to do that. And the board, and that would be in the environmental assessment statement that is submitted to the board. And we believe the board can establish as one of the conditions of its resolution that we comply with the construction methods and techniques as outlined in our environmental assessment statement, which I believe would address the substantive concerns raised by Mr. Cass. Any private agreement between the Frick and the East 70th Street Association, we believe, is outside the jurisdiction of this board. And it's not properly before the board. With respect to Mr. Hiller's comments about the music room and about secret. So as let me point out, which I think the board knows, that we submitted an as-of-right scheme to the board which would remove the music room as part of an as-of-right alteration. Admittedly, does not meet our programmatic needs, but it's something that it could happen without the variance, number one. Second, as I understand SECRA in New York City, it's implemented by, state SECRA is implemented by the City Environmental Quality Review, CEQR. And the city has published a manual under CEQR. And in the SECRA manual, it says that when there is a possible historic resource, whether it's under the state register or New York City eligible, that the agency should refer the matter to the Landmarks Preservation Commission. For expert comment as an expert agency, the manual does that with respect to other issues where they're with his expertise, which every city agency doesn't have. And this board did that. It did that, it referred the entire application to the Landmarks Commission when it was initially filed. And there was response from the Landmarks Commission, which is in the file, that said they did not see a significant impact under the City Environmental Quality Review. And that included the plans that show the removal of the music room. Then the board did that again when the issue came up during the course of the hearing, and asked them to focus specifically on the music room, and there was another response from Landmarks to the same effect. And this is separate and apart from any determination as to whether or not the music room is worthy of being an individual interior landmark, which the Landmarks Commission also did in rejecting a request to designate it as an interior landmark, although admittedly that's a different standard from SECR. But the expert agency in the city has responded to the board and said they did not see a significant impact on the SECR. The board contacted the State Historic Preservation Office, which said it had no jurisdiction because there's no state action at the present time. And so, in our view, you've had consultation with an agency that has made, with expertise, which has made a recommendation, and the board can rely on that in making its determination under SECR.
Thank you. Anything else you wanted to add?
I have nothing else to add.
I do want you to, no, sorry, the public speaking is closed now. No, sorry, ma'am, the public speaking is closed. Everyone had an opportunity to speak, excuse me, ma'am, you'll be asked to leave if you continue doing that. Okay, so I would like you to respond to the same question I posed to Mr. Hiller, which is about how, say, a building that's under a federal or state register, and the sort of latitude that those agencies have to allow modification of a historic resource in the interest of preserving the resource.
That, in my understanding, that happens frequently. Substantively, the context in which it happens is, it could be as part of a Section 106 consultation under federal law, but it does happen frequently. If you want us to give you examples, we can certainly give you examples in which buildings which were preserved were altered in order to accommodate an adaptive reuse or something of that nature.
Okay, that'd be great, yeah. And as you said, is citing to the section in the federal code, right?
But that doesn't mean that section is applicable to our proceedings.
No, I'm not saying it is, but just to put this all in context and to help the board understand the context in which it's operating. Okay, great, thank you very much. All right, so now schedule again. Is there something you wanted to add?
I was just going to say, I was waiting for the timing discussion.
Yeah, okay. So we are, in fact, waiting for agency review to continue.
October 15th.
Was a promised response date?
October 15th.
So that's a response date, and we don't know whether our applicant will have to do something in response to the response, et cetera, et cetera. So maybe put this on for continued, like, end of November?
We would ask you to do it sooner than that, if
But
possible.
we want enough time for there to be a turnaround is the problem. For you, the applicant, to respond to DEP or anybody else's.
Well, we've already responded several times, and hopefully this will be the last
Yeah, but we're
one.
not sure that it's the last one, and that's part of the problem. It's not that they were on the verge of saying, good to go. We don't know what they were on the verge of, and so we want to make sure that we're not just holding another hearing that we have to adjourn, and all these people come, and we have to adjourn, right? So, so early, so November 19th.
Much appreciated.
Under 18 on this, and 19, how many on this one? 25, sorry, I couldn't see. Let's do the 19th. Okay, November 19.
With a submission October 30th, and obviously environmental issues can be resolved at any point.
And if,
Yeah.
October 30th submission and November 19th for the continued hearing.
and we're just talking about environmental issues, and the submission is on this one particular issue that you've identified. Is
No,
that correct?
the submission that I'd like to hear about to us is about the historic preservation subject, right? That's the one that I'd like to
Historic
have.
preservation about adaptive reuse in other locations.
Yes,
That's the only issue we should respond to.
That's the only issue you're responding to the board, and then you're responding
To
to
the seeker.
DEP's or
Yes.
whoever agency's questions to you.
We're
Okay.
responding to whatever the agencies say, but also addressing the questions that you posed.
No, so don't forget, you're not the applicant, you're not a co-applicant, right? So you're responding to the question that I presented about the adaptive reuse of existing historic resources. You're responding to us by whatever date that was again?
October 30th.
October 30th. The applicant, the Frick, is responding to DEP's letter on whatever subjects. When it asks, if it asks for additional studies or wherever it asks for, they have to respond to that. You're obviously not responding to their request for additional studies, right? Just to be clear. No, you're not. You're just, I'm telling you, you're not because you're not the applicant, right? Okay.
It's anomalous that the applicant let me up. I mean, I'm not
It's
saying I
it's not
will,
anomalous, it's normal. The applicant is the applicant whose consultants respond to the agency's requests for information. The reason that you're bringing up this question about historic resources, so I'm posing a question to you, and it's only fair that both the owner should respond, and you're the one who brought it up, so you need to fill in the gaps of what you brought up.
And the November 19th date will be limited to whatever environmental issues are
Yes.
remaining
yeah.
at that
We're
point.
not
Thank you.
opening up anything new about the
Thank you.
architecture, okay?
we're
Thank
done.
you. Okay, that's so to be clear about for the public, there's a submission on October 31 that has to do with environmental issues, and on November 19th is the continued hearing. We can't close the hearing until we've cleaned up all the environmental issues.
30th or
30th.
Sorry, 30th.
30th of October.
30, yeah. Okay, thank you everyone for coming and for your testimony.
New cases, item number 1, 2018-27 BZ, 16 Dover Street, Brooklyn.
How's everybody? Anybody need to get up in a little bit? 5 minutes?
Yeah.
Can we take a 5-minute break before we do that? Thank you. We need to stand.
Sorry. Elise, 5 minutes. Go. Okay, back on the calendar records, September 17, 2019 zoning calendar, new cases. Item number 1, 2018-27 BZ, 16 Dover Street, Brooklyn. Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board in response to the board member questions? Okay.
Elise Fullader from Eric Palatnik, PC, on behalf of the applicant. I'm here today with Joel Mealy, who's the architect, in case he needs to answer any architecture questions. But so I handed out a few items that were submitted with the original application, because there was a lot submitted with the original application, and I wanted to remind the board of some items. So firstly, the home is a legalization. That's a topic that kept...
Today.
I mean, it's not a legalization. The home today, in 1984, let's take it back, sorry. In 1984, they were legalizing the home for the variance, and it was an already built home. So I just handed this out. This is what the...
Already built home that was illegally constructed.
Yes, in 1984.
Mm-hmm.
Or illegally enlarged.
Illegally enlarged, okay.
Gets a little fishier for me.
That's part of the question right there.
Yeah.
What was its status before, what was its legal condition prior
the
to the
variance?
illegal enlargement? Because that's arguably where we have to go.
So that's my next point, is in 1992, that home with the variance got a final certificate of occupancy.
Based on a variance.
Based on a variance of this home.
But didn't the rear yard change from what was approved?
So that's the thing is, it says, in the resolution, it says a certain rear yard, but based on looking at the home, it doesn't appear that anything changed. It appears that this home with that crazy rear yard is what actually was approved. So in the original submission, we provided, there was a lot of discrepancies, we think, in the 1984 variance, and we provided an overlay of the 1984 drawings of the legal conditions and proposed conditions over the current existing conditions. So this was in the original application, and Joel can explain it, I think, a little maybe better than me, but he mapped out what claims was being approved, but was actually approved in 1984, because the house existed.
Okay, so this is the thing. If we were going to go, not to say that people are willing to do this, but if we were going to allow this to be a 73-622 enlargement, we would need an abandonment of the variance, because otherwise it's an amendment to a variance which was granted with the concept that it's the minimum relief necessary, right? So the minimum relief doesn't change. You hit your minimum, it was your minimum, very nice, have a nice day, right? If we're going to go with an increased enlargement, then we need to abandon the variance, and then we have to decide what is the existing building that is going to be enlarged under the 73-622. So an existing building to be enlarged under 73-622 would have been the legal building prior to the variance, not the illegal portion of the building prior, at the time of the variance.
Even though the language of 73-622 says an existing home, and it's illegal.
Yeah, but so now we're looking at it as a variance. It says an existing home,
Yeah.
but it doesn't say anything about an existing home that was enlarged pursuant to a variance, where you've got a collision of two board actions at the same time, and to keep the variance alive and get a 73-622 doesn't make any sense to me, because you're being rewarded when you already were rewarded. You already got the minimum variance necessary to afford relief. This is double dipping, in other words. The reason for the special permit is to avoid the need for variances, right? It's to allow buildings to be enlarged under a special permit process with findings, with a different set of findings, right?
Yeah, and
So
the
you're-
special permit was written, probably, I mean, I wasn't there, but because these homes were getting variances and they wanted to give relief to them, the special permit was written after. They had to
Yes.
get a variance, there was no such thing.
Okay, so this house was lucky enough to qualify in whatever way it was able to qualify for a variance. So yay, it accomplished its enlargement, and it got more floor area than is allowed, and it got more less rear yard than is required, et cetera, et cetera, et cetera. So it already benefited from sort of the equivalent of this special permit. And we see variance applications in other parts of the city where a property owner comes to us and says, look at me, I have this terrible little lot, and I can't even enlarge it because I have side yard requirements and all of these things, and I can't possibly function as a house because the house is, 800 square feet or something, and so please give me a variance, right? You already did that here. You already accomplished the task. And so either if you really want to double the size of this house under, or whatever it is that the 622 might enable you to do, then you can have it both ways. Either no more variance, and we see if you can actually retain existing walls sufficient to qualify under an existing, is a whole can of worms, because we're not really sure where we go with existing. Another way to do it is like what we did on arguably that house that burned down, where we required that the house be rebuilt to the maximum allowable under the zoning and under its pre-existing conditions. And then they came as an existing house that was a complying existing house. And then we allowed the enlargement. I think what we're seeing here is first awarding a bad actor because it wasn't built according to the approvals, and we're talking about double dipping at the moment, so you can't double dip.
Another way of looking at it, let's say if there was the special permit in place, they would have come in, they would have gotten this extension or legalization of an enlargement through the special permit, and now it's a second time around seeking the special permit. I mean, because the special permit was not there, they sought the BSA variance.
Right.
But, you know, it's almost like going through this, like you said, going through the process twice.
Right, but the
One-
variance
one
has
was-
different findings, right?
Fair enough, fair enough. And that's why the text was revised to allow for the special permit, because it just.
Right, but I think one of the problems here is whereas we sometimes allow legalizations when we have the power to legalize what they want to legalize, here we don't. We don't have the power to
Right.
legalize that rear yard.
I agree.
Or
So-
the
Height of the
Or the
building.
height of the perimeter wall.
The-
So that's the problem. It can't be legalized under a special permit, so
It would need to be legalized under the variance, and that's amendment to the variance. Well, that's only part of the problem. Yeah, that's part of the problem.
Yeah.
Yeah, but we weren't bringing it back to
Bringing it to 23 foot too.
Yeah, on this piece of the.
Yeah.
Yeah.
Oh, we
so
wanted to keep the
They're
existing.
saying that even if we do the special permit on the portion of the lot that's not used.
I think
the
you need to
existing
stand
house-
closer to the mic.
So I'm trying to understand that you're making a distinction as to what's existing, and if you lose the variance, you seem to be stating that it's no longer existing, when in fact it is existing.
You
It has a
can't
C
lose
of
the
O.
No, so this is the thing. The minute you walk away from the variance, your building is completely illegal.
Nah, I'm not,
Yes, not completely. Let's say all of those things that don't comply are illegal. So when we look at a 73-622, we say, take away all the illegal stuff, except the stuff that arguably we can legalize. And in that case, you can't count that existing illegal stuff as existing because it's illegal. So you have to take that off from your perimeter wall count. So we would require you to abandon the variance first, basically. And then we'd move forward, right? We can't have you have an outstanding variance in place that you benefited from.
Okay.
And then move on from there.
and why is it that you won't let them reopen the variance and amend it?
Because you have already accomplished the minimum variance
We-
necessary.
Well, we accomplished what was minimum in 1985, not what was minimum today.
Your house exceeds the floor area in this neighborhood, so you're already
The
better
existing-
off. No, the existing house
Yeah.
exceeds the amount of allowable floor area. You were approved at .59 FAR and were built improperly at .63 FAR, so you already exceed by .13 what's allowed in the neighborhood.
So you're allowed
better off.
.6 with attic space, first of all, not .5.
Okay, so is this
Okay.
.63
So,
calculating
and they're
that?
willing to remove the illegal construction as part of this process.
Right, but you were already granted waivers of all of that stuff, right? A rear yard waiver to 12.6, which no one else gets. Side yards, I'm not really sure how that worked out, but the side yards, I
Side yards
guess, are complying.
Side yards work.
Okay, but you got more lot coverage than is permitted, I think. I don't know, because you don't even show what's required. Let's see, so, lot coverage is 35% permitted, and you're at 31%. So that part you could enlarge as of right, okay? But you used up your floor area. So but I'm not understanding like what the argument would be to go beyond the minimum necessary variance, and it certainly wouldn't be what you're proposing. Because why would we allow you to go up to .92 FAR if the minimum variance necessary was .59 back in the day?
Again, that was the minimum back then.
But it's a big house.
Have you seen the house
No.
to the north of it?
That's not the question.
Well, all I'm saying is
knew
the
that.
character of the neighborhood has changed.
I don't think that house, by the way, was
It
built
is,
legally.
2008 certificate of
I don't know how the house was.
But you would still have to make the findings.
I understand that,
again.
but it sounds to me like you don't even want to give them a chance to do that.
If you want to
You have to file it
reapply,
as a variance,
As
an
a-
amendment to variance, first of all. And see if you want to go down that route. I doubt you're going to make it. How are you going to make it? How are you going to show that your unique issues are a hardship when you're overbuilt?
Legally.
That puts you in a better position than your neighbors.
Yeah.
I mean, you have to think about whether or not you have a case here.
Yeah.
Right?
We met with, council in between to try to figure out which way to go with this.
Well, actually, in defense of all that stuff, there was a very, very lengthy notice of comments. And
Yeah.
one of the instructions was,
Well, that's
what are
what
you
we
going to
meant.
do about the variance? And how are you going to coordinate the variance and the 73-622? And the response to that is, we'll let you know when we come to the board, we'll figure it out.
No,
So-
then we met with council. We had a meeting. After that notice of comment. And we
Okay.
provided them with a write-up. And we had a meeting with council and the project manager. And we were told to keep going. So we were told that they wouldn't know exactly which way the board would go.
They didn't know which way the board would go.
Yeah.
Because we did understand that that was a very important comment to address, so we wanted to see if we could kind of do something before we got to this point.
I don't know what to say about that. I don't know how to get around the issue of the minimum variance having been granted already, and no good case that I can think of for, I mean, you're welcome to make an amendment if you think so, if you think you can make the argument, but I don't know what it would be. Go ahead. Yeah, Carl?
Just a suggestion, I'm not sure if it'll fly, but would it be helpful if you could provide a site plan that showed, what within the variance that was granted could have been permitted today under the 73-622?
We did that in the statement.
Okay.
You did that.
No, they already went through some of that, but there are things that are not true in the statement of facts, like we can't legalize the rear yard. The rear yard is not measured over an easement, it's measured from the property line according to the surveyor.
The resolution says that they use the easement.
No, so that's a
they
different
said
thing.
the easement provided extra buffer,
Right.
so
Yes,
it was
right.
okay to go that far. For the only cases where we allowed a rear yard to go further than the 20 feet was when they bought the easement. And there are cases where they have provided proof that they purchased the easement area and actually have recorded a tax lot merger to merge that easement area into the tax lot.
And so far, your surveyor, at the very least, does not think you own that easement. And so if it's not the case, then you need to get your surveyor on board.
There's no way you count the variance as the existing.
No, but that, it would, you understand how, the board believed, like, I along with the board believe that that would be double dipping.
Okay, just clarifying that, so everybody's on the same.
All right, so if you want time to think about this, we could give you a few months to figure it out. I don't know. Okay, so are there speakers on this one? Okay. So why don't we say like January or something, and that way you have plenty of time to figure out your plan of attack, and then that's it. That's all I can
Okay, so submission
They were
January
facing
and a continued hearing on January 20th.
Sorry, what's the date again?
January 8th submission, January 20th.
Item number 2, 2018-191BZ, 215 North 10th Street, Brooklyn. Is this your team? Okay, team. We need to raise the right hands.
I'm not everyone do it. I don't know everyone speak.
Oh, that's what I just asked them to do. Raise your right hand. Yeah, nice and row. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Okay, start then. Thank you.
Good late afternoon. Benjamin Stark for Slater and Beckerman PC on behalf of the applicant, 215 N10 Partners LLC. We watched the hearing video of yesterday's executive session, and I think we have a mix of some lower hanging fruit and higher hanging fruit, so I think I'm going to just attack the lower hanging fruit. But first, as our statement of facts provides, this is a special permit pursuant to Section 7344 of the zoning resolution to reduce the parking requirement associated with the office element of a proposed 64,000 square feet and change a new construction building at 215 North 10th Street in Williamsburg. So the first thing that I want to address is because the revised design, this application, as you know, was submitted last fall, and in the spring, it became apparent that we would need to revise the project's design, and by about a month and a half or so ago, we submitted those plans and revised materials to the board. Because the revised design includes 10 spaces less than what the original proposal was, we agree with the board's contention that the difference is significant enough that the community board should be offered the opportunity to weigh in. Now, after we submitted our revised materials, we of course circulated the copies of those materials with the community board. We haven't heard from them, but of course we
Please reach out to them.
I'm going to reach out to them directly, and we'll take it through the process there. Next bit of low-hanging fruit, yes, writing out 103 caused a bit of a typo on page 3 of the statement of facts. We will be submitting a revised statement of facts that corrects that error. The number of parking spaces generated by the project's office component is 103 because it's 102.996, whatever, that rounds up to 103. We agree with the chair there. The next thing that...
I didn't mention this yesterday, but when I divide 30,898 by 600, which is what you're proposing, I actually get 51.49666667, normally rounded up to 52, right? So that's something I'm not sure how, if DOB goes to a second or a third decimal point, but, that's what we were all taught in elementary school. You round that right up to the...
We've had conversations about those decimals, so I'm glad that you got a kick out of that as well. So we're aware that that we're on a threshold there, and that it definitely influences the number of spaces we have to provide. And we'll work with our project expediters to make sure that 49999 rounds down.
49666.
Right. I believe the next thing that the board brought up at yesterday's executive session was the FDNY's current objection to the application, and that FDNY has not had a chance to review. We had a wonderful conversation outside the hearing room with the FDNY's rep, and so after today's hearing, we will be submitting our plans to the FDNY's technical division for their review and comment. The next comment was, that's higher hanging fruit. I'm gonna hold off on talking about medical versus standard offices. Finally, you know what? No, we're done with the low hanging fruit. So,
The flood zone is low-hanging fruit.
no, I'm going to keep that higher, and I'm going to let the project architect respond to those questions because he's here today and we have him, and he can explain the somewhat unique flood zone dynamic that's going on, and he'll also respond to the questions about why we have cellar 2 on a plan and when it looks like it's the only cellar. But the comment that the board had about standard office versus medical office, duly noted. We, of course, would like to retain the flexibility of occupying the proposed office space with both standard office tenants as well as medical office tenants, which are both in parking category B1. And for that reason, at the board's suggestion, we will be studying the parking demand associated with medical office. We did a bit of a back of the napkin in the last 24 hours, and we think that from our Early feedback is that the demand is still less than the number of parking spaces we propose to provide, but of course, we will complete that parking accumulation study and submit formally into the record. And with that, at this stage, I am going to hand it off to our project architect, who is going to provide some clarity on the flood zone condition of the site.
Madam Chair, we have the new stats on the medical office from Secret. Do you want to give that, do we want to share with them?
The most current that we have.
Well,
That's
I know it's
something
something
we do, you can do by speaking after, because
Okay.
I'm not sure that.
No, we don't want to give right now, but.
I'm not sure what the stats are anymore, we were confused last
Yeah,
time
we
we had
were-
this conversation.
Okay.
So let's.
We greatly appreciate any assistance that the staff of the board would have in having us respond to that comment, so I will reach out to our project examiner after the hearing. Thank you, and with that, I'm going to introduce Chris Glass of Morris Ashme Architects.
Hi, thank you.
State your name, please.
Chris Glass from Morris Ashme Architects. I think I'll start actually with the Cellar 2 question, because I think it's the easiest thing to clear up. It's called Cellar 2 because there is also another official cellar in the building, and that shows up in the ground floor plan, what's titled ground floor plan dash at-grade parking. What is hatched with the hexagonal hatch is actually officially below grade. It is officially a cellar.
That little area, which?
Along the frontage of,
So I can't see how it looks on what you're looking at, but the whole, what's described as office below grade, right?
What fronts on Roebling?
Fronts on Roebling and fronts, yeah, so that fronts on, correct, that fronts on Roebling.
So it's described as office below grade?
Correct. So that is officially a cellar. And if you go over to the residential lobby, what's described as residential lobby below grade, and everything that is hatched that same way, there's also gym below grade and so on, that is also officially a cellar. And just to keep the plans in the section simple, we had to put this all on one sheet, right? But in reality, there is a cellar 2 in the plans, and that is the cellar that is below what is officially a cellar, and that's these spaces I just described.
Why did you do that? I've never seen that done. That you're showing, it's a double height space that shows up on your
It
first floor plan?
it is a higher space, correct.
Right, no, I get it, but normally you would show that on the cellar level. Okay,
It's,
whatever.
yeah, it's just for clarity, because it's very hard to actually describe how the spaces work
But if
if you
it's a
don't show
double
them
height
together.
space, you're sure that more than 50% of it is below grade?
Yes, absolutely. It's because the 0 of the project is the DFE, right? So you need to be 50% below the DFE, or greater than 50% below the DFE.
so the flood zone is higher than the curb level. The flood zone is higher than the curb level.
Yeah, but only a foot, something like that, right? Flood zone is at 11, something like that? 12, 11?
Correct. I'm
And your
flipping
first floor
to a
is at 10?
section.
No?
Give me one moment.
Ground floor, I can't see where those arrows point is the problem. Ground floor is at
Ground floor
7,
below
6?
grade is 2 foot.
So, yes, ground floor below grade is at 2'7" in AVD, 88.
2'4"? Oh, wait.
And the DFE or FRCE, flood resistant construction elevation, is 9'11", rounding up 1/4 inch.
Which drawing was that?
BSA 16, the section.
Yeah, that's what I-
And, okay, wait a second. So the ground floor below grade is at 2'7".
Correct.
DFE is
9'10" 3/4".
9'10", and your floor to ceiling height?
I don't have that dimensioned here. It does add up to our ground floor below grade being greater than 50% below grade.
So there's 11 and
below
then
the
there's
DFE.
4. What is that? So I'm looking at
Or is it steps?
16. So there's 4 foot 11 inches, and then there is 11 foot 10 inches. Isn't
The 4
that
foot is the steps down, so it's a 16-foot floor-to-floor height.
Yeah, that's what
Something
it
like
is.
that,
It would
right?
be 16 foot. Am I reading that correctly? I'm looking at the same section elevation.
Yes, that dimension is dimensioning from
I don't get
what's
any more
described as ground floor, which of course the actual, where you enter the building varies by location. But in that case, 7'6", that's the residential entry, to the ground floor below grade elevation, which is 2'7".
Okay, could you do the math for us, and not now, but on a submission, and show us how you get 2'7" plus 16 divided by 2 to be higher, to be more than 50% below the 9'10" DFE? Just
Yes,
show us the.
of course.
Okay.
Flood.
Okay.
Yes, so the other item was the flood zone. And first thing to clarify is that the map shown on BSA 01 should have been the P firm from 2007 and not the firm from 2007, not the P firm from 2013. And the map shown is what the flood zone will in fact be once the P firm is accepted. And in that case, the site will be in Zone X. But as it is with firm 2007, the site is in Zone AE, which is how you get to the flood zone elevation of 9'10" 3/4".
I'm just curious, because it's so surprising to me that this is not in an AE zone. Was this one of those locations where property owners in the neighborhood contacted FEMA and said, please take us out? Do you know?
I don't know anything about the history of it. The
Right.
thing is, if you do look at the 2013 map, it is, the Zone X is extensive. It's not barely in Zone X. It's
No,
solidly
I
in
know
Zone
that,
X, yeah.
but it was so much in
Yeah.
the 2007 firm. And then you can go on those handy sites on FEMA, and there's a list of reconsiderations, and this area is in that reconsideration. So I believe that's, the way that works is developers go to FEMA and say, please don't make me.
I don't know the history of it. I know the city
Yeah.
contested it. But in any case, we are at this time in the 2007 and in Zone AE, and that is what we are complying with.
So when the waterfront revitalization program consistency review asked those questions, theirs was the same. So they're like, okay, maybe the new firms are not putting you in the zone, but the 2007 firm is putting you in the zone, therefore explain to us how you're going to deal with this in the future, because they're looking for consistency review, right?
That's right. And first off, our submission on Friday, I believe it was said at executive session that we submitted a revised EAS. All we submitted was a revised waterfront revitalization program consistency form, so only an element of the EAS. But our revised WRP consistency form describes how the project is complying with the flood zone regs, and Chris can explain how.
Yeah, let's hear. Okay. So you decide. So you're complying anyway. Yeah. Okay.
Yes, we're complying. I mean, if you go to BSA 04, the ground floor plan, all the entrances are dry flood-proofed, with the exception of loading, which is wet flood-proofed. And in the upper right corner on Roebling, there is a egress which is wet flood-proofed, and that is wet flood-proofed by going up to the level of the DFE and then back down. And that serves both the the residential and office portion. The other egress on the other location described as egress in North 10th next to the lobby is the wet flood-proofed egress for the residential portion of the building, in addition to the one at the top right. So in the event of a flood, the residential entrance, the primary residential entrance is indeed wet flood-proofed with barriers. And this secondary egress, which it will be labeled flood egress, is wet flood-proof. So it has the same up and over stair as the, or not up and over stair, but up to the FE and then back down as the one on Roebling.
You said flood-proofed with barriers, so that means temporary barriers?
Temporary barriers, correct.
That get installed by staff?
Correct.
Right, okay.
This egress plan was actually, this flood egress plan, including this particular stair, was actually reviewed and approved as part of a earlier CCD1.
Okay.
Oh, and explain how the cellars. What you're seeing as cellar 2 is one of the questions that DCP had was, are there any portions of cellar 2 that are below a wet flood-proof part of cellar 1, which we're describing as ground floor? And the answer is no. The cellar 2 is entirely located below dry flood-proof spaces.
Okay.
Thank you.
Thank you.
Okay. Looking through my notes from yesterday's executive session, before we get to the stacker system itself, one of the other questions was in regard to providing a worksheet with the arithmetic that underlies the parking accumulation study. We have that, and we will be submitting formally into the record after the hearing. And that brings us to the stacker system itself. There was a question, the board wanted to know if the stackers are fitting in a 10-foot floor-to-ceiling height. The answer is yes, but here today we have Woody Nash, who is a parking consultant working with the development team, and he can explain just a little bit about how this stacker system works, how it's unique from the stacker systems we're mostly familiar with here in the city, and how the clearances are appropriate. Thank you. Woody?
Woody Nash, Gotham Parking Systems. And I just wanted to show the board, this is a traditional two-post hydraulic stacker, which you've probably seen around the streets of New York City. It's also called a cantilever stacker because there are two legs, hence the name two-post. There's a leg on each side of each car, right? And then the platform that the car is supported on cantilevers out over the feet, if you will, that are attached to those legs. Those lifts were really designed to be a temporary solution for developers that were turning parking lots into like a land banking solution where they could pay the property taxes by renting out parking spaces, and then eventually they'd be taken down and moved when the developer wanted to build a building there. So we recognized that there was an opportunity to improve upon that. The company I represent is called American Auto Park, and they designed something called a electric clear span stacker. So rather than it being hydraulically lifted and then using manual controls like the two-post hydraulic stackers do, where the operator will stand at one corner and they'll manually release the locks, because you have locks just so that the lift won't fall with the car on it. But those locks have to be visually inspected. So if somebody's busy, it's very easy to miss those locks. And so by going to an electric system that's controlled by a PLC, an industrial computer system, we're now taking the human error element out of it, because all four locks, instead of having two locks, by the way, there are now four locks on all four corners of the elevated platform. Those are all disengaged automatically by the PLC, and the PLC confirms that they have either been locked or unlocked before the machine will operate. So it takes out a big part of human error. The reason that's a big problem is that if you do not correctly confirm that the locks are undone and you go to operate the hydraulic system, one lock is stuck, the platform can eventually tilt and warp and can obviously drop the car down. So you can see in the picture that I showed you originally, one of those platforms is actually starting to warp, right? So the car is tilting just a little bit, right? So over time, if you don't actually disengage the locks, it's a big problem. So these systems also allow us to create effectively a drive-under scenario. So in development where your valets, and by the way, these are only valet operated and they're all built in compliance with the DOB Buildings Bulletin 2015-015, which governs the design of valet operated parking lifts. You know, that area over an access path to the parking spaces was typically wasted in a building. And so what this allows us to do is to lift up over that access area and store cars there. And so the plans that you've seen here show spaces elevated in the valet area, not where pedestrians would be, not where drivers would be, but in the valet area, there are cars lifted up over that access way. And
So-
it's totally flexible, so we can adjust the heights of those platforms to accommodate different types of vehicles and different environments within the garage.
But don't you have a minimum floor-to-ceiling clearance that you need for this?
Not by code, it's actually dictated by the practicalities of the cars that you're trying to park. So sedans would require basically, you know, like every sedan is under 60 inches, right? So, and many of them are indeed less than 60 inches. So we have several garages, which I can show you that, well, first of all, that the one that I showed you with the two-post stackers was 10 feet clear. This is in the same garage where the two-post stackers were. There are the electric clear span stackers, and that's at 10 feet clearance in this garage at 106 Mott Street. And so, you know, we have the ability to put sedans, and we can provide a list if you'd like of sedans, but, you know, at the end of the day, the valets make that judgment, and then we have sensors as well, so that if you try to lift a car up that's too tall, it'll break the beam of the sensor, which tells the PLC stop moving, again, removing human error from the equation.
So we're looking at, I don't know if Auto Park is the brand, but we're looking at a brand called Auto Park that's using this system. And it looks like there's a frame, and suspended from the frame are sort of flexible, for lack of a better word, rods. And if that pulls the car up, that pulls the plate, the floor plate up to the topmost portion, and then the hood of the car is right underneath the ceiling, but it bypasses the frame of the structure.
That's right. So the frame of the structure stops at about the door handles of the elevated vehicle. But that is adjustable, so we can adjust that as necessary.
So the frame can be, the frame itself can be adjusted easily by the attendant?
No, not by the attendant. It's done in design.
No, so that's what I'm talking about. So you're going to be designing for 10-foot clearance in this garage, right?
In one specific location.
In the location where you have stackers?
Actually, no, and we're going to leave
So
that
the
next.
problem is we only have one section, the section says it's 10 foot.
Yeah, we can provide architectural materials that show the clearance throughout the entire garage. Chris, why don't you explain, once we get down the ramp, what the heights are? The majority of the garage is over 10.
But I'm just looking at the lowest common denominator where we saw parking. So, and that was my question. I was interested, I'm not saying incredulous or anything, because I think we've seen other systems that might even work at 9-foot ceilings. So I was interested in whether a 10-foot floor-to-ceiling height clear lets you fit that frame in, and then the car rise to the point where the platform is, looks like it sits kind of below the frame, and still enough room for what you say is a 60-inch clearance in that area for sedans, so maybe that area would be devoted to sedans, no SUVs.
So to answer your question, the only thing, if you were to just take two sedans and stack them on top of each other with, like in a junkyard magnet, you'd basically be looking at somewhere less than 10 feet. The only thing of the machine that's taking up any of that vertical height is the platform that the upper car is sitting on.
Right.
Which we have two versions of that platform. So one is about 1.5 inches thick. That's a low clearance platform, and then we have a 3-inch platform, which we use, and it's less money. It's just a better, for monetary reasons. But where we have tight tolerances, we'll put in the 1.5-inch platform. And that's the only part of the vertical clearance that's eaten up by the machine. Everything else is outside of the vehicle.
Okay.
That clear?
Yeah, I guess.
Yeah. And I mean, if you were willing to park Mazda Miatas, we could do it in 8 feet.
Yeah, right. So who has a Miata in New York?
Well, it's practical, right? So, when I talk about 10 feet, we're talking about Honda Accord, Toyota Camry, BMW 7 Series. I mean, real cars that are driven every day by everyday New Yorkers.
Okay.
Thank you, Woody.
Some of this questioning is for our education for future use, and I'm looking up on this spec here, which isn't really a full spec, so, benefit of the doubt. It says the total height to the top of the frame, which isn't the top of the car, is 105 inches. Does that sound right?
Yes, but everything we make is custom. So that's a sort of typical spec that we put out there, but everything we do is custom made.
Okay. Thank you.
Okay.
Yeah.
There was a comment of the board about the having that plan showing the garage indicate the number of spaces and where the spaces were. And I went back and looked at the plan. I think it was a grayscale issue. I just got to get you a new ground floor plan, so we'll do that.
Don't forget, for the architects, we look at PDFs, and often the PDFs just don't show all the layers. So just make sure when it's converted to a PDF that the layers you need us to see are visible, okay?
And I believe that is the full extent of the board's comments. So we, of course, are here and available to answer any other questions.
So the main issue is, of course, the medical study.
Right.
Because I think the others were more or less for our information. I didn't have any issues. I don't know if anybody else did with the design or the access. Sometimes we talk about sort of danger of pedestrians and things like that, but that's not the case here because you have an automated system. Fire department obviously wanted to be involved in your automated system and needs to be, right? And we've had one case where fire department it was a much bigger multi-level garage, but they had problems with the proposed automated system, which was extremely cool. They couldn't fight a fire with it. So that was not permitted, but I don't know if this one presents the same kind of issues because it's just a 10-foot change. Maybe it's a 12-foot ceiling. Okay. So then, let's schedule you to do your medical
That's right.
study.
And to talk to the CB.
Yeah.
The only thing I would want to add, since this is an attended parking, do indicate in the plan when a car does arrive, where it has to park itself. So
Where it goes to be picked up by the
where
attendant.
it goes to be picked up by the attendant, yeah.
Because it's all attended parking.
That's right. Now,
so it's almost like a reservoir space, like do you have a one or where, if I'm going to drive in, I don't want, basically what I'm trying to get at is at the end of the day, I don't want to leave my car on the sidewalk and for the attendant to pick up from the sidewalk. I should be able to drive into the parking garage and park the car.
Oh, of course.
And get the key. So if you can indicate that location.
So we'll indicate on the plans, I know on the plans we've indicated where the attendant has their booth, but we'll do a little dotted line of the drop-off and pickup area.
Yeah, so I mean, it's a really good point because the reservoir is...
We actually already sort of designated that a little bit just because I thought
You can approach the chair.
Yeah, you can approach so we can pick you up on it.
that yellow area there
Yeah.
is all designated as sort of pedestrian traffic area, where you would come in and be able to park a car. Let's say you came in by accident, you decided you didn't like the rates, you could back up and leave. So it's, well designed for the size of the garage.
So one of the things that we're often looking at with these garages is about, let's say it's the most popular garage in the neighborhood, or lots of people are coming to this building, right? What if everyone, which they do, arrives for the standard work hour, they arrive at 9 or 9:30, and then there's a lineup of cars. That's outside. That's something we don't want to see. The cars should be coming into the garage so the throughput is fast, right? And so to Commissioner Shanda's point is I don't see how the operation works where it's taking a car quickly. Yeah, sure, absolutely.
Sure.
Just real quick, so.
Come stand
Yeah,
at the mic,
sorry about
please.
that. So Woody Nash, again, Gotham Parking Systems. The way the valet teams that we work with, we don't operate garages, but we work with them every day, is they will, during rush hour, they'll say, okay, great, come on in. They'll tear a ticket, they'll give it to you, they'll take your car, and it's really easy for them to park cars into the garage because they'll just go to the first available space and put them in there until the rush subsides, at which point they'll rejigger the garage according to when they anticipate somebody to be leaving. So it's easy to fill a garage up. It's the getting the cars out part that might take a little bit of time. If somebody says, oh, I'm leaving at 5 o'clock, but they come, or sorry, I'm leaving at 7 o'clock tonight, but they come at 5 o'clock when the garage is busy, they might have to wait a little bit. But you're not so concerned about that, is my understanding, because they're waiting inside the building to get their vehicle. They're not forming traffic out onto the streets.
Exactly.
So valets are very good carrying tickets, giving someone their ticket, putting the car somewhere safe temporarily, and just keeping the flow going.
And I think that, thank you for answering that question, and just to make sure that the plan operates in the way that you're planning to, what you've indicated, if you can reflect that in the plan. So it just is very clear for the operators, for those who are driving in, as to what's the staging area and up to what point a passenger, driver can wait.
Yeah.
And for pickup and for drop-off.
Yeah, that should be
And all of that.
striped out on the floor of the garage.
And that's
to make it
also a
very
safety
clear.
measure that
Yes,
you're
for sure.
factoring in. So I think
Yeah.
those are all.
The one advantage of the ClearSpan system that I was talking about is that, you have a leg on the outside of the first and third space. So when you're in the garage, it actually looks like a normal parking garage. So the valets can park very quickly. They're not having to thread the car between the two legs of a conventional hydraulic stacker, which they have to be very careful and they have to operate slowly. So this allows them to operate
So
during
it's a 3
peak.
by 3, it's a 3 by 3 structure.
Yes.
Within which.
Three spaces wide, and then sometimes we'll put two machines, one in front of the other, so it becomes like,
Got it.
6 spaces.
Got it.
But when you look at it, it just looks like a regular garage because there's no legs there to obstruct.
Got it.
Okay, great. Thank you. So if you could write that up, basically, and show a diagram of how that would be operating, then we have an operational plan that we can rely on, okay?
Okay.
Okay, good. So what's the timing?
What is the turnaround that we're expecting?
Joe, I know we're halfway through this revision to the parking accumulation study.
Well, let's not make it too zealous. We have a hearing schedule that's tight, so
No, and we, like I said, we need to
time. Okay.
time with the community board.
Oh, right, good point.
They're gonna, that particular community board has a bit of a longer process than others. So and that'll just drive the timing. What is your availability?
In
December.
Nothing in early November or mid-November. Because I'm just thinking that.
No, mid-November is not good. So November 26th is our best offer.
November 26th with the November 6th submission.
That's a Tuesday, November 26th?
Yeah.
Sometimes you guys meet on Thursdays, but it sounds like Thanksgiving.
Why you're not available on Thursday?
Oh, I'm not available for Thanksgiving. It's my favorite holiday.
It's not on Thanksgiving, we promise.
The board would give thanks by approving our project.
2 days before Thanksgiving.
Totally fine. All right. Thank you so much.
Okay, well, thank you everyone for coming. I forgot to ask you if there were any speakers on this, but
I don't think
everyone
there
is
are.
part of the, everyone is part.
Item number 3, 2019-23BZ, 290 Mulberry Street, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board of respondents? The board of questions? Yes.
I do.
That's good. Yeah. Keep going.
So it allows for 3 spaces.
So if they do 3,
Now, it was 7 o'clock. Good.
Good evening, Madam Chair, members of the Commission, Fred Becker. We attended your review session. The 2 items that seemed to be outstanding, yes, there was great, I won't say confusion, just quasi-dyslexia on the tax lot, the block, I'm sorry, it should be 509, not 590. It's a mistake that's repeated through all the documents. We can make that correction very, very quickly, depending on the board's schedule. So that is the first item. We noticed there was some issue about the floor area and cellar, and we were a little confused over that comment. We didn't understand what the board was referring to because...
It's very simple. There isn't such a thing, which the board has ruled on several times already in the last recent time. There isn't such a thing as floor area in a cellar. It's called floor space.
Floor space.
Right? Or it's called gross square footage.
Okay.
So to clarify, because it makes it sound like you've converted something to floor area. Anyway, since you already have to correct something.
Yeah, no problem.
Yeah, you might as
So
well make
we'll
that
talk about, just we'll prefer floor space in cellar, and then just, how does the board, this is a question, in terms of saying the PC occupies a total of
X number of gross square feet.
gross
That's
square
our
feet, fine,
standard
okay,
method.
that's,
And in the zoning chart, you still show the amount of floor area that is counted as the zoning floor area.
right, I think we do, I believe. I think I always make a comment that...
And I think some go to the extent and put a little asterisk and put in the note saying the gross floor area of the PCE is X.
I'm pretty
And sometimes you can even do a chart where you call it GSF versus ZSF.
Right, on the zoning analysis, I guess we have 2,016 square feet with an asterisk, and then I PC only 193 square feet, 1903 is zoning floor area, is the way
That part's good.
Okay, so that, yeah, we do that, we always do that. Because then we base our FAR on only the zoning floor area. All good?
Yeah, so you,
Okay.
what did we have? So we do need to correct these things. Okay.
Is there a fire alarm in the PC space?
I believe there is. We have a
Fire
fire
department
department's
had
here.
no
They have a letter of no
Fire
objection.
department, no objection, 74 persons, no people.
No, but I think the other question was, how many people are actually in this space? Can't be 70.
No, it's not 70. I've been there half a dozen times. They're clearly there at 12.
So they should correct that on the drawing. It should
And
say
the statement.
75, because that triggers a PA.
Correct. Occupancy.
So they're putting 75 or not?
That's what I understand, and so I don't understand.
No,
It said 74 on
It should be 74. Understood.
Fire department said 74.
Right, but it says on the drawing.
I saw that. I'll correct that.
John Daly, Fire Department. The question regarding the fire alarm, the building currently has an approved automatic heat smoke detector with a water flow switch in it. So putting in additional equipment would be incompatible with the existing system.
Right.
And the numbers that the plan has 75, but the schedule has 74. So I used Schedule A from the all-one.
Right, so, but that's the thing, we need consistency in our drawings on.
It's done.
So it should be 74, and then to remind, the fire department said we don't want another system, remove note number 3 on BSA 2 and 3. Which must be saying we're installing something else, right?
Remove note number 3. Got it.
On BSA 2.
2 and 3. Mhm.
Okay. Okay, and if you missed anything, please listen to the
No,
video to make sure you picked up
we're good.
everything from
I'll
session.
go through the whole The application form, the statement, the plans, anything that the analyses, it'll go through, yes.
It's always easier if you do that the night before.
Everything came in, we tried to do it the night before, it came in, he got back so late and there was so much to do that it was a long review session yesterday.
So then, are there no speakers because everyone in the room is related to us in one way or the other?
I have if I may request, this will go on the morning calendar. I have hearings, I think, on October 22nd, if that's all right. I mean, I have hearings on the 3rd and the 22nd, whichever is better. I do have 2 hearings on the 3rd.
So a submission October 2nd and a continued hearing on October 22nd.
And may I request, if everything is in accord, that it can be closed and granted?
Please scour your
I
submission
will-
for errors and
yes.
consistencies so that
There
if
are,
you'd done
yes.
that before, we mostly wouldn't have had to
Yeah.
have this continue.
I understand and I appreciate it and I apologize. Thank you.
Item number 4, 2019-157 BZ 8802 Northern Boulevard, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to all member questions?
Elise Fullader from Eric Palatnik, PC, on behalf of the applicant. I'm just going to go back with you through the comments to make sure that we know all the things we're going to be doing. So firstly, we heard the comment about slatting. We will, obviously, the community board also had that comment at the land use committee meeting, so we'll get that done right away. For lighting, I can see that it's over 0. Right, and so we will put light shields, show pictures of the light shields and have it be 0 on the property line. Landscaping, I would like to confirm where you would like to have more landscaping, because I know we have some, but you said to add landscaping?
Yes.
Sorry, can I go?
Yeah.
So I think the landscaping suggestion was, there's a space, there's dirt between the building and the menu board. There are like few small hedges, and a good part of it is kind of barren.
Okay.
So if you could add to that, and I don't know if a taller shrub there would help in the buffering or noise absorption.
We can try to put in a taller.
Yeah.
And then in terms of sound, talked with the engineer/architect, and he understood what you meant by having a sectional of the sound and a plan. He actually explained it to me. And if he did say that we do meet seeker standards of noise, but I talked with the client and they said if you need it to be lowered a little bit, the soundboard, we can do that. We can do it at a certain time in the evening.
To lower the sound.
Yeah. Because you said 60 was too high.
Right, so the issue is, why does it have to project all the way that far away? At what point can it be audible to a person in a car?
Yeah.
And that's good enough. It doesn't need to be audible to the person in the next car.
And we can also have I think we've done this before, where at night or something we lower it.
That was one question I forgot to mention yesterday. It seems a prior condition did have a time restriction, right?
We didn't forget to mention.
No, you said it, yeah.
It was supposed to have been
From 7 a.m. to 9 p.m. on weekdays and 8 a.m. to 9 p.m. on Saturday and Sunday.
Okay, so you need to limit it in the same way.
Okay.
Yeah, but you're open later hours though, right, aren't you?
And that's typically because the ambiance noise during the day is higher, and it's at night that the limiters have to bring it down to compensate.
Right, but the idea of having someone ordering that square hamburger at after 9 p.m., I'm just imagining you're sitting at home, you're trying to just be quiet, and you can hear 3 sliders, please. Is that correct?
Are you asking to
Will
make
that be
sure
the
that
cheese?
the hours are the same as they were on the
Yeah,
previous?
same hours. I don't think there's any reason why you have to maintain that after 9 PM. Because after that point, you're presumably not getting so many people who need to use a drive,
This is White Castle.
unless it's your kids. Well,
No,
you
White
should
Castle, I'm
take
saying White
them
Castle's usually very
inside.
busy. From what I understand, it's busy at night. It's busier in the evening hours.
Yeah, so people go after work, I'm assuming.
Yeah.
I think people go after parties.
Yes, parties.
And all the more reason why the people who are living in the house next door shouldn't be listening to how many sliders those people are ordering.
At 2 AM.
I will discuss that with
Okay.
the client.
That's what was agreed to
I'll
before, and to the extent it's not going on now, it's not in compliance with terms of the grant.
And then for traffic patterns, they said they can restripe if it kind of it's not as clear now. We can do restriping to make it clearer about entrances and exits. That came up with both the White Castle case. If there's any specific signage you think has to be there, we can look into doing that.
And sorry, you need to speak up.
Oh, sorry.
I can't really understand.
I said, sorry. We can restripe if it's not as clear in order to show exits and entrances, because that was an issue that came up with both White Castles. And if there's any specific signage you think needs to be there, I can ask for that
How
as
about
well.
exit only?
Yeah.
On the curb cut, that's exit only.
Okay. Exit. Sorry. I took the heels off by accident, so too short.
Entrance and exit only, is that what you said?
Yeah,
Exit only.
And this one,
Okay. And that is on the 88th
It shouldn't be two-way
Street.
on 88th Street, right?
No, two-way. And there should be a sign from both direction. Well, definitely from the 88th Street entrance side, saying no entry.
No entry. No entry, 88th Street side. Lumens, hours. Okay, and then we will make sure that the drawing that was taken from the previously approved plan is dropped behind, so it's not as blurry. That's not a big deal. Word sound section. I think that was all the comments?
Yeah, I think so, yes. Okay, so.
How much time?
Oh, and all the banners or anything
Yes,
excessive will be removed.
you need to correct the signage drawings. You went through this list, right? You need to correct the signage drawings to make sure they're all showing up.
Yeah.
The lumen diagram.
Yeah.
Right?
Yeah, I feel like I missed that, that's why. I was asked to maybe get a December hearing or a late November.
This was not the White Castle in Harold and Kumar.
In where? Oh, Harold and Kumar. No, I think that was in New
Just a
Jersey.
sidebar.
I know it had to be.
I
Or
don't
was
know,
it?
I'm just asking that question.
Yeah, because they go to Princeton.
Right.
After they go to
Oh,
White
so
Castle.
they went to the White Castle.
Yeah. So, you know.
Oh, and the community board is Thursday, you said, right?
Yes. For this one, yeah, the full board is on Thursday.
We're waiting, yeah, on both of these, right?
The other one has, I believe, a land use next week, but that should, if we have a December, it'll be long done.
Okay.
Okay, so submission November 20th with a continued hearing on December 10th.
So November 20th, December 10th. Okay.
Item number 5, 2019-158 BZ, 8903 57th Avenue, Queens. Raise your right hand.
Oh.
Just raise your right hand. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond to the board member question?
I do, thank you. Elise Fullader from Eric Palatnik, PC. Very similar comments, so I guess one question is with the lumens, this one has 0 along the property line. I don't know, behind, on the next property, is it not close enough to the edge?
No, I think this is the one where the lumen skipped. It went from 0 and then it went back up again, which is quite strange. So that may just be a mistake.
Unless that residential building has.
Unless it's confused because the residential has its own light source.
So figure that out.
Yes.
Okay.
Which is very light.
There's a fence there, but.
Right. It could just be.
And a lot of trees behind.
Right, so it could be that the measurements are distorted by the residential, but it needs to be corrected. So, you know, if it says the lumens are going up there, then it should be attributed to the right light source.
Right height source. And again, I'd like to ask where, I know the landscaping is sparse in portions, but I'd like to confirm where you think it needs to be added to.
Looking to
So there's a bunch of little bushes in lots of different areas.
Say again about the little bushes?
I said there's a bunch of little bushes in a bunch of little areas.
Yes, well, that's typical of these sites, right? This one, it wasn't for me so much the landscaping looks sad. So sad just means no one's, you know, landscaping is supposed to be maintained, you trim it, you fertilize it, when you see a deadhead. you
Make it
take that
look
one out.
happier.
Make it look nice. Look like the pictures.
Again, we will take the previously approved drawings from behind out, so it won't be blurry anymore. Remove all banners from the site. That was another one. And then I was told on 57th Avenue, it is a one-way traffic, but they can restripe again, or if you need a sign there. But they said everybody comes in, it's a turn in and a turn out, and it's a one-way traffic.
From 57?
Yeah, 57th is one way, so.
57 looks like it's a two-way.
Traffic flow is both in.
Oh, you mean traffic on 57
Yes.
is one way?
Yeah, but it is an entrance and an exit.
Got
but
it.
They're going to restripe. But if you need a signage in addition to that, I can ask them, but they'll
Oh,
tell.
I see. So you don't have a choice except to do a right-hand turn, so what do you
Yeah.
need a sign that says right-hand turn for?
Right.
I don't know,
Yeah.
that's an
Fair
interesting
point.
question. Maybe they changed it, maybe it used to be.
They said it used to be two
I
ways.
don't remember.
I was
Yeah, okay.
Maybe, I don't
So,
remember that.
hopefully people aren't driving the other way. That would be crazy. What else is there? Trying to figure out what I'm missing. 7, landscaping, signage.
The same thing about the menu board.
Oh, menu
The
board.
other one.
Yeah, they're gonna do with the sectional and the above plan, and I'll ask them to lower.
And maybe provide more landscaping around it to do more buffering.
More landscaping around.
However you can accomplish that. And then with the signage, the fence signs aren't shown on the calcs and whatever else there is.
Yeah, we're gonna remove all excess signage. Oh, and then the trash was another question.
Oh, that was a big question.
They do currently have a composter, they said, at the...
Composter or compactor?
I mean, compactor, sorry.
Not working very
Compactor.
well.
But they said that must have been a really, really busy day because I said that was crazy and that looked crazy, but
So
I can...
that's one of those things
Yeah.
where you, the attorney,
Yep.
say to the client,
Yeah.
please give me a different photograph.
Yeah,
Because when you look at the photograph, you can know there is no way the board's going to be okay with that photograph.
We're too honest. It's a crazy day. So I will confirm when trash is picked up and make sure that it's picked up and...
And maybe there was maybe the compactor was broken and that's the
Yeah.
result of it, but they do own 3 dumpsters, or at least maybe they don't own them. Maybe during the broken period, their hauler said, here's 3 dumpsters. But if you have a compactor, you shouldn't need 3 dumpsters.
Yeah.
Right? 'Cause they're actually really good.
Compactor, so tell them to start using their compactor a
Yes,
lot
and
more.
get rid of those other dumpsters, which they shouldn't.
Okay.
You know, when the staff moves the trash out into that area, it should go right into the compactor, and then
Yeah.
you hit that button, and it's very exciting.
Use.
That's what it says.
But they said it is on site, I'll get a picture of that. I think that's everything.
I think there were a couple of comments, though there was the other question about the generous amount of garbage cans that
I thought she just said
No,
to...
that's the dumpster.
Oh, the dumpsters, okay.
The other was about garbage cans, but.
Right, so I think,
Okay.
I think I know why you have so many garbage cans along the property edge, but the concern was that they tend to move around. When it's windy, they fly around, roll around, so.
Make them permanent.
Make them more permanent and give them a much more appealing appearance rather than a kind of a.
Okay.
Are they part of the business district, the bid? there's like
Is there a biz there?
A bid district or something?
No, I don't think there's a bid there.
Because they make those covers for the garbage
No,
cans.
there is no bid
Like
there.
Bay Ridge Business District, if you contribute, they
There
put
isn't a
those
bid there.
covers.
You would think there is, but there isn't.
But, in terms of the trash cans, I agree, it's always a good thing to provide trash cans. The problem is that these are very kind of temporary looking, and you could get something that's really substantial, and that's part of this kind of otherwise known as street furniture, right, instead of a.
The other comment I had, and that was based on the mistake I made when I went to the site visit.
Yeah.
I entered from 57th, and I exited, not through the drive-through lane, but basically went through the parking, and then I took the Queens Boulevard exit. And when I was doing that, I felt it was not a safe movement to be doing. And then I looked at the plan, and it seems it does allow for an entry and exit. And so if I am exiting from the parking lot, that will create a little bit of an unsafe situation. So maybe you, I have to apologize, I did not see the sign mark.
But
marking.
hopefully some restriping on the road.
I think so,
In
yeah.
bright yellow.
Yeah,
will
something, yeah.
really be like, don't go there.
Because I definitely didn't see those markings.
Yeah.
As I'm looking at the Google map aerial, it does show there are, but, I didn't see it when I was driving.
And they told me they could have faded, we'll definitely re.
Okay, good. All right,
Can we
anything
have
else?
this?
That's it? Anybody else? Okay.
Can we have the same day?
December 10th?
You like the same?
Everybody likes when I give them one.
No, makes sense. The same client, basically, right? Yeah.
So, submission November 20th for a continued hearing on December 10th.
Okay, thank you very much.
Thank you very much.
Item number 6, 2019 6BZ, 138 East 39th Street, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Good evening again, Frederick A. Becker. I am the Omega, it seems. Just to give some background on this project, so I think it will explain some of the questions that were raised yesterday, and then I have something that may get rid of or eliminate many of the other issues that were raised. The Eastern Prelacy is out of Armenia, out of Lebanon actually. It is an Orthodox church similar to the Greek Orthodox Church. This facility is effectively the Vatican of this church on the eastern part of the United States. This is where His Holiness is effectively who is the head of the Armenian Prelacy stays. It's where he has his audiences. You think of it as St. Peter's Square is the request for this larger audience room, individually and in groups, as well as other events throughout the year for educational and religious purposes and religious gatherings. There is no congregation with this facility. There is a church. It's located several blocks away where services are held. This is a combination of the headquarters, a small office part that is not the basis for this request, but the meeting place for His Holiness, and also the seminary, which is located on the upper floors of the building. So I hope that clarifies the use of this building.
Only a little bit, because we needed a programmatic needs analysis, so
Well, the programmatic needs now, the upper floors are for the seminary, that is fairly, I think,
So 2 of the floors are apartments.
they are where it's the seminary, yes. The students live there, study there, hold classes there, research there.
Okay,
Yes.
so this is the part where we didn't get any materials on any of that.
I thought,
So when we get, for instance, sometimes we get, by way of comparison, a yeshiva,
right,
and we learn about how the students who are in the yeshiva go to classes, and the classroom's over here, and they study over here, and they pray over there, and they sleep upstairs.
Right.
And it's all, and the dormitory has to be associated with the yeshiva.
Right.
For whatever reason, it has to be associated, which they explain, because why don't they
Right.
just live someplace else, right? We need that. And
But
by the way, we have programmatic needs analyses for seminaries, for yeshivas, many of them, which, please don't interrupt. We have programmatic analyses for yeshivas with seminaries, many of them, and that should be your model. You need to use that and explain, and use that as a model and explain to us clearly, because from what I got from reading was a lot of administrative offices, 2 places for I don't know who to live, and no clear nexus between those places and the needs for the waiver. At the same time, it still doesn't answer what we wanted to know was, why can't you just flip the
well,
chapel?
I'll explain all of it. So I thought that in describing the proposed use and enlargement on page 5, we did describe a floor-by-floor analysis, setting forth what floors would be used, how they would be used, in conjunction with the seminary and with the rest of the space. So I'm misapprehending then that when I talk about the 3rd floor continue to be used for seminary students, contain a library, 2 study rooms, a research room, in connection with the library, a private chapel for the students, and the vicar's office.
Right, so that doesn't help us understand how it's used. Go
We
ahead.
don't have the number of seminarians. We don't have why it's important that they be able to study and live in the same site. We don't have information on His Holiness and what his function is and why it's necessary that he be located and live at this site. We don't have information about the numbers of people who usually are assembled in that multipurpose room and how often they're there and why they have to be there and not at the church. We don't have any of that
All
information.
right, I will explain, but His Holiness effectively think of him as the Pope, and this is where he holds his private audiences, which is not appropriate to be held in a church. It's where he receives his visitors and
So you would have to say how often that happens,
I
when
will
that's
explain,
expected.
and I'll explain how often they have educational and religious meetings there as well, when His Holiness is not there, because they also have the Archbishop, who is the head of the church here in New York, and the vicar, and he also has his audiences and his other functions. So I will have no problem going through that.
So I would ask you, please, to have a submission from the prelacy itself, an administrator at the prelacy, and have that person attend the hearing so we can ask those questions directly
He
of them.
was going to be here. He was on call until around 6 o'clock. So yes. So yes, he was scheduled to be here, just not at this hour. Okay, just getting to some history of the site and then something else that may alleviate a lot of questions. This was the site of the premises was the subject of a variance application in 1996. In 1996, the board did grant an enlargement on the floor which has the current meeting room, if you will, in the Archbishop's office, which was to go directly to effectively the rear yard in between 2 adjacent buildings. We did give you photographs of the rear yard. I have additional copies if you don't have them, we're attached, which show how we are surrounded on both sides by almost full yard extensions to a height of approximately, I have a person standing there, and assuming he's between 5 and 6 feet, it's around a 20-foot wall on both sides.
On 2 sides, but there's another side that's open.
That's the rear yard.
That's what I'm talking about, the rear yard.
That's looking south.
Okay, but that's the side that's open. So your papers describe the heights of the adjacencies, but we didn't get any visuals on the heights of the adjacencies.
I gave this, I'll give them out to the board.
No, not that. So, so for instance, just to make it easy, take a satellite image, Google satellite, where you're doing one of those, what's it called, the 3D view, where you tilt it, and then do a screenshot of that, and the tilting turns it into something that's 3D. When you just look at satellite, it's 2D.
Okay, but if,
When you do a 3D view and you tilt it a little bit, which is easy to do with the mouse,
okay.
then it moves it a little bit so we can get the sense of the heights of the adjoining buildings in the rear.
Did the board not see these attachments to the plan?
But I didn't see, I only see these photographs,
Right,
which
the
is not
photo-
the same thing.
But that shows you the height of the adjacent
No,
buildings.
it shows you standing in this backyard, looking around the backyard. I want to know how tall are the buildings in their backyards that you're backing up to?
Oh, well, we
Their
own
backyards,
the backyard of the building to the south.
to all the buildings. I want to know how high are the backyards of the buildings to the south, which, to the different sides, which you discuss in your papers, but you didn't give us in visuals.
Okay.
So just do what I just described. You go to Google Satellite,
Fine,
right?
I'll work that
Do
out.
a little tilt, and then
Okay.
you can
We'll-
actually see the heights of the adjoining
Fine,
buildings.
and I can also indicate we can do a measurement.
Actually,
And-
tilt won't work. 'cause it's on the bit.
Well, you do different tilts.
But
Like
I can also give you measurements of
Oh, right.
where how tall those buildings are.
Yes.
Okay.
At the proper, at their, so the issue is simply this, you're asking for waivers of the rear yard, and we want to know what the impact is on the adjoining properties.
Right.
At the moment, you're extending already into the rear yard, but your waiver is to extend more.
Okay, well, right now, we're a permitted extension into the rear yard on the existing building, because it's one level, below
Right.
23. Okay, so after discussion, after hearing yesterday, what we are proposing, and I have plans just for information purposes, not just for submission, if you want me to pass them around, or you can just take a look at if you look at drawing number P 09, you'll look at P09.
Not there yet, but we'll be.
It's the section, building section.
Okay,
What we are proposing is to eliminate what would be the third floor extension for the library.
good.
We therefore are limiting our variance request. The result of that is severalfold. One is it limits the rear yard enlargement to just the prior approval, as well as keeping it within the existing bulk of the other two buildings to the east and to the west. It also reduces the floor area to a number that is a complying floor area. The numbers come out to, it's a floor area, we are permitted floor area of 4.0, and this would be a 3.97. So therefore, there would no longer be a floor area request. There would only be the rear yard enlargement for the one floor, which would be to, again, to build what was previously approved and really addresses the main function, which is there is no other place for a large meeting room, given the size of the lot, given the elevator, given the stairwell. There is nothing else within the existing building that can be built that would give a clear floor of space of the nature we want.
But I still go back to the same question. Why not flip they're building a new building.
Because there's no way to put the elevator and stairwell, it cuts the building in half, or cuts it in 2/3. There's nowhere to flip it.
I don't.
No.
Flip the
What
floors.
Chair is saying, instead of the second floor being, having the multipurpose room, why can't the first floor have the multipurpose room and relocate all the office spaces, director's office and all of that on the second floor?
Because the first floor is, basically is Lower level, it is I can describe it, I've been to the building.
But now you're bringing the first floor level to grade, so
the offices are currently just slightly below grade. What it would do is, it would interrupt the flow of the building, and I can have the administrator explain why putting the offices in the middle of the building would be disruptive to the building, as opposed to having the full use above. It would just be disruptive to the use of the building as a whole, and again because we are going to meet the floor area requirement, and because of the conditions of the rear yards, which already are compromised by the two adjacent buildings, and because of the prior approval, we think this is a very reasonable request.
So which is the most public face of this building? Which is the most public floor of this building?
The most public, well, there's an entrance floor.
Not the entrance floor, there's the entrance.
The entrance, but when you go up what you would have is effectively, you would have the Archbishop's office on the ground floor in the entryway. There'd be no space for an entryway, a reception area, a bookstore, and then you'd have, so it would be putting in the religious uses with the Archbishop, which the ceremonial space, for lack of better
Okay,
words.
so this is the problem. We don't have somebody from the prelacy to help us understand this.
Okay.
And so
No, I understand that.
It kind of doesn't make any sense.
I-
So that's why we need.
No, I understand that. I can explain why it's, to have the office space above, you can't walk into the Archbishop's office. It's not appropriate. You
No,
can't put
no,
the-
of course
you
you're
can't-
not
You can't put the Archbishop's office on the same floor with the other offices. The Archbishop is going to go directly from his office into the ceremonial space. When His Holiness comes, he will be in one, he will go upstairs, downstairs, or he'll go from the Archbishop's office into the ceremonial space. So there is a continuation, which I will get them,
Yeah.
I'll put it in writing. I have no-
That's all we're asking, just to.
I have no problem doing, I'm not arguing against it, I'm explaining it, and I will explain it further in my papers. I will get a explanation from the prelacy itself, explaining all this. As I say, by removing the library, we reduce the scope of the variance significantly, and then put it back to what it was, and put it, again, because it's relatively uniquely spaced between these 20, I think we'll be lower, I'll find out exactly with dimensions, that we may in fact be lower than the two adjacent buildings as well.
Okay, that would be good.
And no, I'm not arguing against providing it, I just,
Right.
I will stretch it out.
Okay. And, right, so, and that'll go into your programmatic needs analysis of why it's ordered the way it is, and how, which you'll get the prelacy to help you make, oftentimes the easiest way is to get them to write it instead of you writing it.
Yeah, I'm
So,
not.
Right?
Yeah.
So, I mean, we often have that, where it's the administrator of the entity writes the whole programmatic needs analysis because they know better than anybody what their needs are, and then you just put your name on it.
I have no problem with that.
Right.
Not a,
Okay, good.
I'm not in, no argument. I let them explain it better than I can. They live with it. I can only observe.
Okay,
But this
no
is,
speakers.
You're raising two floors, the ground floor and the first floor. Is that correct?
the building will be raised, yes. I mean, the whole building is going to be raised effectively.
Well,
It's-
not the, yes.
Your cellar floor
They're
is at
gutting
this,
it. It's a
right.
The
total
cellar
gut.
floor is staying. The entire building will be elevated. Right now, you walk down approximately 2 to 3 steps, and you walk onto the floor, which has the reception area, the library, the executive director, and the back office space. What we are going to, and it's not handicapped accessible, and there's no elevator in the building. So what we will do is we will effectively raise that floor approximately 3 feet, whatever it takes, and then that'll be at grade, and then everything else will go up accordingly from there.
All the floors are, all the joists are being removed and they're sliding them up, and they're just
Right.
maintaining the front and side walls and the rear wall to the extent it needs to be rebuilt, will be rebuilt.
Right, I mean, right, exactly. We're not moving, other than the potential grant, we're not moving the rear wall.
I'm not saying we're keeping the joist, they're just
We're,
relocating.
right, we're
Yeah.
moving it up. I mean, again, it's, we're putting in they have wooden stairs now, we're putting in metal stairs, we're putting in an elevator, it's just making the building
So this is the other thing that just pointed out, so, which is confusing, right? You're showing the floors as existing, it's not true. All of your floors are being, all your joists and everything are being redone, you're just keeping the shell of the building to preserve the classic department building. It's not more than a removal of 25% of the walls.
I don't disagree. Where are you?
I'm looking at PO9, your proposed plans that shows every floor existing. It's not true.
Okay.
Take all that out.
Okay, I think it's, okay, PO9, it should be, yeah,
Proposed.
right. No, I understand.
It's a gut reno.
I think the intention there of the architect was to say that we already have an existing four-story building, and then we
Well,
were.
the architect could just create a dash line that says profile of existing.
I have no issue with that. That's how he did it, and he's the expert, and it wasn't for me to change him on
You're the
that one.
expert too, don't forget, you need to look at the drawings.
I understand, but we had lots of discussions. This was one battle I didn't fight.
Okay, submission date.
Yeah, submission date.
When do you need timeframe?
We're basically, it's
How long
basic.
is it going to take to come up with a thorough programmatic needs report?
Several weeks, I would say. I mean, I would think that, I would say a November hearing would be, if that's possible, would be appreciated.
Reach out to your project manager, who is that actually? Jella.
They may not be able to.
To give you a copy, do it soon.
Yes, I understand. Yes, that's why I said it's.
Like tonight? No, sorry.
To give you a
No, Jella will send
copy
it
of
to
a
you.
standard programmatic needs analysis for a seminary. Okay.
Okay, so submission on November 20th for a continued hearing on December 10th.
This concludes the public hearing for
Thank you.
September 17th, 2019. Thank you.
So the other